let's go back on the record. We finished with Duke's direct and supplemental testimony yesterday, and we're going to be starting with the public staff this morning. Before we get started, are there any preliminary matters that we need to address? Any motions that any of the parties would like to make? Okay, seeing none, I'll turn it over to the public staff to call your panel of witnesses.
Public staff calls the panel of Dustin Metz, Jeff Thomas, and Evan Lawrence.
Good morning. And I'll go ahead and get you sworn in. If you can place your left hand on the Bible and raise your right hand. And do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. And Ms. Laura, I'll turn it over to you.
Okay, Mr. Metz, would you please state your name, business address, and current position for the record?
My name is Dustin Metz. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm an engineer and manager in the electric section, operations and planning of the Public Staff's Energy Division.
And Mr. Metz, on May 28, 2024, did you prepare and cause to be pre-filed direct testimony in this docket consisting of 158 pages, 1 appendix, and 4 exhibits?
Yes.
Did your testimony contain confidential information?
Yes.
And on July 24, 2024, did you prepare and cause to be pre-filed an errata sheet and corrected direct testimony in this docket consisting of 157 pages, 1 appendix, and 4 exhibits?
Yes.
Other than the corrections filed on July 24, 2024, do you have any other corrections to your pre-filed direct testimony?
No.
If you were asked the same questions today, would your answers be the same?
Yes.
And did you prepare and cause to be pre-filed on July 23, 2024, a summary of your testimony in docket number E-100 sub 190A?
Yes.
Presiding Commissioner Camwright, at this time, I would move that the pre-filed direct testimony of Mr. Metz as corrected on July 24, 2024, and the pre-filed summary of testimony of Mr. Metz be entered into the record as if given orally from the stand, and that Metz exhibits 1 through 4 be marked for identification as pre-filed.
Seeing no objection, your motion is allowed, and the confidential direct testimony of Mr. Metz as corrected will be entered into the record as if given orally from the stand, and exhibits 1 through 4 will be pre-marked as marked.
Thank you. So Mr. Thomas.
In addition, I apologize, the summary of his testimony will also be entered into the record as if given orally from the stand.
Thank you. Mr. Thomas, would you please state your name, business address, and current position for the record?
Yes, good morning. My name is Jeff Thomas. I work at 430 North Salisbury in Raleigh, North Carolina, and I'm an engineer with the operations and planning section of the Energy Division of the Public Staff.
On May 28, 2024, did you prepare and cause to be pre-filed direct testimony in this docket consisting of 124 pages, 1 appendix, and 1 exhibit?
Yes.
Did your testimony contain confidential information?
Yes.
And on July 24, 2024, did you prepare and cause to be pre-filed an errata sheet and corrected direct testimony in this docket consisting of 124 pages, 1 appendix, and 1 exhibit?
Yes.
Other than the corrections filed on July 24, 2024, do you have any other corrections to your pre-filed direct testimony?
No.
If you were asked the same questions today, would your answers be the same?
Yes.
And did you prepare and cause to be pre-filed on July 23, 2024, a summary of your testimony in docket number E-100 sub 190A?
Yes.
Okay, presiding Commissioner Camwright. At this time, I would move that the pre-filed direct testimony of Mr. Thomas as corrected on July 24, 2024, and the pre-filed summary of testimony of Mr. Thomas be entered into the record as if given orally from the stand, and that Thomas Exhibit 1 be marked for identification as pre-filed.
Seeing no objection, your motion is allowed. Mr. Thomas's direct testimony that contains confidential information along with a summary of his testimony will be entered into the record as if given orally from the stand, and Exhibit 1 that is attached to his testimony will be pre-marked as marked.
Thank you. Okay, Mr. Lawrence, would you please state your name, business address, and current position for the record?
My name is Evan Lawrence. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm an engineer with the Public Staff's Energy Division.
And on May 28, 2024, did you prepare and cause to be pre-filed direct testimony in this docket consisting of 47 pages, 1 appendix, and 1 exhibit?
Yes,
Did your testimony and exhibit contain confidential information?
yes, it did.
And on July 24, 2024, did you prepare and cause to be pre-filed an errata sheet and corrected direct testimony in this docket consisting of 47 pages, 1 appendix, and 1 exhibit?
Yes,
Other than the corrections filed on July 24, 2024, do you have any other corrections to your pre-filed direct testimony?
no,
If you were asked the same questions today, would your answers be the same?
yes,
And did you prepare and cause to be pre-filed on July 23, 2024, a summary of your testimony in docket number E-100 sub 190A?
yes,
Presiding Commissioner Camwright, at this time, I move that the pre-filed direct testimony of Mr. Lawrence, as corrected on July 24, 2024, and the pre-filed summary of testimony of Mr. Lawrence be entered into the record as if given orally from the stand, and that Lawrence Exhibit 1 be marked for identification as pre-filed.
And Ms. Lord, you also were requesting the summary of his testimony be entered into the record. Is that correct?
Yes.
Okay. Seeing no objection, your motion is allowed, and Mr. Lawrence says direct testimony as corrected, along with the summary of his testimony, will be entered into the record as if given orally from the stand. The Exhibit 1 that is attached to his testimony shall be pre-marked as marked.
Thank you. Last one. So Mr. Metz and Mr. Thomas, on July 18, 2024, did you prepare and cause to be pre-filed joint settlement testimony in this docket consisting of 8 pages?
Yes.
Yes.
And do you have any corrections to your pre-filed joint settlement testimony?
No.
No.
If you were asked the same questions today, would your answers be the same?
No. We would add that on July 22nd, 2024, the stipulating parties filed an amended stipulation that supersedes the initial stipulation. The amended stipulation includes modifications resulting from engagement between the initial stipulating parties and CCBA. The changes made between the initial stipulation and the amended stipulation are shown in the July 22nd, 2024 filing.
Thank you. And did you prepare and cause to be pre-filed on July 25, 2024, a summary of your joint settlement testimony in docket number E-100 sub 190A?
Yes.
Okay, Presiding Commissioner Camwright, I would move that the pre-filed joint settlement testimony of Mr. Metz and Mr. Thomas and the pre-filed summary of joint testimony of Mr. Metz and Mr. Thomas be entered into the record as if given orally from the stand.
Seeing no objection, the joint settlement testimony of witnesses Metz and Thomas, as corrected by testimony on the stand, along with the summary of their testimony, shall be entered into the record as if given orally from the stand.
Thank you. And the panel is now available for cross-examination.
So in regard to the order of parties who are going to be providing cross-examination, I believe that the Attorney General's office is first.
Yes, thank you. Good morning. Terrell Moore with the Attorney General's office. The public staff conducted modeling in this proceeding, correct?
Yes, we did.
And as part of that modeling effort, you came up with resource availability assumptions.
The resource availability assumptions were an input to the model. Yes.
And those resource availability assumptions were based on the public staff's experience, expertise, research, correct?
Yes, generally, I think we looked at what Duke had proposed for their interconnection limits, and we kind of looked at both their P2 resource limits and their P3 resource limits and arrived at a slightly modified interconnection limit that we believe represented aggressive but achievable limits on interconnection of new resources.
And you conducted extensive discovery in this docket, correct?
Yes.
And the public staff would not suggest any resource availability assumptions that you consider unreasonable, would you?
No, I think the purpose of our modeling in this proceeding was to try to understand, given resource interconnection limits that were aggressive but achievable, what interim compliance date could we achieve? I think that's maybe in contrast to Duke, where their P1 and P2 set an interim compliance date and then determined what level of resources we would need to achieve that interim compliance date, which we believe resulted in portfolios, particularly like in P1, that had unreasonable levels of interconnection. So we tried to keep our resource interconnection limits to be reasonable but achievable.
So again, all of them that you suggested, you found to be reasonable.
If I can add. So I just want to make, if we're talking about the core portfolio assumptions used in PS1F 2034, that'd be a correct statement. However, when we explored the sensitivities, we did look exploratory analysis that would be informative, but some of those dates may not have been achievable. It was more of a what if analysis.
So one of those assumptions used in your base portfolio was the inclusion of 1,800 megawatts of onshore wind by 2033, correct?
Yes, subject to check. I believe that was the amounts that we put in.
And Mr. Lawrence, I think you came up with that and it was based on your review of the company's siting study, correct?
In part, yes.
And I believe the lowest amount of onshore wind selected under any of the public staff's modeling runs was 1,350 megawatts by 2033. Is that right? I think that's on page 15 of Mr. Lawrence's testimony, if you want to reference that.
Yes, that's correct. 1,350 megawatts.
The amended stipulation calls for 1,200 megawatts by 2033, correct?
I believe that is correct.
Although I would just add, there is a provision in the amended stipulation that for Duke to seek, and during its development activities, an additional 600 megawatts to bring it more in alignment with the figures we have put in there.
And House Bill 951 requires the commission to take all reasonable steps to achieve the authorized carbon reduction goals, correct?
Yes.
The public staff's proposed portfolio targeted achievement of the interim target by or in 2034. Is that correct?
That was our base portfolio assumption, was 2034.
And if you compare the near-term action plans proposed by Witness Metz with the amended stipulation, is it fair to say that the key differences are more combined cycles and less onshore wind than the ones proposed by Witness Metz?
1 minute.
It's on page 8 of your testimony.
So I believe in Exhibit 1, I provided more details on the public staff's near-term action plan. As Mr. Thomas had pointed to a little bit earlier on the onshore wind, the overall settlement was to evaluate and see if we can bring in that incremental difference for onshore wind at approximately 600 megawatts.
I guess my key point is that there were no other adjustments besides combined cycles and onshore wind. Those were the two numbers that were changed from your proposed near-term action plan.
So the near-term action plan for the combined cycles and combustion turbines in my initial testimony lists the minimum amounts because there was still uncertainty on the impacts of the Clean Air Act because we only ran one sensitivity.
That's fair. So there may be more combined cycles that are needed in the future.
That is correct.
And the public staffs, you targeted achievement in 2034, correct? So is it fair to say that the amended stipulation would result in the interim target being reached after 2034 or in 2034, but no earlier?
That'll be a fair characterization. I'd only add a qualifier that the impacts of the Clean Air Act or EPA 111 are fully not known at this time, and whether or not 2034 can be accomplished. Yes.
Another assumption that was used in the public staff's modeling was the power pair program. Is that right?
Yes.
And I believe that targeted 30 megawatts from a residential program and then 10 megawatts of a commercial industrial program.
Yeah, so we essentially modeled the power pair program, initially just the pilot program, so trying to reflect the residential installs that would occur over the 3-year period of the pilot program. But beyond that period, 3 years out, we had modeled additional capacity being added through this program, both representing a continuation of the residential program as well as an expansion of the program or something similar to commercial and industrial customers.
And I guess I want to follow up on that. You said a continuation of the pilot program, but not an expansion, just keeping the 30 megawatts the same.
The 30 megawatts was a 3-year target, but we assume that there's not an infinite demand for these types of installations. And so there's a kind of a natural amount of the market size that's going to continue to kind of come. We're not going to see 100 megawatts of residential customers adding this every year. So we tried to make a conservative assumption about how much of this program would continue into the future.
And the model economically selected all 40 of the available megawatts.
Subject to check, I believe the model generally selected the most amount that it could, because we modeled this program with the only cost of the utility being the incentive prices based on the approved power pair program. And so even though the solar that's being procured has a much lower capacity factor reflective of the differences between rooftop and utility scale solar, the model still is always going to want to select a cheaper resource. And so because the only cost paid by Duke and its ratepayers would be the incentive cost, this was a relatively low cost resource.
Given the public staff's model economically selected all of the available capacity under the power pair program, do you think it might be beneficial to explore a larger residential power pair program in the future?
Just one moment. Yes, and I would just point to paragraph 43 of the stipulation. And so obviously we modeled this program in Compass and the model selected it. That is a good sign that says that, hey, this resource can be used. It's helpful to the system. It's part of the least cost path. However, I want to just emphasize that modeling a potential customer program within Encompass is not the same and not going to give you the same information and detailed feedback as evaluating a pilot program. And so we'd like to see it expanded, but we need to make sure that the actual results of on-the-ground results from the pilot program are reasonably in line with expectations, right? We may find that there's some fatal flaw of the program that doesn't get exposed until we're able to establish and review these customer applications. I believe last I checked, there were about 1,300 applications to the Power Pair pilot program. And so we do want to understand what that is and what that looks like and what kind of benefits that the system gets from those installations. And I think that's what the paragraph 43 reflects, is that we want to still evaluate these programs. And but the model selecting this as part of the least cost plan is a promising first step.
My last question is regarding some language in the amended stipulation on page 5, paragraph 14. And it reads, the stipulating parties agree that the company should check and adjust the most reasonable, least cost, longer-term pathway to achieve the interim target. And I was just curious what the term longer-term pathway means in the context of that sentence, if that longer term has any importance.
So I believe from my understanding of this language right here, the longer term was to be longer than the 2030 compliance.
Okay, thank you. No further questions.
Thank you. And I think that Mr. Smith, Avangrid is up next.
Thank you. Good morning. My name is Ben Smith, and I'm going to be asking you some questions right now on behalf of Avangrid Renewables. I'll be back with Environmental Defense Fund in a little bit. I want to start first with direct testimonies, Mr. Metz, and I think Mr. Moore covered some of this, but I want to make sure I have it locked down. Mr. Metz, can you turn to page 8 of your direct testimony?
Page 8, I'm there.
Okay, and there's a table which sort of summarizes the public staff's proposed near-term action plan. Do you see that?
Yes,
And can you confirm that that near-term action plan included recommending the commission include 2,200 megawatts of offshore wind with a proposed in-service date of 2034 to 2035?
that is correct. And I would refer back to Exhibit 1 with the additional qualifiers that I included for offshore wind.
Thank you. And ultimately, this recommendation was modified in any event by the amended stipulation and then the amended stipulation, correct?
Correct.
All right, moving to the stipulation. And I'm going to be, I might say stipulation, I mean the amended stipulation. That's the copy I'm working off of. In the amended stipulation, public staff and the stipulating parties, I should say, seek commission approval for procurement of offshore wind for up to between 800 and 1,100 megawatts to be spinning by 2034 and 2,200 to 2,400 to be spinning by 2035. Is that right?
That is correct, and that is near alignment to the proposal to the public staff's near-term action plan.
Well, I did want to ask something, and I think that this is just a sort of language issue. That is, this would be cumulative 2,400. This wouldn't be 2,400 by 2035 in addition to the 800 to 1,100 the year before.
That is a cumulative number. That is correct.
Okay, good. All right, I'm going to get deeper in terms of the amended settlement on offshore wind, but I want to talk about it in the context of the nuclear terms that were agreed upon versus offshore wind. So can you turn to page 13 of the amended settlement? It's the section on initial development of advanced nuclear.
I'm there.
All right, in paragraph 25, the stipulating parties recommend to continue to develop preliminary advanced nuclear. Isn't that right?
Stipulating parties agree that the company should continue the near-term development activities outlined in Table 412 to the CPIRP execution plan to support the future availability of small modular and advanced nuclear reactors.
Thank you. And as part of this continued activities, paraphrasing what you just said, the companies are expected to, beginning in the 2025-2026 carbon plan IRP proceeding, file annual reports on their advanced nuclear development. Is that right?
That is correct.
And the stipulating parties recommend the commission select advanced nuclear as a resource in this carbon plan. Isn't that right?
That is correct. That's in paragraph 26.
Yes, I think so. And the stipulating parties agree that the company should make reasonable efforts to bring the first 300 megawatts of advanced nuclear by 2034, with an additional 300 megawatts totaling 600 megawatts by 2035, and then an aggregate total of 1,200 megawatts by 2036. Is that right?
Subject to the regulatory approvals and development milestones outlined in the company's control, correct?
Sure, but those regulatory approvals would, in theory, apply to any new generation resource, right? With it stipulating that there are different regulatory approvals for different types of generation.
That is correct.
All right, were you all present for Duke's long lead panel, direct panel?
Yes.
And did you hear Mr. Holman testify that a 300 megawatt SMR unit would cost more than $1 billion?
I remember the conversation, yes.
Based on your knowledge, do you concur that a 300 megawatt SMR unit would cost more than $1 billion?
Yes.
And does the public staff have a number that they use when they're modeling the costs of what a 300 megawatt SMR unit would cost?
So it's my understanding that we utilized the company's updated numbers that was pulled from the Idaho National Lab report.
Okay, so the number you use is the same numbers that Duke uses from the Idaho National Lab report?
Correct. And benchmarking that, we also compared it to Dominion's public number and their IRP. for small modular reactors, and it was relatively close.
Do you recall what that number was offhand?
It was a nominal $13,000 per kW, subject to check.
Thank you.
The Dominion.
So in any event, the public staff and Duke agree that 600 megawatts of new SMR capacity would presumptively cost more than $2 billion.
Yes, that is correct. But it has a high energy output of near 95% annual capacity factor.
Sure.
95% annual capacity factor.
And I'll be getting back to capacity factor in a later line of questioning. But and did you hear during that same long lead cross that Mr. McIntyre talk about the CVAL cost estimates at 9.8 billion for the 2.6 gigawatt CVAL project?
I remember that conversation. He had a whole bunch of other qualifiers associated with that number as well.
So strictly on a per watt cost analysis, is it fair to say that the estimates for offshore wind and advanced nuclear could be considered cost competitive?
Well, if you're benchmarking the CVAL data, which was generally around 2018, I would say those values are very stale and out of date, and not reflective of where we are today. But let's just say the numbers are equal, then yeah, the dollar per kW is a simple derivation. However, you have to look at the energy value output, which nuclear would be about double of that compared to offshore wind, if not greater than.
Thank you. Let's go ahead and turn to the offshore wind section, the amended stipulation, beginning on page 14.
Okay.
On paragraph 27, the stipulating parties agree that the companies should issue a ARFI in early 2025. Do you see that?
Yes, I do.
The public staff had previously moved for the commission to open a new docket to expeditiously move towards an offshore wind procurement process. Isn't that right?
Yep, that's correct.
And that that the process that the public staff requested in that motion, which was ultimately denied by the commission, would occur in parallel with the current docket. Is that right? I can ask that again if I was a little bit.
Yeah, if you can ask that again, please.
The proposal in the public staff's motion included the parallel a docket that would operate in parallel with the current CPIRP docket. Isn't that right?
Yes, that motion, which was filed, I believe, in sub E-100 sub 179, essentially asked the commission to direct Duke to move forward with the RFE in a separate docket. And so the stipulation here also establishes a separate docket for RFE updates and for potentially moving forward this process outside of the CPIRP 2-year update cycle.
But not in parallel, right?
Presiding Commissioner Camright, I would just ask that if we're going to have more specific questions about that specific motion, if council has a copy so they can refer to it, that would be helpful.
I don't have a copy, so that's all right. We can move on. All right, moving to paragraph 28 of the amended stipulation.
Okay.
This includes some language that says the ARFI should request binding information to the greatest extent possible. Do you see that language?
Yes.
Can you explain how, in your view, how that would work?
Yes.
So we understand that there are a number of parties here who have interest in offshore wind, and the developers in this case, we understand that they have acquired these leases, they would like to develop these leases, and they have large costs that must be spent to develop those lease areas. And through that process, they need certainty here. to some extent. And so with this, we are attempting to provide some level of certainty and some that this is needed, then this is going to be considered in future dockets. And for that, we need to have as good of information in those dockets and in these proceedings as we can have. So that binding information, to the greatest extent possible, will inform that. And it has to the greatest extent possible there, because we also understand that the developers can't provide fully binding bids, and that's not really what we're seeking here.
If I can just add a little bit, Mr. Lawrence is correct. We understand the conflict between some sort of binding estimate from the wind developers that is not also binding on Duke, makes it difficult to get, extraordinarily accurate quotes. But we believe that this stipulation, particularly section 30 of this paragraph 30 of the stipulation, lays out a process that if the prices that are submitted through the RFI, the ARFI are
You can go on.
reasonably close to the model for this maximum selected price that's discussed in paragraph 30. We believe this provides a pathway for Duke to submit within this docket. Here is a plan to move forward with this resource. It is confirmed to be cost effective. It is part of the least cost plan. It represents a reasonable step, and that action can be taken on that within this RFI docket. And so we believe it provides a pathway to potential commercial viability that is sufficient to at least get the developers to review this RFI and take it seriously and submit as accurate as a bid as they can, because this is the kind of the threshold step, right? We have this resource that's sometimes selected, sometimes not. There's a lot of uncertainty to resolve around it. But if the costs are competitive and it's being selected as part of the least cost plan, it would represent a reasonable step, and Duke should move forward with kind of development efforts as laid out in the stipulation.
And if I can expand, goes further into item 32 and 33, to the extent that we have that information, we hope it's good information that's coming from developers, that it will be fed into as an input into the next CPIRP. And that's why it's important to meet these dates. And when the company files their next CPIRP, we'll be able to see if that resource is selected with those cost inputs, also noting the changes that can occur between now and the next CPIRP filing to reinforce the need for the project.
Thank you. You guys just opened up a whole bunch more questions for me. Mr. Lawrence, you mentioned that I believe that the developers cannot present a binding, I'm not sure, I'm paraphrasing, a binding bid. Did I hear you right?
It would be difficult for them, we believe, to submit a fully binding bid within these constructs with the information that everyone has at this point.
Within the constructs of what's been included in this ARFI process?
Correct, yes.
Have any developers taken the position that they could not provide a binding bid outside of these constructs?
We have, through our discussions, we have been told that it would be difficult to obtain firm pricing on many of the things necessary without a direct course of action through this docket, or without specifically calling for offshore wind.
And another challenge point is, my also understanding is how the contracts are to be situated. Will it be a build own transfer? Will it be a development activity? The terms and conditions on a multi-billion-dollar project will be very complex, and that would require more extensive conversations as well.
Maybe just to put a finer point on both of these gentlemen's testimony, as part of our investigation into the CPIRP, we sat down with both Total and Avangrid multiple times to have meetings on, Kitty Hawk and what offshore wind's role is and how do we protect ratepayers. So we really tried to get their perspective and implement that perspective to the extent that we thought it was appropriate in both witness Lawrence's testimony and the amended stipulation.
Any more? Oh, okay. And I was part of those Avangrid calls, and so I guess I'll ask again. Do you recall Avangrid ever mentioning that they wouldn't be willing to present a proposal with binding constructs on it to either the utility or the public staff or the Utilities Commission?
I just want to understand your question, if I may. Point of clarification in that we may be going into potential confidential information. I don't know. So if I just want to clarify any question that you have so they don't divulge anything confidential that you or your client.
Mr. Smith, can you restate your question and then let's determine whether any response would involve confidential information?
Sure. Do you, in your discussions with Avangrid, do you recall at any point that Avangrid said that they could not give a binding proposal to sell their offshore wind energy area?
And if this involves confidential information, will you let the commission know before you answer?
So just to make sure I'm understanding the question correctly, you're speaking to the sale of the lease area,
Yes.
not the development of the project by Avangrid to.
Yes, the sale of the lease area I mean, subject to check, Avangrid took the position in sub 179 that they're open to any sort of construct for sale. And so I'm asking is any sort of construct which would meet the requirements of HB 951's ownership portion where Duke would acquire it. Do you recall Avangrid ever saying that they would not they would oppose a binding bid process?
No, I don't believe they did. And if memory serves correctly, they were open to it in the correct manner. It had to be again, I think there, and sorry, I'm trying to remember between my discussions with Avangrid, my discussions with Total Energy, and discussions we had with Synergy. So, I'm trying to work through that in my head, and I don't recall Avangrid saying that.
And if I could just add, I think there's a difference between, I think the public staff is not necessarily, and I think the RFE is not just trying to get what is the price for the WEA, right, for the wind energy area. Because there's a lot more involved here than just buying a plot of open ocean, right? So I think the context of that I'm providing this, developers have stated they could not provide necessarily binding bids is we were looking for a developed cost. And I believe kind of in general, the concept was the developer may not go out and get very detailed quotes on the cost to rent the wind turbine installation vehicle and the cost to procure the blades and the nacelles and to install it. They may not go out and do all that effort to get a very detailed quote to construct and develop if they did not have kind of some assurance on the end that this effort would not be wasted. But certainly, I'm sure that both Avangrid and Total would be happy to enter into negotiations to transfer the wind energy area. But I think it's the all-in cost that this RFE is trying to get at. And that's where I think there's some squishiness in terms of how firm and how binding the bids would be. But ultimately, we just want the most accurate bids that we can get, given the significant uncertainty, so we can make sure that this is indeed a reasonable step in meeting our obligations.
Thank you. And in the Duke's long lead direct panel, Mr. McIntyre repeatedly referred to the fact that Duke does not yet own a wind energy area and so cannot take developmental steps towards it. Do you recall that?
Yes.
So pushing aside development costs, operation costs, construction, restate this. Setting aside plans for construction, development, operations, just talking about the asset acquisition to meet the requirements of HB 951. Wouldn't it move everything a little bit faster if Duke had certainty as to ownership of wind energy area?
So If I may, I'm a little confused on your open terminology of the requirements of HB 951. Can you be more specific on exactly what you mean by requirements? Are you saying, the 951 require us Duke to buy offshore wind? That's not a requirement, so I'm just a little
No,
confused on the question.
There was define in the law, other than a carve out for utility scale solar, the utility is required to own what's selected in a commission approved carbon plan. Do you understand that part of the law?
Yes.
And that's what I'm referring to here.
Okay. Thank you. Can you restate the question then, please?
So my question is, given Mr. McIntyre's position that Duke does not yet own a wind energy area and therefore cannot move forward with development efforts wholesale, wouldn't it move things more quickly for offshore wind development if we move forward with the asset acquisition portion of it?
But I think a challenge is which asset do we acquire? And we did the 2022 wind study, which Mr. Lawrence can talk more in detail on. You have to evaluate each one of those projects to see what is the most cost effective or cost beneficial for ratepayers. So right now we have 3 commercial non-regulated entities holding the WBAs, and I can't say for certainty today on which one of those that should be acquired through an asset acquisition. Mr. Lawrence.
And in the last, the carbon plan proceeding and the, I believe E-100 sub 179, the order from that, the Duke Energy requested acquisition of a lease area, and the commission required them prior to that. It denied the motion to acquire the lease and said that before acquiring a lease and upon request to do so, there were certain actions that needed to be taken and certain studies to ensure that Duke was acquiring the correct lease for ratepayers and for compliance here. And so to your question of whether it would be faster for Duke to acquire a lease now, I can't say that it would be. There are development activities that would be required, the same for Duke as they are for Total, they are for Avangrid, they are for Synergy or any other lease area holder. And the process is set by BOEM. So I don't know that, if Duke had a lease, if they had gotten that lease in the last carbon plan proceeding, if we'd be any farther along now than what we are, or if they were to, would have asked for permission to acquire that lease in this one, that we'd be any farther along in the next proceeding. I don't have the information to say that for certain.
So is the public staff's position that the 3 offshore wind developers will continue developing the offshore wind energy areas while they wait for some sort of transaction between Duke Energy and one of the 3 of them?
If I can identify that we continue to see that offshore wind is the most ductile resources selected. So for example, if load doesn't manifest, it had impact to offshore wind. If other generation resources aren't built, it had impacts to offshore wind. When I say impact, it is sometimes it moves forward, but in most cases we've seen it moving backwards, shifting out in time, and even decreasing in overall procurement. So this public staff position is that in order to make the determination that we need more cost information, we can move in a parallel track as outlined within the settlement agreement or stipulation agreement.
Thank you. I have more on that, but given the time, I'm going to move on. I have one more question about the binding information. I think I understand the concept, but I want to make sure to give you one more opportunity to explain a little bit more. What if Duke is ultimately going to be the owner of this offshore wind development, then how can the developer give binding information for things such as transmission costs and other things like that in the ARFI process?
So I believe that the transmission costs, there was in the last RFI process that was a result of the the last carbon plan proceeding, which we have used to inform this carbon plan proceeding. There were a number of things such as the interconnection point that were common to all three developers and for wind energy areas at that time. Now it'd be the three wind energy areas. And that was to, levelize the playing field because, to your point, there are studies that have to be done, and there are, other requirements that the developers, the three developers, aren't going to have the information on, but it's largely going to be the same activities between the three of them. So, in a way, it doesn't matter whether it's Total or whether it's at Carolina Long Bay, whether it's Avangrid at Kitty Hawk, if they're both connecting at the same point. And at that point, it's largely the size of the facilities that would matter. It's not the area or the location of the lease or the leaseholder.
And if I could just maybe add a little bit to that, I think the way that you're framing this question makes me think that your expectation is that Duke is going to simply buy a WEA and develop it themselves, and that's the path to completion here. But I just wanted to note that as part of the RFE, as part of this paragraph 30, we want, if these prices are favorable, for Duke to propose a plan and a list of a timeline of executable actions to procure this resource. And we don't know necessarily what that looks like. It might be that Duke buys the WEA and develops it themselves. It might be that Duke enters some sort of joint development contract with one of these developers to put up matching funds. It might be a build own transfer where the other company builds it and executes it. A lot's going to depend on, the risks to Duke, the risks to ratepayers, the risks to the supplier or the developer. And we have to balance those, and the public staff's going to have to take a major role in this to make sure the ratepayers are protected and that we can procure this resource at a reasonable price, a reasonable cost, or not at all. And I think the ownership question is, settled, and we saw that in the 2022 carbon plan. But there was a footnote in the 2022 carbon plan order that pointed out that the commission at this time was not defining what utility ownership looked like in terms of, does it have to be 100% owned and developed by Duke? And so I think, to the extent that the carbon plan order addressed that, that's something also we would look into, right? How much of it does Duke need to own? Is it all going to be owned by DEP, or can DEC own some of it, right? So I think that's a question that's not resolved yet. And I think that's something that's part of this, a plan to begin these development efforts and a timeline of executable actions. This is a good resource. Let's go get it, but let's work out those details as well in a way that protects ratepayers.
And Mr. Thomas, two quick follow-ups on that response. You mentioned that the way that I was framing these questions makes it seem like the developers want a pure asset acquisition. Did I say that correctly?
That was kind of my impression.
Okay. Has Avangrid Renewables taken the position in any filings they made, either here or in the sub 179 that you're aware of, that that's what they want?
I don't believe so. I don't recall the 2020 carbon plan. I remember there were some negotiations going on at that time that were not fruitful, that we had to have a confidential session on, but I don't recall exactly the efforts there. But
thank you. And well, I'll move forward. All right. So to get going, since I'm probably getting to the end of my time, the independent evaluator, the way I read the amended stipulation, Duke and the public staff establish the reference point price, and Duke has the sole discretion whether to move forward with the procurement. So what role does the independent evaluator play?
The independent evaluator would be similar to the wind study that was recently completed. So the independent evaluator should be able to leverage his or her expertise to determine if the values will have multiple roles in one. I mean, a lot more of the roles still need to be developed and worked out in more detail. But the independent evaluator will be able to say, is the cost information being provided by developers make sense? For example, pure hypothetical, is one developer saying we want to use 18 megawatt turbines that may not be actually commercially developed right now, and all other developers are proposing 15 megawatts. We would rely on an independent evaluator to look at those assumptions. Other assumptions would be HVDC, the type of cabling manufacturer. Is one developer using a hypothetical cable that hasn't been manufactured yet? Are they banking on future planning or cost curves assumptions? So we would rely on independent evaluator and their knowledge in the overall industry to gain insight. Or Mr. Thomas or Lawrence have anything to add?
Thank you. And moving on to the asset acquisition reference price, the way that it's written in the amended stipulation, it's to be developed by the companies without input from the offshore wind developers. Is that right?
Can you point to me exactly which section you're reading?
Paragraph 30. Second sentence, the asset acquisition reference price shall be developed by the companies in consultation with the public staff and IE will not be shared with the market. Sorry. The asset acquisition price shall be developed by the companies in consultation with the public staff and IE and will not be shared with market participants.
Yes.
Can you explain the logic of having a blind reference price to the market participants?
So the fear would be if I tell developers what our maximum price that we'd be comfortable with, they would just bid at that price. We wouldn't be able to leverage lower costs.
Right. This is somewhat of a competitive bidding process, and we have a ceiling here. And right, if developers know what I would consider competitive information, then it's going to influence the results of the bid, and you know it's going to potentially result in higher costs to ratepayers than what would otherwise be realized if they don't know the ceiling. And yeah.
And Mr. Smith, before you ask another question, I want to make sure that the questions and the testimony is recorded correctly in the transcript. So I would ask all of the attorneys and the witnesses to speak very carefully and slowly and directly into the microphone to make sure that the record is clear. Thank you.
Will do. Few more questions on this. Wouldn't the economic selection of offshore wind provide a ceiling by the modeling process?
The selection of offshore wind, you mean in the capacity expansion planning?
Well, the way I read this, the ARFI will be informed by the company's modeling on offshore wind. So I'm assuming that part of this will be a capacity expansion modeling exercise, and that will be sort of a determinative factor for whether offshore wind is selected in the future, and it's sort of built into this process too. So I guess I'm asking, why is there a blind reference price needed when we already have a ceiling effectively?
Well, I mean, if you look at the sensitivities for offshore, if the sensitivities that both we have run and that Duke has run, you know, offshore wind is not always selected, right? If it was selected in every single portfolio without fail, same time period, and the model was consistently calling for this resource in the quantities that we put forth, then I think we'd be having a very different conversation about what we want to see, you know, vis-a-vis the RFI. But I think the problem that we saw, particularly in our modeling, was that there were quite a few decisions or assumptions or sensitivities that we made that significantly reduced or pushed out offshore wind, kind of, you know, this almost this marginal resource, right? I mean, we ran a revised load sensitivity, you know, for example, that'll be discussed by public staff witnesses Hinton and Fay, and that model run dropped a lot of offshore wind and pushed it out, right? So there's a lot of uncertainty about what is happening and whether it's being selected. And so I think the reference price, the asset acquisition reference price, essentially the way I envision it would be take the same capacity expansion model that's selecting offshore wind, and you just continue to raise that CapEx price until it's no longer selected. And there you go. There's the maximum price. And then when you get the RFI results, you compare them to that maximum price. And if you're over that, you can pretty confidently say that the model would probably not select this. It's not economically selected. It's not a part of least cost plan. But if developers can get in under that, because again, there's a disconnect between the prices that developers will bid in and the prices that are input into the model, right? They're not one-to-one. They're not the same information. They're reasonable approximations, but there's a lot of differences here. And then there's also other complexities like contract structures that aren't reflected in the model. So that's the purpose of this, is what is that price at which the model is still saying offshore wind's part of the least cost plan. If we can get offshore wind for less than that, let's do it, because that's a reasonable step and part of the least cost plan. But we need that threshold here because offshore wind is such a fickle resource in terms of its selection in all of our sensitivities and in a lot of Duke's modeling as well.
And just to highlight, I mean, if the commission was to look at METS Exhibit 2 and look over on the far right-hand corner, you can see offshore wind. You can see in some resources, only 1,100 megawatts is selected, and it slides all the way out to 2038. So this resource appears to be the most ductile or moves around the most, and that gives us some concern on saying what we absolutely need to do today, given the complexities of the contract structure and future steps that need to take place. But the RFE, at least from my view, and through the stipulation, is saying, well, if we can determine this price, and let's just say we use it for 1,100 megawatts for 2034, and we can flex up to 2,200 megawatts for 2035, there may be benefits for ratepayers in that, to the extent that some of these WAs could be joint developed. Be able to leverage transmission, be able to get more energy or potentially more turbines by not having a buffer area between WBAs. So we believe that the stipulation does provide a degree of flexibility for benefits also for ratepayers, while balancing the need for certainty.
Would you agree with, well, I'll actually state this. Mr. Thomas, as I recall, in the sub 179 proceeding, you agreed with the position of some of the I believe, Avangrid's position that the unique characteristics of each wind energy area were of such nature that modeling them in a unique way to reflect their project fundamentals might result in a better outcome. Do you recall that?
That sounds eerily like a quote. I don't know.
I don't have it in front of me.
Maybe you've memorized it. That sounds like similar to something I said. I don't know if I said that during testimony or in my direct testimony or in our initial comments, but I generally, yes, I agree with that.
And so what you're relying upon here as we talk about offshore wind is a generic modeling output, or I guess input, to the model that was probably from the DMV study, I'm guessing.
Witness Lawrence can expand a little bit more, but yes, the DMV results were deemed commercially sensitive. And in my ideal world, it would have been nice to just take those results and plop them right in the model and have a resource called Kitty Hawk and a resource called CLV East and West, and let the model pick from the three. But that involves commercially sensitive information. And so the resource that was ultimately selected was some sort of amalgamation of the results, right? So to anonymize some of the data, but if you need to add anything.
I think that was a fair characterization. The results of the DNV study were taken into account, and a generic load profile or generation profile was synthesized for input into the modeling, and so those results informed the characteristics, but were not the characteristics individually, and so one lease area might perform better than what was included in the Compass modeling. One might perform worse because it is somewhat of an average of a lot of different scenarios.
So it's possible that the ARFI modeling inputs that are included in this analysis might not reflect what the true outcomes are for a developed offshore wind farm.
Well, I think the establishment of the RFE docket in this kind of parallel proceeding, if you want to call it that, is because we want to get a more detailed analysis of all of these resources. And part of that evaluation is obviously going to be involved in Compass modeling to determine the reference price. But it is entirely possible that we might see Duke use Compass modeling to provide a more detailed look at the individual sites and compare and contrast their benefits and differences in a more detailed way that maybe wouldn't be something that would be publicly filed with the underlying data provided to interveners such as this proceeding due to the commercially sensitive information. I don't know exactly how the RFE is going to play out and how the plan is going to develop, but I imagine that there will be modeling. Duke uses the Compass modeling for more than just the CPIRP, right? likely using that and can use that for many more purposes. There are, I believe even in South Carolina, Dominion uses some modeling software to select the optimal portfolio in all source RFP. Right. So that can be done, and it has been done, and it's done throughout the country. So I'd like to see something like that done, and we will commit to explore that and develop that and work on this RFP and the best way to manage this data, protect commercially sensitive information, while at the same time providing meaningful contrast between the sites so we can determine what the best path forward is. And we will work with Duke and the IE and market participants to do that.
And I'll just add that with that reference price there, to your, I believe, to your point that you know, you have all these wind energy, the bids that were received through the RFI process, that they inform the overall process, the modeling inputs, but are not any one specific. And so with the reference price, it could end up being that if it was, the inputs to the modeling had $1 more expensive CapEx, then offshore wind is no longer selected in any of the modeling results. It could be that it's several $billion more expensive, and so it's not intended to reflect any single wind area. And so that reference price, it gives the ceiling, and it allows for the individual wind energy areas to provide their site characteristics, which may give a competitive advantage over another, or their internal processes that they have, which could give a competitive advantage, and to be able to realize that. And it's not intended to exclude any area or to select one specifically. It's meant to give a fair shake to all three.
And Mr. Lawrence, when you speak again, can you speak more directly into the microphone, please?
All right, so to get to the point of this more quickly, let's talk about capacity factor. Duke's model assumes, I believe, a 40 to 41% offshore wind net capacity factor. Is that right?
And Mr. Smith, I think that we're going to have trouble with the transcript. So can you slow down with your questions? I want to make sure that everything is recorded correctly in the transcript.
I apologize. I'm trying to take care of this more quickly. Do you recall what the net capacity factor number that Duke relies upon in its modeling for offshore wind is?
I do not recall that number off the top of my head. But the number you
check 40 to 41%.
Subject to check. That sounds correct.
And did you all attend the intervener's technical presentation in this proceeding?
Yes.
And do you recall, subject to check, that Avangrid presented that Kitty Hawk South could provide a 42 to 45% net capacity factor?
Subject to check.
But the net capacity factor is also has multiple variables that you can also increase and decrease the overall nameplate of the capacity also to influence the annual capacity factor. Say differently, you can put in more wind turbines and have a higher capacity factor, but you will lower your overall energy, and the inverse would be true.
Sure. And presumptively, we would be trying to design this in the most cost-effective and efficient way possible, correct? Would we agree with that?
I hope so, yes.
So anyone on the panel, but Mr. Metz, and you've commented on capacity factor, would you say that capacity factor is a primary driver for an offshore wind energy area's economic case?
I can't distinguish that as a primary driver, but I would say it is a factor, a key factor. I don't have the metrics in front of me to say which value is or is not, but also generally the further north you go up the eastern shore, the higher your annual capacity factors will be in an optimized offshore wind facility.
Sure. And looking at it from a mathematical perspective of 40 to 41% and a 45% capacity factor would be a difference of 10%, right? Because it's a 10% higher number.
Generally, yes, but when you look at the overall economics, and I'm looking over the map in the back right-hand corner, we have a long way to go from those northern facilities to get them into the North Carolina service territory comparative to other ones, which would have the more southern locations would have a lower capacity factor, but that is another reason why we need assistance from the independent evaluator to evaluate the total cost to ratepayers, which would look at both the annual capacity factor and the all-in cost of the projects.
So you'd agree that the project fundamentals of the unique project should be considered as we consider the 3 different offshore wind energy areas?
Yes.
Okay, I'm going to try and get to the last portion of this. The end of paragraph 30 in the amended stipulation. And that is on page 15 of the amended stipulation. And I'm going to read this into the record and just let me know if I read this correctly. The companies will notify the commission of the results, and to the extent that the definitive pricing submitted within the ARFI results in projects that are at or below the asset acquisition reference price, the companies shall propose a plan to begin development efforts and a timeline of executable actions, or provide a detailed explanation for why development efforts or other executable actions should not be pursued and or delayed. Did I read that correctly?
Yes.
Does the public staff have concerns that if if one or more wind developer provides a proposal that beats the ARFI reference price, that Duke could still say no, despite the fact that it beat that price?
From my understanding and my interpretation of looking at the settlement, there may be other factors that come into play between now and the RP price that may prevent development for offshore wind facilities. For example, if our load projections, if we have significant load that doesn't manifest itself between now and a year from now, it would cause a delay. I think it would be very reasonable and prudent by the utility in the interest of ratepayers to say, we were expecting this project need. It shifted 2 years because we had 3 large load customers delay, which we have seen in news where large load customers shift. There could be other regulation, state or the federal level, that would potentially impact offshore. Maybe a moratorium, may not be. Could be more information on Jones Act compliance. There's a significant factors that should be evaluated or potentially discussed if a delay is warranted.
Right. I would not expect Duke to not move forward as set out in this stipulation without very good reason. And once we complete this part of the process, I expect that in our next CPIRP proceeding, we're going to be able to move concurrently. We're not going to have to, in the last proceeding leading up to this one, and now in this one, we've had to move in a linear process where we do one thing, find the results, then go to the next step, find the results, next step. And so we're trying to get out of that cycle here. And we don't want to be sitting here having the same discussion in the next carbon plan proceeding without a very good reason to do so. And this helps get away from there. We can move forward in one docket and have the same evaluation in the carbon plan proceeding so that we're still advancing, but we're doing so at an appropriate pace and with appropriate measures in place.
So the timing of advancing, as you talked about, is a number of years, it sounds like. Is that right?
I'm sorry, can you restate the question?
Well, you mentioned the next carbon plan, and going off of the timing is required by law, there's a filing made in 2025 and an order issued in 2026. Isn't that right?
Yes, that would be my expectation there.
So if that's the case, then we're talking about a few more years that the developers will have to juggle contractor costs, other development costs that they would put into a bid. Do you all agree that that sort of lack of urgency or expedition will potentially affect their ability to give their best foot forward?
It could have potentially negative implications, yes, but we believe that there are risks to the developers here. There are risks to Duke. There are risks to ratepayers, and with the as Mr. Metz spoke to, the fluidity of the resource. Sometimes it is selected and with different modeling assumptions. Sometimes it's not selected. Being the most fluid resource, we do have to proceed with caution. We can't move forward full steam ahead at this point. We do need some more surety before we would be comfortable moving and saying definitively that we need to acquire an offshore wind lease area for compliance with GS 62-110-9.
If I could just add to Mr. Lawrence's, I agree with exactly what he said. And I just want to highlight for the commission the timeline that we have laid out in the RFE, right? So following the issuance of an order in this docket at the end of this year, we anticipate that the RFE would be issued by early 2025. So early, I assume that means Q1, early Q2. So that's when the RFE is issued. Developers are going to be working on that event, and the IE, Duke, the public staff, we working on evaluating that, curing proposals, resolving questions, right? That all takes time. And then an issue or and then the results of the RFE be published in the RFE docket with the aforementioned plan to begin development efforts and a timeline of executable actions on July 30th, 2025, which is a few months before the 2025-2026 CPIRP will be filed in September of next year. So we believe, again, that this gives time in this RFE docket to review this report, solicit comments, understand, how close were we? Is this still looking like a good resource to get? What are the plan that Duke has proposed? What does that look like? And then we can proceed if that looks like a good resource. And then in the filing in September, offshore wind is again selected, maybe more consistently this time. I think that gives most parties here a reasonable pathway to say within the RFE docket, let's proceed with Duke's plan, right? And let's move forward with these executable actions in a way that during the 2025 proceeding, we are talking about how quickly we can get it, and we're using the results of this RFE, and we're having a more grounded conversation about what these costs looks like and what the actions look like, and maybe a more definitive timeline too that might inform the 2025 CPIRP. So I think that's the expectation, right? That we're going to get better, but we are hoping that this is going to elicit somewhat of a, as Mr. Lawrence said, a parallel track here where we can work on both things at the same time.
But there's no timeline that's been given here.
I think I just talked through the timeline.
Well, I believe I'll pull the actual framing. The companies shall propose a plan to begin development efforts and a timeline of executable actions. Do you see that language?
Yes, I believe that would be in service of procurement of between 800 and 1100 megawatts by 2034,
Sure.
and 22 to 2400 by 2035.
But the timeline of executable actions has not been proposed in this docket.
No.
And so looking forward over a couple of years, is it possible that during the 2025 proposal period, that by the time that the development of the actual acquired assets happens, that the numbers used could be stale at that point?
I believe that is possible. However, in this case, we had the RFI that was issued and completed after the last carbon plan proceeding, and now we've had there's been a period of fairly high inflation, and that's unusual. That's not a common occurrence, and I would not expect the same type of thing to happen after the next one, so that the results might be similarly stale and be as far out of line as what I would think they would be if we did the RFI right now compared to the previous one. And again, it's we're balancing risks here between all the different parties. And again, it's a appropriate path forward given the information we have today. And we need more information on offshore wind to say that we need to move forward with it, with acquiring it. And we're trying to balance, a number of different risks to achieve that. And as you note, that is one of the risks that are being considered.
So I just have two more questions and then I really am done. What you just said, wouldn't the offshore wind developer be incorporating cost assumptions associated with what they understand for subcontracting, construction, development costs in a proposal? And wouldn't we be risking that that would not be what would ultimately be the cost when the development of the project occurred with this uncertain timeline ahead of us?
Right. Yes, that is a possibility. There's no getting around it. However, as a co-state, we are not pursuing any resource at all costs. This is our proposal, and I believe the stipulation captures this, is a reasonable approach to balance the risks to ratepayers and hoping that the offshore winds resources or WA leaseholders bring their best estimates forward, and hopefully we can leverage the IE's expertise and potentially evaluate any metrics or inflation adjustments that have transpired between the date that you submitted and when we look at the actual item outlined in paragraph 32 of the stipulation.
Last question. You're requiring under this amended stipulation, the stipulating parties are asking that the wind energy developers provide binding information to the greatest extent possible, but they're not requiring Duke to be bound to the very terms of the contract that's proposed. Is that right?
In what, can you maybe clarify in what way Duke would not be bound?
Well, if Duke decides not to move forward, even if the asset or the reference price is beaten, Duke need only provide a quote unquote detailed explanation for why development efforts or other executable actions should not be pursued or delayed. So Duke isn't bound by the constructs of what you all have agreed upon. Isn't that right?
I mean, the construct gave the flexibility for Duke to explain the overall plan to move forward with. It could be development activities. It cannot be development activities for items that I listed.
And they are, they are bound by the stipulation. They will be bound by the commission order if the commission elects to accept the stipulation. And, there are several steps here laid out of how to move forward. There are some details that, of course, need to be figured out. But if they are required to report of exactly why they would not move forward. That's not to say it's not binding. There's just if they decide not to pursue, then they have to provide a reason of why. And if that is a reason that is not consistent with the requirements of either the stipulation, the commission order, or 62-110.9, then there are remedies in place. We have these proceedings where I'm sure that would be discussed extensively. Should Duke act unreasonably? And they are subject to several layers of review. So I don't completely agree with the characterization of them not being bound, just because there are processes that are already in place that they're bound by.
No further questions.
Thank you.
Ms. Kress-Sigfer is next.
Thank you. Good morning, gentlemen. Mr. Thomas, you testify on page 44 of your direct testimony that Duke's bill impact analysis converts the annual revenue requirement figures into an estimated bill impact for retail customers. Is that correct?
Yes, I do.
And subject to check, the bill impact analysis performed by Duke has projected customer bill impacts at approximately $80 a month for the company's residential customers by 2038, correct?
Subject to check that for P3 fall base, that sounds right. I don't recall the compound annual growth rate. I think it was between 3 and 4%.
Thank you. And would you also agree that these customer bill impact projections do not reflect all of the costs necessary to implement the carbon plan?
Yes, I think that, I would argue that probably the vast majority of costs are being captured here, but in particular, one area of cost that's not really captured in the carbon plan is distribution costs. But transmission upgrades, interconnection facilities, fuel consumption, O&M or operations and maintenance, capital costs, carrying costs, financing costs, all that's included. I'd say the biggest bucket is probably distribution.
And just to be clear, no distribution capital investments are included in the proposed carbon plan or bill impacts, correct?
There might, that's a difficult question. I'd have to look back at, there may be some component of certain generation that's kind of grouped into the distribution category. The bill impact analysis is extraordinarily complex for different spreadsheets feeding in and allocation factors. It is possible that there are some costs that routinely get allocated to distribution, but for the most part, I would say there's very little in distribution costs subject to check.
Okay, if we could get a binder in front of you and have you turn to Sigfer's potential cross exhibit number 72. And Presiding Commissioner Kimmerite, we would request that this document be marked as Sigfer 2 and 3, Cross, Metz, Thomas, Lawrence, Direct and Settlement Exhibit number 1.
It will be so marked.
Thank you. Mr. Thomas, do you see letter C here, requests that Duke Energy provide for each pathway included in the CPIRP, the forecasted amount in dollars for all distribution capital investment necessary to implement the plan and the associated revenue requirement?
Yes, I see that question.
And then the answer to letter or part C of this data request reads, no distribution capital investments were included in any pathway included in the CPIRP, correct?
Yeah, I see that. And I just want to clarify, witness Williamson performed the bill impact, but yes, so I was mistaken. There was no distribution in the bill impact. No distribution in the bill impact analysis.
Thank you. And would you also agree that Duke did not include in the bill impact analysis certain costs that are common to all portfolios? For example, the cost to obtain the subsequent license renewals or SLRs for its existing nuclear fleet?
I know that many common costs are excluded. I don't recall if SLRs will. Do you recall?
I can't remember the specifics. I'm going back into the O&M rates and the fixed and variable rates and what factors those are inclusive of.
Yeah, but subject to check, I think, yes, many common costs were excluded and SLRs could have been one of those, yes.
Okay, if you could.
And
turn with-
Mr. Thomas, can you be sure to speak directly into the microphone as well?
Of course, sorry.
Thank you.
If you could turn with me to Sigfer's potential cross exhibit number 71. And Presiding Commissioner Kimmerite, we would request that this document be marked as Sigford 2 and 3, Cross, Metz, Thomas, Lawrence, Direct and Settlement, Exhibit number 2.
It'll be so marked.
Thank you. Gentlemen, do you see the last sentence of Ms. Poplar's response on behalf of Duke Energy, which reads, "The CPIRP does not include the nuclear second license renewal costs, since these costs will be the same in all portfolios modeled and do not differentiate portfolio costs?"
Yes, I see that.
Thank you. And would you agree that Duke's proposed customer bill impacts also do not include capital investments unrelated to the carbon plan?
Presiding Commissioner Camright, I believe that a lot of these questions seem to be more targeted towards the testimony of Mr. Williamson, and he will be up later. So perhaps these questions are best suited for him.
Presiding Commissioner Kimmerite, if I may, this panel is the panel that has offered testimony supporting the amended stipulation entered into between the public staff and Duke Energy. And this line of questioning goes directly to the reasonableness of that amended stipulation and the potential customer bill impacts associated with it. So respectfully, I believe these questions are most appropriately directed to this panel.
Okay, Ms. Lord, did you want to say something else?
Yes, I do think to the extent we're getting into the details of what is included in the bill impact analysis, if we're getting that specific, I do think Mr. Williamson is more appropriate.
So I will overrule the objection, but ask that the witnesses answer the questions to the best of your ability based upon your testimony. And if you're not able to answer the question, and identify which witness would be better suited to answer the question.
Thank you. So I believe I had asked a question, but I don't think I got an answer yet. So let me ask it again. Duke Energy's proposed customer bill impacts, projected customer bill impacts rather, excuse me, also do not include, to the extent you are aware, capital investments unrelated to the carbon plan.
To the best of my ability, yes, the bill impact analysis looks at essentially the production costs and all the costs associated with building out the CPIRP and all the new generation and new transmission that's selected through that process, as well as some kind of baked in resources as well. So yes, there's certainly, as I said before, distribution investments that Duke is making are not included in the bill impact analysis.
Thank you. And you would agree, would you not, that the actual costs of transmission investments are highly dependent on the location of the project, for example?
Yes, the proxy that Duke used in this for certain resources is largely based on average results from our cluster studies, and they largely align there. Some projects will have a higher interconnection cost. Some projects will have a lower interconnection cost. So yes, it's clearly dependent on siting and the specific characteristics of that facility and the particular transmission line that it connects to.
Is it fair to say that the generic transmission proxy value could be a significant underestimate of actual transmission costs?
I wouldn't go to that far to say it's a significant underestimate. The magnitude of resources that we're trying to project across the system, it's uncertain in itself. We made our best informed judgment by using prior cluster studies across both the DEC and DEP systems, which is a very wide net across both North Carolina and South Carolina to determine the overall proxy cost. Now, it could be theoretically that costs could come slightly under that. It could be at some point in time, there'll be a tipping point where a large transmission project will be needed. Yet in that case, it would be an underestimate. But we also looked at the public policy results in a $2.6 billion upgrade, compared that to the proxy cost and the amount of solar that's being interconnected, and they were relatively close. I can't remember the exact dollar value, but they're relatively close. So that's how we benchmarked the proxy cost and its reasonableness.
Okay, Ms. Kress, we've come to our morning break. So we are going to take a break. We'll come back on the record at 11:15 and resume the cross-examination. With that, we'll go off the record. let's go back on the record. Ms. Kress, you may continue with your cross-examination for SIGFR.
Thank you. Mr. Metz, I believe before the break, you disagreed with my characterization of significant underestimate. So let me try to ask the question this way. Is it fair to say that the generic transmission proxy value could be an underestimate of actual transmission costs?
That would be correct, yes.
Thank you. And Mr. Thomas, to the best of your knowledge, do Duke's bill impact projections assume that South Carolina will pay its jurisdictional allocable share of carbon plan implementation costs?
Mr. Williamson, again, performed the bill impact analysis, but to my knowledge, the bill impact analysis only allocates the North Carolina retail share to the bill impact for North Carolina customers.
And to the best of your knowledge, are you aware of any public indication from South Carolina to date that it intends to share in the costs for investments made to satisfy the carbon emissions reduction goals in North Carolina's House Bill 951?
That would require speculation on my part to state what South Carolina believes or does not believe.
Mr. Metz, respectfully, I'm asking whether you're aware of any public indication to date from South Carolina that they intend to allow cost recovery of carbon plan implementation related costs.
I am not aware of any indication that they have stated that they are not going to pay for these costs. I know there's a lot going on in South Carolina right now with all source RFPs and an IRP and a rate case. So I'm sure that there's testimony there that I'm not aware of, but I did briefly review their comments on Duke's IRP and did not see a statement to that effect. But again, I have not exhaustively read every ORA statement in South Carolina.
And has the public analyzed how much higher the potential bill impacts related to the carbon plan implementation could be if South Carolina disallows cost recovery for one or more carbon plan related investments?
No.
So for all the reasons that we've discussed this morning, is it fair to say that the $80 a month projected bill impacts by 2038 are likely to be much higher?
I think that the bill impacts, I assume this is the 2038 estimate for residential customers. Yes, it could be higher. I think that the fact that distribution and spend is not in there would indicate it might be biased a little low. Some costs are not included, but it's hard to tell, right? It's hard to say what might happen between then and now if tax credits might, continue or be repealed, or if technological advances could lower the costs of certain resources that were anticipated to be too high, or fuel prices might change. So yes, there's a lot of uncertainty. And I would say that given the information we have at the time we have, the $80 estimate is what it is, but it could go, it could be higher.
And you testified in response to counsel for the Attorney General's office that House Bill 951 requires all reasonable steps be taken towards the carbon emissions reduction goals set forth in that legislation, correct?
The statute, I believe, speaks for itself. Yes, it says all reasonable steps, but there are obviously considerations to that effect that have to be considered by the commission and the public staff and interveners in Duke.
At what point, in your opinion, in the opinion of the public staff, do we cross the threshold into an unreasonable step?
I mean, I think I can mention one is, and generally is just, we're not going to go procure everything at all cost. I mean, that would be crossing the threshold, for example, the offshore wind discussion, that we're not authorizing to move forward with procuring any resource, but notably just offshore wind at all costs. When we looked at it, it was the most influential resource on the for selection.
So if $80 a month for an average residential retail customer is not crossing the line into unreasonable territory, what would be, in the public staff's opinion, $100 a month, $1,000 a month? Where do we cross the line into unreasonableness?
I can start off. I mean, public staff considers any rate increase to customers, regardless of the customer class, to be a very important step to evaluate. At this point in time, I don't have an absolute dollar value. The only thing I can try to do is from a benchmark standpoint. If you look at Duke's P0 plan, which is the non-carbon constrained plan, and if you look at the overall PVRR numbers, which one can gauge the PVRR could be in ratio or scale to overall bill impact analysis. And if you look at, notably I'm looking on page 82 of my testimony, figure 1, it just has the nuclear capacity because I have the PVR for all the portfolios, just not nuclear, but all the portfolios. If you look at those costs for 2029, you can see that the median was $29.6 billion. P0 subject to checked was $30 billion. If you look at 2033, the median was $49.7 billion. P0 was also $49.7 billion. When you go out to 2038, the median was $77.7 billion and P0 was $74.3 billion. But when you look up at the range of sensitivities that we ran, that for purposes from present to 2038 with a 15-year horizon, which is already making assumptions on the tail end of a planning period, the overall price, the PVRs, are relatively in a tight band. There's only a few outliers, and P0, in my opinion, is not one of those outliers.
If I could just maybe add a little bit to that. So, obviously, if we saw rates go up and the average bill go up today by $80, that is a big increase. I think I just want to make sure, as Mr. Metz said, we always look and review closely any plan or any rate increase request by Duke to ensure that it is reasonable for ratepayers. But $80 increase by 2038, some of that increase, not all of that increase, is coming from investments necessary to meet the carbon plan. First, that includes inflation. So there's going to be some amount of that is simply due to inflation, right? Prices go up over time, incomes go up over time. Some of that would be needed to facilitate new load and retiring assets, even without a carbon constraint. As we see in P0, there are still costs in the no carbon constraint scenario to maintain and expand the grid and maintain adequate reliability. And yes, there is an incremental component to meet the carbon plan emission reduction targets. So I just want to make sure that we don't know what a reasonable number is or in what context that number is given, but we will closely review any rate increase requests and any expansion plan presented by Duke to ensure that ratepayers are protected to the greatest extent possible and that we are following that least cost plan.
Mr. Thomas, you said we don't know what a reasonable number would be. Whose job is it to determine what a reasonable number is, if not the public staff's?
Well, if I may, Mr. Thomas, correct me if I'm wrong, but we're saying we can't determine whether it should be $79.7 or $80.01. There's not a finite way to say with an absolute on what the reasonable rate monetary amount would be, Mr. Thomas.
I think that's accurate. I think if the statute had laid out a particular cap on costs, as we see in other statutes, I think we could use that as a benchmark, but it didn't. So we have to evaluate bill increases in the context in which they're happening, right? We have costs are going up, load is coming to North Carolina. We have to build new generation for that load, regardless of what other, regulations, statutes we have to comply with. There's rules coming from the EPA, right? There's other actions being taken here that could drive up prices, could drive down prices in terms of incentives and grants. So it's very difficult to determine what is necessarily reasonable, but we believe that the stipulation that we've filed and that we've agreed to does represent reasonable steps to both maintain the adequacy and reliability of the grid, to follow the least cost path and to be able to actually execute on.
There's nothing in the amended stipulation, correct, that caps Duke's total capital spending in the aggregate over the 15-year planning horizon?
That is correct.
And there's also nothing in the amended stipulation that caps the potential customer bill impacts during the 15-year planning horizon?
There is no line item with a hard-coded number to set a maximum cap.
Yes, this is, again, this is a planning proceeding and not a rate recovery proceeding. So
And there's nothing in your settlement testimony specifying customer bill impacts resulting from the as stipulated near-term action plan, correct?
no, there's no caps in the stipulated testimony. There are no billing caps in the stipulation testimony.
Other than 45% of the new solar resources called for in the resource mix proposed and stipulated between the parties, Duke Energy will own and receive rate-based treatment of costs recovered for new generation and transmission assets built pursuant to the carbon plan. Is that right?
Yes, pursuant to 62-110.9, any new generation facilities or the resources selected by the commission in order to achieve the authorized reduction goals shall be owned and recovered on a cost of service basis.
And what qualifying is when they're found to be reasonable and prudent.
In other words, Duke Energy has a clear profit motive for signing this amended stipulation.
I'd require speculation on what Duke Energy motive was for the stipulation.
Does rate-based treatment mean that Duke Energy earns a return on capital investments?
That is correct.
And did you hear my conversation with Ms. Bowman that as we sit here today, 29% of Duke Energy's North Carolina residential customers qualify as low income under federal poverty guidelines?
Yes, I recall that.
And as we sit here today, 16% of Duke Energy's North Carolina residential customers are currently in arrears on their electric bills.
Is there a question?
That was a question, yeah.
Did I hear that?
Are you aware, subject to check?
Oh, subject to check. Yes.
And one of the parties to this amended stipulation is a trade group who primarily advocates for the interests of solar developers, correct?
Which organization? I believe so. Yeah. Talking about CCBA or?
Is one of the parties to this amended stipulation a trade group that primarily advocates for the interests of solar developers?
Believe so, yes.
Thank you. No further questions.
Okay, Mr. Trathan for CUCA.
Thank you. Good morning, Marcus Trathan for CUCA. Just a quick follow-up on Ms. Kress's questions about bill impacts. And I heard you say, well, this is just a planning exercise, but not a rate case. But isn't the problem that if the commission authorizes the construction of a facility, Duke's going to be back asking for recovery of those costs, is it not?
In a CPCN proceeding, which this is not, the commission would authorize the construction of a facility. And yes, once that facility is placed in service, Duke would presumably come in and request recovery in a general rate case. And we would investigate those costs to ensure that they were reasonable and prudent.
So my point is that if you get to the point of a rate case, it's too late to be figuring out what the bill and the bill impacts are for investment that's already been made, isn't it?
And Mr. Trathan, I'm going to need for you to speak up as well. We need to hear you better for the transcript.
Thank you.
In part, yes, but as I tried to clarify earlier, when looking at P0, which is a non-carbon constrained scenario, compared to the public staff's multiple other sensitivities and core planning assumptions and Duke's own core planning assumptions and sensitivities, the cost, at least through 2038, are relatively the same. So to me, that's showing a few items, but notably, we need to retire approximately 8.5 gigawatts of coal based upon, one, they're reaching the end of their life. Two, they were never really designed to operate this way. And it's economic to actually replace the generation resources as a benefit to customers. And couple that natural retirement or progression of those assets with the amount of load that's projected to come into North Carolina, we need additional resources on top of that. And to me, that's why I look at P0 when looking at the overall PBRR compared to the other scenarios which have a carbon constraint. You start to get insight onto what is the minimum cost in order to engage in this transition without a carbon constraint, and it's relatively close with a carbon constraint, at least through approximately 2038.
Okay, well, let me come at it this way. And Mr. Thomas, I have some questions about your direct testimony, but certainly if any other members of the panel wish to chime in, feel free. Mr. Thomas, at page 11 of your testimony, lines 16 through 21, a chance to get there.
Yep, I'm there.
Okay, so you've got a Q&A here. If Duke implements the NTAP proposed by the public staff is compliance with HB 951 guaranteed, and the response is no, with a significant amount of uncertainty around the dates by which new resources would be available and the costs that we incur to procure them, it's not possible to guarantee compliance by a certain date. Did I read that accurately?
You did?
And is this still the case even with the near-term actions agreed to under the stipulation?
Yes, I believe it's always the case. And we're talking about interim compliance in 10 years. If I could tell you exactly what the situation would look like in 10 years, I would probably be on a yacht somewhere. We don't know what the load will look like. We don't know what the resources will look like. We do competitive procurements for many of these resources, but we like to make sure that there's enough of the resource bidding in. We don't know what kind of laws Congress will pass or regulations will be adopted that might influence the selection or the maintenance of existing and new resources. There's a lot to be said. So I think we are taking reasonable steps to comply in the early to mid 2030s. But this is not a guarantee that if we follow this near-term action plan that we will absolutely guaranteed reach compliance by 2034. I think we have to check and adjust every 2 years. We have to make sure we're procuring these resources in the least cost manner. We have to make sure we're getting every single dollar of federal and state incentives that we can get our hands on to make sure that the ratepayers are benefiting from these programs being passed at the federal level. And so we may not see, we may have in 2034 a significant crisis with natural gas and prices jump to $20 a decatherm, and this whole thing has to be reassessed. There's a lot of uncertainty here, and that's what I mean by this portion of my testimony, is that we're on the reasonable steps, we're taking those reasonable steps, but at the end of the day, nothing 10 years out is guaranteed.
Okay, if you could turn to page 21, please. Lines 4 to 6. And do you see your testimony, the year chosen to meet the interim compliance target as a fundamental input to the CPIRP can be considered as influential to resource selection as the electric load forecast? Do you see that?
I do.
Okay. And am I correct that both the public staff and Duke implemented a financial penalty in its modeling for failure to hit the target time, the target on time?
Yes. So whenever you implement some constraints in the modeling or to allow the model to solve, there's somewhat of a soft constraint. They can be violated. So like, for example, a ramp rate constraint on a resource, that cannot be violated. But the carbon cap, as well as the load forecast, those are constraints that can be violated for both. The model can choose to emit more CO2 than the limit if it is cost effective to do so. But you have to kind of implement a penalty to force your model to attempt to take reasonable steps to get there. And the same penalty exists for load forecasts. The model is capable, if it cannot select the right resources, it is capable of shedding load in order and say, I'll just not serve these customers during these times instead of building new generation if it's cost effective to do so. But again, you have to put a penalty in there to discourage the model from doing so, because the model is simply linear optimization. It doesn't have feelings. It doesn't talk about not shedding load on Christmas Eve. It is simply a model, and it will do the cheapest thing that it possibly can do. And so we have to make sure we put in some sort of penalty or disincentive for it to do those things in order to comply with things like a statute or a regulation.
And so in this case, to my question, the way the carbon plan targets were implemented were through the penalty, correct?
There is the carbon plan the carbon constraints are implemented by setting an annual limit on CO2 emissions. Every resource and fuel has a certain emission rate and efficiency rate. And so based on the dispatch of these resources each year, the model adds up all the CO2 and checks to make sure that it's below that cap. And so that is the primary mechanism by which it is implemented. The penalty is simply a disincentive to say, hey, this is a law that you should follow, and we are trying to see what resources are needed to comply by that date. So don't ignore it. And here's the disincentive to do so.
And so would refer you to page 50 of your testimony, lines 18 to 19. Okay, and this is in reference to the 2030 interim compliance date, and here you testify that compliance by 2030 is nearly impossible, likely cost prohibitive. Do you see that?
Yes.
Is it the public staff's position that if achievement of the interim target by date and certain is cost prohibitive, that the commission is no longer required to develop a carbon plan to achieve that date?
So kind of as an initial matter, I think I spend a lot of time in my testimony kind of discussing this. I think the biggest flag for us on the 2030 compliance or portfolio one is that it is likely impossible to connect that number of resources while retiring that quantity of coal. I just do not see a pathway to connect over 7 gigawatts of solar and storage in a single year in North Carolina from where I sit. And so are talking about a three-legged stool, least cost, reliability, and execution risk. From my perspective, that is simply unexecutable. And that will be, if we retire that coal and we can't build that much replacement resources, we are going to have problems in terms of reliability. So right off the bat, that's part of the reason why we said 2030 is not possible. And I believe our amended stipulation reflects that, requiring Duke to continue to submit models that comply by 2030 in the future is no longer a productive exercise. It is simply the load and the new resources that are needed to be added and the rate at which we need to add them. It is simply not possible to get there. And that's why our stipulation reflects that.
And we also expand upon looking at the 2030. It's not just from a modeling exercise, but the real world impacts. So in the reliability section of my testimony on page 139, we showed a graph, notably a Duke Energy progress for DEP 2030 high grid edge case. What that graph is trying to show, here's our normal load shape. In order to meet 2030, we had to interconnect this much solar generation and other resources, which as Mr. Thomas pointed to, we don't even know how we could interconnect that much without causing other grid constraints, that you would see for the shoulder seasons, the amount of generation that would be going into nuclear generation, which you would have to curtail for significant hours out of the year. And it also shows the amount of solar generation that would just have to be curtailed because we have more generation than we have load. So when we looked at 2030, it was both from can we implement it, and then what are the actual reliability impacts if we tried to do it on our system. And based upon the combination of those two items, we do not believe that we should move forward with 2030 at this point in time.
Okay, so for those reasons, the public staff agrees that Duke has satisfied the statutory criteria for relief from the obligation of 70% carbon reduction by 2030, correct?
From my view of the operations and reliability standpoint, I no longer believe it is reasonable to pursue 2030 compliance with, yeah.
Okay, and I believe that the public staff modeled compliance by alternative dates, 2032, 2034, 2035. Is that correct?
As well as a 2037 sensitivity with the EPA 111 variant.
Okay, but wouldn't you agree that the carbon plan statute doesn't refer to any of those dates, only refers to 2030?
Yes.
Presiding Commissioner Cameron, I would just note that some of this might be getting into calling for legal analysis, which is, outside the purview of our witnesses.
Mr. Trathan, do you want to respond?
Certainly, I'm not asking for legal conclusion. This is, they've done modeling. I'm asking what they modeled and why they modeled it. And if they don't have an opinion as to how this conforms to the law, that's fine.
Okay, so the objection is overruled. However, the panel, you are not lawyers, and provide your answer to the best of your ability within your field of expertise, please.
Sure. Do you mind just restating the question?
Yeah, certainly, I think I was asking whether or not those specific dates, 2032, 2034, any date other than 2030 is called out specifically in the carbon plan statute. Yes, in the carbon plan statute.
Mr. Trathan, can you speak louder and a little bit more clear, because we are having trouble, I think, with the transcript with your questions.
Thank you.
So I would say that, yes, 2030 is the only year mentioned in the statute, but Section 4 of the statute does, state the commission shall not exceed the dates by more, specified by more than 2 years, which obviously puts 2032 in play, right? That, to our perspective, that's always said the commission can delay up to 2 years to 2032 without any really triggering event. And then beyond the rest of that sentence essentially gives discretion to the commission to delay that goal beyond 2 years, in the event of a construction of a wind or nuclear facility, or in the event necessary to maintain the adequacy and reliability of the existing grid. And I believe in my testimony, we argue that 2034 at this point is that is achievable based on earlier compliance, potentially threatening reliability of the grid if we're not able to connect the required resources while retiring coal. So I think that's a big part of what we use to justify going beyond 2032 in this particular proceeding.
And then further, just to add on to that is, the 2034 plan is aggressive in itself. We consider it to be aggressive but achievable. To go much further beyond than 2034, you're almost, for terms of interconnection limits and the plans, et cetera, you're almost setting yourself up for failure, that you're not going to achieve it. So we tried to balance that as what is an actual reasonable expectation, albeit on the aggressive side, and not necessarily be passive and not to set any specific date.
So would you agree that ultimately the commission will have to resolve the legal issue as to whether some interim compliance date should be read into the statute if relief from the 2030 date has been justified?
I think in part that require legal conclusion that I can't speculate on what this commission must or must not do.
No, the question is just simply that that's an issue that the commission would have to resolve. Do you agree with that?
I mean, I think the commission can do what it would like. I think that in the last proceeding, 2022 proceeding, you know, the commission found that it was reasonable to approve a near-term action plan and no particular portfolio, and that, you know, we should shoot for a target range of interim compliance. And I don't know exactly how this would, you know, will shake out. I think we're going to continue in future carbon plan proceedings in evaluating a range of interim compliance dates, because I do believe that provides valuable information to the public staff and to the commission and to interveners. But whether or not the commission needs to pick a date and set that date in this proceeding, I don't know. I'm an engineer. I run the models. I don't know what is needed for the next carbon plan hearing.
Thank you. That's all I have.
Mr. Smith, you're up next for EDF.
Thank you. And I'm gathering my thoughts for just a second because actually Mr. Trathan took some of my questions. So just one second. Okay. I'm not going to rehash a lot of what Mr. Trathan just went through, but I do want to make sure I understand that when you were doing the modeling runs and looking at Duke's modeling runs, compliance with House Bill 951, you all didn't input sort of the specifics of the statute when you were looking at the modeling. And I'm talking about the language saying that extensions beyond 2032 require either an offshore wind construction, advanced nuclear construction, or a question about the adequacy or grid reliability issues.
As far as what we put into the model, I can say you might be overestimating the abilities of the model there to think that that could get in there, but I think that's the discretion that we apply, right? That's why we run so many sensitivities, why we analyze so many different interim compliance dates, so that we, the public staff and Duke and the commission in particular, can decide what is reasonable steps. But no, there's no mechanism to put this type of language into the model.
And
We
we exercised our discretion in looking at notably, or in the event necessary to maintain the adequacy and reliability of the existing grid, which I illustrated in the reliability section of my testimony to that point. There's just certain actions that should not be taken or you'll compromise system integrity.
Thank you. Sorry, this is cutting a lot of my questions, so this should be good for everyone involved. Okay. And this might be, well, just tell me if this isn't appropriate for this panel. I'm going to talk a little bit about CA Rule 111, EPA Rule 111, because Mr. Metz, you testified a bit about it, but I also know the next panel has some testimony on it. So feel free to punt if you think it's inappropriate. Under the new final Rule 111, can you explain what the annual limitation on capacity factor is for new natural gas units?
So Mr. Nader will be able to explain that in more detail, but at a very high level for new natural gas combined cycle plants, it is my understanding, subject to check, that is a 40% annual capacity factor unless you have carbon capture or sequestration or another mechanism to get the overall carbon down to, I can't remember the range.
Thank you. And are you aware of any concrete developmental plans that the companies have put forward for carbon capture and sequestration at this point?
I'm mixing dockets here a little bit. So there was some confidential discovery within the Person County combined cycle CPC and application on that direct topic.
Thank you. But in this docket, I think, would it be fair to say the companies have said, we're likely going to look into this, but there's nothing yet concrete on the table in this docket?
But the company, Mr. Thomas, the companies did provide in rebuttal testimony a EPA 111 variant, which
Yeah, I mean, just to answer your question, no, Duke is not right now making concrete plans in this docket to CCS. In fact, I believe that they've said in the rebuttal, as Mr. Metz was pointing out, that their compliance plan with the EPA rules involve limiting their new combined cycles to 40% and not pursuing CCS. So,
Thank you. And do you all think that that in part reflects an execution risk involved with the CCS development?
well, if we were planning to run our new combined cycles at full bore with CCS, yes, I would say that would be a huge execution risk. But that's not where we're at. We modeled several portfolios limiting new natural gas units to 40%. So did Duke in their rebuttal testimony. The model still selects these combined cycles, but a large part of the reason why you are the Clean Air Act rules and this limitation appear to push out interim compliance or make interim compliance more difficult is because a lot of the benefit of these new combined cycles is that they're more efficient, they're less expensive to operate than our existing natural gas fleet, and they produce a lot less CO2 at the stack than coal. So when the model is building these new combined cycles, part of the way it complies is by using these new efficient, modern combined cycles to replace the generation, less efficient, more expensive generation coming from older combined cycles and coal units. When you limit those new gas plants, you still need the energy from them, you still need to build them, but you don't get as much benefit in terms of displacing your older units. And you can see that in the modeling results. And the results where we model the 40% cap, you see existing coal and existing gas are utilized a lot more than in those situations where we did not limit it. And again, witness Nader can maybe expand on the impacts. Yeah, I'm just mostly talking about the modeling and the impacts that it had.
And that's what I want to focus on. You're just talking about the results of the modeling would require coal to be relied upon. That would imply, well, does that imply that, I'll restate that. When referencing the impact of CAA Rule 111 and the modeling outputs resulting in relying on coal, is that informed at all by the compliance requirements in HB 951?
I think everything that we are doing is informed by the compliance requirements in 951.
There's essentially two binding constraints. You had essentially the North Carolina carbon constraint as well as the Clean Air Act constraint.
Exactly. So talking about that challenge, that limits the abilities of natural gas firing turbines from what sort of previously they were able to do in some ways, shape, or form. Is that right?
Yes, it's a limit on their output, so it's less energy coming from those facilities.
So what is the primary driver then for pushing forward new natural gas, given the constraints that are on them?
New load and the orderly exit from coal. So new natural gas is necessary. We have significant economic development load, data centers, new manufacturing, new residents moving into the state. We need energy and we need capacity. Much like many utilities in the Southeast, we are staring down the barrel of a deficit of capacity and energy. And so these facilities are needed. And without them, you have to meet that load somehow. And so you're either going to rely upon wholly unreasonable levels of interconnection of new alternative non-gas resources, or you're going to shed load. And so we have to look at this and balance both the risk of underutilization of these new gas plants, right? Are we going to be running them on hydrogen in 2050, or are we going to be securitizing their net book value? I don't know. I can't tell you that. I know we have some doubts, concerns about hydrogen, as witness Mishna can talk more about, but at the end of the day, we have very limited options in this near-term window to meet load and maintain the reliability of the grid. And that is critical, right? The statute explicitly calls that out. And so there are risks with natural gas. There's risks with a lot of resources, but we do need some of this resource in order to meet the load of our customers.
Just going to expand upon to put it in context, between 8.4 to 8.6 gigawatts of coal generation will be rolling off the system within approximately a decade, even faster than that. That magnitude of capacity, winter morning capacity, plus the coal plants are still some operated at different stages, but let's just say they operate at a nominal 30 to 40%. We have to replace those resources for both the capacity of energy. So yes, we have our concerns about all resources. It's just not natural gas, but the combined cycles are filling and are complementing the system needs with aggregate of our existing systems and from an economic selection of future resources.
And I'm going to try and cut to the quick here. Is it fair to say that an advantage that natural gas has over alternative generation resources, like say nuclear, is its dispatchability?
Combined cycles and combustion turbines would be more flexible than, say, traditional nuclear generation assets. It's not to say that nuclear can't be cycled, and there's certain plants that can be cycled more fluid than others, but generally, yes, natural gas generation resources are more flexible.
And you just referenced winter mornings. Are those the times where that resource flexibility is most needed?
I would say it is needed. I can't say it's most needed. If you look back in the reliability sections of my testimony and you start looking at those ramp constraints, I would state that there is almost now more flexibility needed on the middle of every day and at the end of every day as we try to complement the existing solar generation penetrations that are occurring in our system.
And would an offshore wind build out complement that solar profile you just referenced?
From a generation profile standpoint, yes, if setting aside costs.
And would it potentially offset some of the need for dispatchable natural gas resources that aren't optimized?
That's complex to state and require a high degree of flexibility. I mean, you have to factor in the ELCC curves, which Mr. Thomas is going to expand upon in more detail. Every generation unit, regardless of what type it is, you're going to have outages, you're going to have cycles, there's going to have to be maintenance. I think we heard from the Duke panels, you don't put all your eggs in one basket. We're not doing that.
Mr. Thomas, can you comment on the ELCC curves for offshore wind on particularly winter mornings, but really overall for their profile?
Yeah, so I believe you're asking about a particular table in my testimony.
I was going off his question. I actually didn't have this ready.
Yeah, so ELCC is, I explained a little bit in my testimony, it's a measure of essentially how able is this resource to replace something that's relatively firm and dispatchable, and what's the ratio of replacing that we need. And so offshore wind, I'm looking for the particular figure, does have a relatively high ELCC. So I'm having trouble finding up there. Yeah. So figure 5 on page 39 of my testimony kind of shows these declining ELCC curves. This is the winter ELCC, the effective load carrying capability is what ELCC stands for. And so offshore wind is the blue line there we have for DEP. And so you can see there that essentially that first block of offshore wind gets about 75% of its nameplate capacity that it can be reliably counted towards its reserve margin. That does not mean that in every single winter morning it's going to be at 75% output, but it's kind of a probabilistic analysis, and over many winter mornings and many different weather years and all of this, that's what we can reliably expect. And it is pretty high. It's a little lower than onshore wind. It's higher than, no, I'm sorry, it's higher than onshore wind. It's lower than kind of the initial deployment of batteries. And it's obviously much higher than standalone solar. So certainly it can provide some help during those winter mornings.
Thank you. And talking about probabilistic scenarios, I want to make sure that like the idea of there are forced outages for natural gas firing facilities that can cause some issues related to being able to have ELCC curves at 100%, for instance, right?
Yes, and I think, outages is a component of this, right? I mean, this analysis assumes and uses outage data and even these resources, right? I mean, there's no guarantee that every turbine in an offshore wind field will be operating at, 7 a.m. on a winter morning. There may be some down for maintenance. And so a lot of this is kind of like baked in, right? That there's always the potential for some level of outages, at thermal facilities as well as at renewable facilities.
Thank you. Back to my questions. I want to talk a little bit more about modeling issues. Are you all familiar with the concept of a scenario analysis and modeling?
Yes.
And can you kind of explain for everyone, define that if you would?
My understanding of it is kind of similar to what we did. We put forward portfolios with different underlying assumptions, right? Call it a scenario, and said, well, if this is how things shake out, this is what we'll want to do. This is the least cost path. And if this is how things shake out, this is our least cost path. And then Mr. Metz can kind of talk about it, but then he took these multiple scenarios and kind of tried to determine a near-term action plan that would, be least regrets, get us to where we need to be, and was robust over a variety of these kind of scenarios.
No, I agree.
And I want to get into advanced nuclear and specifics. What sort of scenario analyses did the public staff do on the advanced nuclear case?
1 second. So you may be referring to page 80 within my portfolio analysis section that specifically calls out new nuclear, where I list out figure 1, nuclear capacity, that lists out all the public staff's sensitivities and core assumptions, as well as Duke's core portfolios, and looked at when new nuclear was being added to the system. I go on to multiple pages after that, talking about the pros and cons, the least costs, and the pros and cons of each one.
And I guess this is very helpful for you to point this out, and I had seen this before, but I'm not a engineer, so sometimes I need to be walked through a little bit. Talking about the scenario analysis on advanced nuclear, do you see or what were the variances that were included? And I don't know if I'm using the right term, variance, but what were the sensitivities that were included in that scenario analysis for the range of advanced nuclear outcomes?
I mean, for example, looking at figure 1, you go to PS1F 2034 Excel SMR. We just allowed the model to say, what if we could build nuclear faster? What would the model do? Basically, are we over constraining the model? Setting aside even if we can build it, or the execution risk associated with building it faster, would the model be able to select it? And I believe, subject to checked, we have moved up to, it's on page 83, starting at line 3. We accelerated SMR portfolio. We allowed it to be selected in 2032, but the model did not economically select it to 2033. So even though we allowed it all the flexibility to come forward, it didn't select it, but it did select it in 2033. As we transition to the next bullet points, we tried to make correlations between some of the portfolios. The highest PVRR in both 2038 and 2050 had the lowest SMR deployment. the lowest PVR in 2008, 38 had the greatest SMR deployment. So we started seeing is, could we build it faster? It didn't build it as soon as it can, but it did accelerate it. And in model runs where it did accelerate it, we had overall lower costs. In models in which it was built later than, we had higher PVR costs. And those are just a few.
Sure. And let's talk about costs, because it looks like on page 83, you list the first risk factor with the deployment of SMRs being the ultimate deployment cost. Can you talk a little bit about how the public staff modeling sort of determined the range of costs that could be associated with the build out of SMRs?
We used Duke's updated SPA analysis, which had a significant update in the overall dollar per kW cost. I can't remember the direct dollar amount, but I know it's also confidential.
Yeah, just in between the initial filing and the supplemental planning analysis, the all-in direct installed cost of SMRs increased by approximately 70%.
And
with that model input, which is represented in our figure 1, the resources was still being selected.
but you're just using what Duke gave to you. You didn't run it at higher than that cost.
No, because you then would have to run every scenario, every sensitivity with both high and cost for every technology. So it would be exponential the amount of sensitivities would have to be run.
Also, I would just note, just because of the way that the capital costs are modeled in Encompass, pulling it in or accelerating the nuclear as we did kind of moves it up the cost curve, because it costs start in 2023, they decline for about 10 years, and then generally start to increase again, kind of reflecting some learnings and inflation and all these facts. And so by moving it in by two years that we pulled it in, we also, that just by definition increased the price by
It's a steep curve. The updated price used a very steep curve in the early years before it plateaus versus the prior plan had more of a slower slope or less slope.
Yeah, just wanted to
But-
point that out.
These are costs that aren't based upon commercially operating SMR units, right? These are more projections, isn't that right?
It's projections of Idaho National Labs, which does nuclear research and multiple other aspects of research across the industry.
Sure. But there's no way for you to compare it to a commercially operational unit to make sure that those prices are accurate.
That's fair to say.
And so was there a and I'm going to go out over my skis here a little bit, but was there a deterministic sensitivity analysis that spoke to if advanced nuclear was not ready on the timeline that you all expect it to be, or if it costs more than what the projected costs are supposed to be?
No, I think I will say, we have probably run more models than we presented in our testimony. But I think we tried to winnow it down, as I'm sure Duke did as well, try to winnow it down to a reasonable set of scenarios to present. But for that particular one, we did not testify to that, but I believe I recall running some of that at least in 2022. And but I think that is something that we will probably explore in the future. Right now, we have a reasonable understanding of nuclear. It's selected by the model almost as much as it can get, as soon as it can get it. And if that resource is delayed, right now, I think I have no real reason, Mr. Metz can add, no real reason to believe that it would be delayed beyond the dates that Duke has assumed for its first availability. But if in the next carbon plan proceeding, we find that, maybe the NRC has moved faster than expected, or maybe slower than expected, then we're going to have to understand what replacement resources would be needed, assuming those SMRs could not come online.
And in part is also why, again, identifying, going back to offshore wind, we're talking about the two long lead time resources. So by default, it is nuclear and offshore wind. that in some model runs, offshore wind was either delayed or even not selected. I identified that risk in laying out our near-term action plan with looking at nuclear, how it's being selected. So that's why I propose to say we need to move forward with further evaluation of offshore wind as listed in the stipulation agreement, because we need to evaluate, we need to be able to have the ability to potentially pivot in a relatively short time for a resource that may take approximately a decade to build. And I believe that if the commission was to approve the stipulation, that we are doing just that in order to gain more insight, gain more knowledge, gain more data, to get more absolute numbers, get more surety to advance moving forward.
Offshore wind is a commercially available resource, correct?
I mean, it's a resource that is in commercial operation along the East Coast and in Europe. And yes,
I believe there's a limited number of smaller plants commercially operational on the East Coast of the US, but it is, yes, a wider used resource globally.
So you
And,
could,
and Mr. Thomas, can you speak a little louder into the
Yeah.
microphone too, please?
so for modeling purposes, you have some historical data to validate what your assumptions and inputs are. Isn't that right?
Yeah, I mean, I think the best source of information that we kind of have for that is we've looked and talked to the offshore wind developers about, auctions that are happening, in the Northeast, New York, New Jersey, right? They have these auctions for these resources to bring them online, and we've seen, lots of projects having to go back and revise their bids and cancel their PPAs because they can't make that price work. And inflation hit the recent bout of inflation hit the offshore industry quite hard, as well as many industries, right? So we've been keeping an eye on that, and I'd say that's reasonably validated there. But again, those are also states with clear offshore wind statutes or mandates in competitive markets with state government involvement. So it's a bit of a different situation here, but it is a guide point that we can look at.
And comparing to SMRs, there are no commercial SMRs where you could validate the data that you use in the modeling. Isn't that right?
there are no commercial SMRs deployed within the United States.
So the projections are essentially you all hoping that it hits those cost and timing marks.
I wouldn't go as far as say that I'm hoping that we use public data from a nationally recognized resource, Idaho National Labs, which the company also evaluated. We also benchmarked that based upon discussions and dialogue that we had with Dominion Energy during their IRP, that we felt that that number was reasonable for planning purposes. The company's proposed actions for nuclear development will provide more information for future IRPs and be able to further construct or get more scope or absolute dollar value on what those costs will be.
Have you spoken to Dominion about their recent purchase of Kitty Hawk North?
I have not spoken directly with Dominion Energy on that purchase.
No further questions.
Mr. Dodge, your turn for EMC.
Thank you, Presiding Commissioner. Good morning, gentlemen. Or,
Morning.
yes, good afternoon, I guess, at this point. I'm going to start with a few clarifying questions regarding the stipulation of settlement that the public staff entered into with Duke and Walmart that was later amended to include CCBA on Monday, July 22nd. Do you have a copy of that stipulation with you?
I do.
And Mr. Metz and Mr. Thomas, you both filed testimony supporting the amended stipulation, is that correct?
Yes.
We did.
See, I'd like to ask a few questions regarding the unresolved issues section, which starts on the top of page 22, I believe, of the clean version. I'm sorry, what was? Of the clean version of the document. Yes, sorry. There was a red line down a clean version. I was referring to page numbers on the clean version.
Top page 22 on there.
Right. And this indicates that the public staff and Duke do not agree with regard to recommendations regarding whether or not the commission should acknowledge the RZEP 2.0 projects as necessary for carbon plan compliance. Is that correct?
That is correct.
So the position recommended in public staff testimony, Mr. Metz, your testimony is still consistent with the public staff's overall position with regard to RZEP 2.0.
That is correct.
Can you turn to paragraph 40 of, it's on page 18, paragraph 40?
I'm there, paragraph 40.
And briefly, about 2/3 of the way down the document, there's a header there in bold and italics underlined that says continued focus on strategic transmission planning and acknowledging the benefits of RZEP 2.0 projects to support resource plan execution. Did I read that correctly?
That is correct.
And that statement seems inconsistent with the unresolved issues section in this stipulation, does it not?
It is, and looking at this now, yeah, I think that header would need to be clarified. It's probably a remnant of continuing negotiations, which were not able to be finalized.
Thank you. And with regard to the amendments that were made when CCBA joined the stipulation on page 41, and I'm going to paraphrase here briefly. The language now states that the commission should direct the companies to plan, identify, and propose cost-effective least regrets transmission upgrades to, among other things, achieve future system requirements and to maintain reliability. Is that a reasonable paraphrase of that, the new language that was added?
Yes.
Mr. Metz, you are currently participating in the CTPC process in some capacity, are you not?
That is correct.
And would you agree that the CTPC is currently considering benefit categories that are appropriate for consideration in the various study processes?
Yes.
And with regard to the statement in this stipulation regarding least regrets planning, would you agree that the phrase least regrets has a temporal element to it? Meaning that you're looking to anticipate future contingencies or changes in events?
That would be a fair characterization. I look at least regrets to say at some point in time, in order to implement a generation plan, we need to evaluate the transmission system. With carbon constraint, without carbon constraint, we're still seeing renewable generation resources and as well as thermal generation resources being implemented into the plan. So the extent that the transmission system is becoming constrained, I think it is who of us to start looking ahead and projecting of where those potential pinch points may be in order to maintain system reliability. Doesn't necessarily mean that we have to act on that plan. It just so we at least start identifying that plan to start having that conversation so we don't get caught off guard.
Thank you. I agree. And so by formalizing that least regrets plan, you base it on the best information available about what could happen in the future. Is that correct?
Correct.
So, for example, the public staff today, I assume you were thinking about contingencies such as changes in load forecast if large economic projects were not to materialize in North Carolina. Is that correct?
That would be one item of consideration, yes.
And would you also be considering contingencies such as if a jurisdiction declined to pay for specific policy-driven costs?
That would be an element of that could be a element in the MVST study, yes.
Have you seen the partial stipulation that was entered into by SIGFR and NCMC that was filed yesterday, July 29th in this proceeding?
I'm generally aware of it. I've seen it. I don't know. I haven't memorized it.
Presiding Commissioner Kemerite, if it would be appropriate, I'd like to have an exhibit identified as a cross-examination exhibit.
Please proceed, Mr. Hodge.
This document was not, I'm sorry, Mr. Direct.
If I could, may I ask a question just to clarify what this document is?
Go ahead, Mr. Jarrett.
Are you seeking to enter the stipulation in the record at this time?
The partial stipulation between SIGFR and NCMC, yes.
Okay. We do object to that, so at the appropriate time, I'd like to be heard on that matter.
So, Mr. Dodge, go ahead and identify the document, and then we will hear from Mr. Dirac in regard to his objection.
All right, thank you. The document was not included in NCMC's original list of potential cross-examination exhibits, but we do have copies available that we'll distribute to the parties. This is the agreement partial stipulation of settlement between SIGFR 2 and 3 and NCMC that was dated July 29th, 2024. And I would ask that it be identified as NCMC, Lawrence, Metz, Thomas, Direct and Settlement Cross Exhibit number 1.
You'll be so marked, and you may pass out the stipulation.
And for clarity, I would note the document is pre-marked as SIG for potential cross exhibit number 102, but I'm using those copies here. This would be re-identified as indicated.
So, Mr. Dodge, the document shall be so marked. And Mr. Direct, did you want to make an objection?
I would.
Okay, please go ahead.
Okay. Thank you, Presiding Commissioner Kimwright. We do want to briefly address the evidentiary, procedural, and practical objections we're going to raise to the admission of this settlement in the record. For context here, I think it would be helpful for the Commission to be aware, to the extent they're not already are, that this stipulation was filed yesterday on in the docket, and there was a similar stipulation entered in the docket on 7/25 involving a number of other parties, and we would raise the same set of objections to that stipulation entering the record as well when that time comes in the proceeding. So our comments on these issues relate to both stipulations to the extent that they are attempted to be entered in the record. So, and I'll be as brief as I can here, but it's a relatively complex issue here to consider. So I want to briefly address, again, evidentiary, procedural, and practical concerns we have about this. So start with evidentiary perspective on this. Our perspective would be this is not a settlement and therefore not relevant evidence in this proceeding. First of all, it does not involve the applicant in this proceeding. That would be Duke Energy, who has the burden of proof. And there's no precedent that we can find for this sort of stipulation being entered in the record in a contested evidentiary proceeding that does not involve the applicant. There's other states have held similarly that a settlement agreement that is not relevant evidence to be admitted in the record when it does not resolve any of the issues before the Commission because it does not involve an applicant to the case. I would say then, moving beyond just the plain fact that it does not involve Duke Energy, I think our perspective on these settlements, when you look at them in detail, you will find, I believe, that they don't represent meaningful compromises of position in this case. I think the core of a settlement agreement should involve compromises where parties have compromised on contested issues where there were disputes between parties. And I don't believe when you study these stipulations, you'll find any meaningful compromise. As evidence of that, I think, as best as we can tell from documents submitted in this case, there was really no plans for cross-examination amongst the parties on these issues. So I think that provides evidence there were not meaningful contested issues settled by these settlements. And taking that a step further, I'd say it's not really clear that these constitute valid agreements without valid consideration because there is no compromise of disputed issues. Two other core procedural substantive points we would make then. This Commission considered in the rulemaking process the request of parties to be offered a surrebuttal opportunity or to file rebuttal testimony along with Duke. And in that rulemaking, the Commission very clearly found that Duke, as the applicant in these cases with a burden of proof, is the only party with the rebuttal opportunity. Practically speaking, I think these stipulations could also be read to be prohibited rebuttal or really surrebuttal testimony in this case. And so we would argue that's sort of contrary to the findings of the Commission in the rulemaking. And this is particularly, I think, noteworthy as it relates to the NCEMC settlement that Mr. Dodge is seeking to introduce here, because That settlement includes much more detailed recommendations with respect to the proposals on the table, all of which could have been inserted in their testimony, but were not. And so I think particularly noteworthy in the case of NCMC stipulation, we see an attempt to introduce effectively rebuttal testimony, introducing new proposals into the case at a late stage in the proceeding. And then moving on to procedural efficiency and fairness, I'd say that from Duke's perspective, in addition to concerns we've articulated here with respect to evidentiary issues, we'd say it's generally unfair to the applicant to be called upon to review and assess these one-sided stipulations without Duke Energy in the middle of the evidentiary proceeding. It puts quite a burden on our witnesses to assess these stipulations, decide how and when to respond to them, prepare to respond to them. And furthermore, as I sort of mentioned earlier, it's not really clear that these stipulations are resolving contested issues and therefore meaningfully contributing to a more efficient proceeding in this case. Certainly, there are multiple other ways these parties could have introduced joint positions on these issues. They could have elected to file joint testimony, as other parties in this case did. They could certainly file joint post-hearing briefs and orders, but to submit this new perspective, new evidence or attempt to submit this new evidence in the record, we would not agree with. And so I think from our perspective, I think the commission should think in detail about how and why the role that these stipulations might play in the case and whether in fact they're contributing to an increased efficiency. So for all these reasons, again, we would oppose the admission of this particular settlement into the evidentiary record, and would plan to also oppose similar evidentiary stipulations in the record to the extent that that is attempted. And then certainly ultimately, if the commission elects to allow these stipulations in the record, we would certainly reserve the right to comment on them in post-hearing briefs and make our arguments with respect to the appropriate characterization of these documents.
Thank you, Mr. Drack. And Mr. Dodge, do you care to respond? And in your response also, speak specifically to compliance with the procedural order and good cause for identifying this document at this late date.
Sure. Thank you, Presiding Commissioner. We acknowledge the short notice to all parties, but the document we believe reflects compromise discussions taking place in good faith between parties in this proceeding that are relevant to issues the commission is being asked to address. We did reach out, albeit on short notice, to Duke seeking feedback or interest on this, but recognizing that was not until the weekend prior, Sunday prior to filing this. So acknowledge the short notice there. Duke and other interveners in this proceeding are asking the commission to provide specific direction for issues considered by the Carolina Transmission Planning Collaborative, and we think it is relevant in this discussion. I would disagree with Mr. Jack's assertion that we did not plan to that we did not reserve cross-examination time for Duke witnesses or other witnesses. And I think both NCMC and SIGFR have reserved time and presented witnesses to address some of these issues we're raising. And generally, we acknowledge the commission is receptive to parties reaching settlements on issues with all parties, recognizing this is not a unanimous stipulation. And so we would recognize the commission would give due weight to a stipulation of this manner, recognizing the limited parties and its non-unanimous nature. With regard to your request regarding the procedural order the commission issued, again, this was a stipulation that was not finalized until yesterday morning for filing. We do apologize for the short notice. I would acknowledge that the proceeding in this case was continued for 3 days as a result of the first stipulation that was entered, and then a second stipulation was entered, amended stipulation of that same stipulation was filed by Duke and other parties on the 22nd, the original date this hearing was supposed to start. So this is not the only time that this is happening. In fact, in past cases, Duke has been party to settlements being filed with the commission during hearings, and in some cases even after that date. So I think we, again, recognizing the commission's order and how it laid out the request for us to amend adhere to that schedule. We do recognize it is short notice, but we still think it provides useful information and represents a reasonable compromise of issues between the two parties to the partial stipulation.
And Mr. Dodge, do you want to speak to Mr. Drax's argument that it is in fact not a stipulation or a settlement because the applicant or Duke Energy is not a party to the agreement? Did you want to speak to that?
I agree, recognize that Duke is not a party to the stipulation. As we indicated, we reached out to try to engage Duke on willingness to participate in this. However, we do believe there are issues that we have resolved and with our discussions and compromise negotiations with SIGFR that represent a compromise among intervening parties here.
Okay.
And Presiding Commissioner Kimmeray, if I may be heard as well, since this implicates SIGFR and SIGFR is a party to this stipulation, although frankly, I was not prepared to respond to Mr. Drax's oral argument here this afternoon. And so I'm not sure how brief I'll be able to be. Is now the appropriate time to?
Please go ahead and respond to the objection.
So in addition to the arguments made by counsel for NCEMC, I would just state that there's nothing in commission rules that require the applicant to be a party to a stipulation. In addition, there's case law in North Carolina that stands for the proposition that non-universal stipulations may be considered by the commission as it pertains to only a subset of parties and not all of the parties to a particular proceeding. The commission is authorized pursuant to that case law to accept those stipulations into evidence and to give them the weight that they are due, which this commission is absolutely capable of doing. In addition, I would just note that both NCEMC and SIGFR have witnesses who will be attending this hearing and appearing live before this commission and will be able to be cross-examined by the applicant or any other party to this docket. And to the extent that Duke is attempting to argue unfairness or burden in response to this late date, SIGFR would remind the companies that, as Mr. Dodge mentioned, their amended stipulation came at the 11th hour on the eve of this hearing as well, and put all other parties in quite a precarious position. And understanding that the commission then delayed the hearing by 2.5 days, it still caused great consternation among other parties, especially SIGFR, with respect to its preparation for this hearing. And so to the extent that the companies are trying to make that argument here about a much narrower stipulation that pertains to a single discrete issue as opposed to a few dozen pages worth of resolving almost all issues between the public staff and Duke, we would respond, that's a disingenuous argument under the circumstances. It does not constitute SIR rebuttal and in fact is simply a stipulation agreeing on positions that do not fully reflect the positions as filed by NCEMC and SIGFR. So there is compromise reflected in this stipulation. And again, the issues that are resolved in the stipulation are not reflective of either party's complete position. And so we would disagree with the assertion that there was no meaningful compromise as between the parties. There was no meaningful negotiation. There was, and again, I think most of Mr. Dirac arguments are, essentially attempting to deprive the commission of the ability to give this evidence the way that it's due, which at the end of the day, I think it comes back to the commission is able to give this stipulation the weight that it's due. And Mr. Dirac is going to be unable to cite to any commission rule or case law standing for the proposition that this stipulation should not be accepted into evidence. And so for those reasons, SIGFR would request that Mr. Dirac's objection be overruled and that this stipulation be allowed. Thank you.
Okay. So, Mr. Dodge, can you explain what the contested issue that has been resolved in the stipulation for the benefit of the commission that has not seen this document?
Thank Thank you, Presiding Commissioner. So paragraph 6 is the bulk of the discussion with regard to the stipulation and the terms that are being reached here. The goal expressed in this represents interest from the perspective of NCMC, a wholesale customer of Duke, and SIGFR representing large industrial customers in the state with regard to transparency and information. The information that would be elicited from this type of information may not necessarily be reflective of favorable outcomes for either of our parties, but what we did agree on in providing this information was it improved transparency of the process. And so I think the compromise is increasing the transparency. The disagreement may be over the fact that what that transparency provides may have different implications for our members.
And Mr. Dodge and Ms. Kress, if the commission were to determine that this agreement does not constitute a settlement or a stipulation among the parties, explain how the commission should consider the evidence and how it would not be and how the applicant would not be in any way adversely affected by evidence that is presented at this stage of the proceeding if it is not in fact a settlement or a stipulation, because we want to have an orderly understanding and presentation of evidence. So in what way could it be considered if it is not a stipulation or a settlement and not interfere with our orderly consideration of evidence?
Thank you, Presiding Commissioner. I again just note we recognize the Commission has the ability to give due consideration or due weight to the non-unanimous stipulation such as this. I think we think that this, again, while the Commission provides a procedural order and it expects parties to adhere to that to the greatest extent possible, there are always deviations from that. We've pointed to a couple in this proceeding already where there have been settlements reached, other documents that have been provided outside of that procedural order. The Commission acknowledged there may be some extenuating circumstances where other matters could be considered. This is a late developing document, but we do still believe it provides some value for the Commission to give weight to. As Mr. Jurack noted, these are issues that could also be addressed in post-hearing briefs and other matters as well. But we wanted to try to provide this to the Commission prior to NCMC and SIGFR presenting witnesses that could be available to answer questions the Commission may have about this. So to provide the Commission an opportunity and other parties to evaluate it when we have witnesses to present on it.
Okay, Ms. Kress, I see that you want to be heard, and I think specifically what I'd like to know is that if the Commission were to determine that it does not constitute a stipulation or settlement, how should this be considered as evidence? On what grounds is it evidence for the Commission to consider?
Well, thank you for the question. And I believe that we are still in the cross-examination stage of this proceeding. And I think that at a bare minimum, it reflects alignment that was able to be reached between two parties whose positions would otherwise not be identical to what you see in this document in front of you. And to that extent, it's relevant evidence and would be properly before any witness that testified to RZEP or multi-value strategic transmission planning for them to comment upon and respond to. And I would just note, as an additional matter, I emailed counsel for all parties on July 26th, asking if there would be any objection to moving the other partial stipulation into evidence. And counsel for Duke did not respond, indicating that there would be an objection. So the fact that there is even this objection is news to at least counsel for SIGFR.
Okay, so I think Mr. Jurack, did you want to quickly respond?
May I just have 2 or 3 minutes to respond to a few of those points? First, I'll begin by saying, obviously, our thinking on this has taken some time. We've been in the middle of an evidentiary hearing, so receiving this information, deciding what our strategy is, has taken some time, and it's also been informed by this additional settlement that came in. To the question of what contested issue is being resolved, Mr. Dodge pointed to paragraph 6, but he never articulated in what ways that issue was ever a contested issue specifically as between NCEMC and SIGFR. So I would still reiterate our perspective that no disputed issue has been resolved. I would also urge you to look at the entirety of the stipulation and ask yourselves whether there's a lot of extraneous information, quotes to orders that have no bearing on a stipulation, if this is one, which again emphasizes our view that this is really surrebuttal testimony in many respects. And I would speak to the comprehensive settlement that Duke Energy was able to achieve and enter in this record, and contrast a couple key points. First, in terms of timing, right? If NCEMC and SIGFR filed testimony on May 28th in this proceeding, to the extent they believe there was a dispute or alignment or potential for something to be done, they've had a long runway to do that. In contrast, we, Duke Energy, filed our rebuttal testimony in this case on July 2nd and immediately worked very hard to get a settlement done in this case, working as collaboratively and constructively with all parties as we could. And we're able to get a comprehensive settlement done. And so while, yes, it was filed close in time to the start of the evidentiary proceeding, obviously it was filed before the start of the evidentiary proceeding. But more practically, there was realistic timing constraints on our ability to get that comprehensive settlement done that caused it to move close in time to the settlement. To the start of the evidentiary hearing. But again, we would say that timing was reasonable given the procedural scheduling order. And then I'll obviously also point out that our settlement is comprehensive and covers nearly the entirety of the case in terms of the near-term execution plan. And so that also contributed to the efforts there. And again, resolve clear issues of dispute as between the company and public staff that were very well set forth in direct testimony and rebuttal testimony. So in that respect, I don't think that's really a valid comparison at all. And then finally, I would acknowledge that, yes, this commission has precedent that suggests they will consider and give appropriate weight to non-unanimous settlements. But to our knowledge, we haven't found any of those instances involving a contested evidentiary proceeding and a non-unanimous stipulation that did not involve the applicant to the case. So that's.
Thank you, Mr. Drack. And one last question for Mr. Dodge. Mr. Drack has just argued that the stipulation does not resolve a contested issue between NCEMC and SIGFR. Can you respond to that?
Yes, Presiding Commissioner. I think in NCEMC witness Ragsdale's testimony, as well as NCEMC witness Amadou Fall's testimony, we have presented information and concerns regarding the costs and the transparency associated with transmission upgrades and things along those lines. There are perspectives as I said, as a North Carolina wholesale customer that we think are important to be considered here. I can't speak for SIGFR's witnesses as to the positions that they put forth with regard to these costs, but the implications of our positions don't necessarily align on those issues. And so while we did not have an opportunity to file testimony and rebuttal testimony and respond to each other's points as clearly as Duke and the public staff or other Duke and other interveners may have had in this, the points of difference that were raised in the initial testimony, I think provided us with a framework to try to resolve where there were differences and that we thought would provide a meaningful compromise for the commission and others to consider.
Okay. Ms. Cressa, do you want to say something very briefly?
Yes, very briefly, just taking a step back, I would just note that, again, we're talking about retail customers versus wholesale customers. There is an inherent cost allocation difference of interest as between those two groups of customers. And so, I think this framework here contemplates very much that one of those parties, perhaps both of those parties, won't be happy with the outcome of the discussions that are envisioned by this stipulation. And so I do think fundamentally there are different interests being represented here, and there is a fundamental divergence as between those pecuniary interests.
Okay.
Thank you.
And thank you to Duke, NCMC, and SIGFR for your arguments. I will take the objection under advisement and will provide the commission's ruling when we come back after the lunch break. So we will we'll break for lunch and come back at 1:45 and go off the record now. Before we continue with cross-examination from Mr. Dodge and NC EMC to the panel, I want to rule upon Duke's objection. So I am going to sustain Duke's objection to having the agreement and stipulation of partial settlement between North Carolina EMC and CPIRP identified as Exhibit 1 and introduced into the record. The basis for sustaining the objection is that the introduction of the agreement and stipulation of partial settlement does not comply with the procedure that the commission has established. And commission order denying the public staff's motion to expedite, I apologize, I have too many documents here. The commission's order establishing the procedure for the way that this hearing is to be conducted. In addition, North Carolina EMC and CPIRP have not provided good cause for providing a different procedure for providing an exhibit under cross-examination that did not comply with the commission's procedural rule. So on that basis, the Duke's objection has been sustained. You may proceed with your cross-examination, Mr. Dodge.
Thank you, Presiding Commissioner. I'll return to the public staff panel. And just as a reminder where we were talking about least regrets analysis and the provisions that were included in the amended stipulation calling for least regrets. Do you agree, would you agree with that an upfront perspective on costs, benefits, and cost allocation, even if only in general categories, would be informative to a least regrets analysis as part of a local planning process?
I was supposed to ask a question on a question, but apologies. Are we referring to the CPIRP modeling, or is your question in local planning process for tying back to local transmission planning? Apologies. Clarification.
So my specific question was the latter, the local transmission planning process and having an upfront perspective on cost benefits and cost allocation.
Increased transparency and looking at the overall cost and benefits is beneficial to all stakeholders in local transmission planning.
Thank you, Mr. Metz. My remaining questions are mostly directed to you, Mr. Metz, but Mr. Thomas or Mr. Lawrence, please feel free to join as well. Mr. Metz, I'm going to refer to your direct testimony that was filed with the commission. And I'm going to refer to the page numbers for the corrected version that was filed on July 24th. You have a copy of your testimony with you?
Yes, I do.
All right. So starting first on page 10, you state that the commission should not approve the proposed RZEP 2.0 projects in this proceeding. Do you not?
Do you have the line number by chance?
Let's see, check the number. It's right at the bottom of the page here on page 10, sorry.
Okay, yep, I'm there.
It's underlined if that's helpful.
Yes.
Statement's underlined.
On page 10, the commission should not approve the proposed Red Zone 2.0 projects at this time as requested by Bowman Exhibit 1, request for relief.
And I appreciate your being forthright here, not using the approve versus acknowledge distinction that we've been talking about here so far in this proceeding. Can you next turn to page 66? And then are you at that page?
Yes.
All right. And in the first Q&A on that page, and I'm paraphrasing a bit here, but you state that your primary concern is that the RZEP projects were identified in reaction to interconnection requests, and that now I'm quoting from lines 8 through 10, there has been no formal study or cost analysis to demonstrate that those proposed upgrades are least cost or leverage the most system benefits for all customers. Is that correct?
That is correct. Part of our discovery investigation for the Red Zone 2.0 projects, we asked for additional transmission analysis to further identify the need and reasonableness of the plan, but the analysis was not completed.
And turning to page 68, in response to the question on that page, are the proposed initial and first supplemental RZEP projects reliability driven? You responded no. Is that still your current understanding?
Yes, generally that they are not right now, triggering a TPO, 001 impact. However, the only thing that I do start to identify to on one of the projects, the Lewisville to Oakboro, if you include the additional transmission upgrade that was listed in Duke Witness Roberts' rebuttal testimony, there may be a reliability concern of the need to allow for more power flows from east to west.
Thank you. There's been a fair amount of discussion already in this proceeding regarding the cost benefit analysis that Duke completed regarding the RZEP 2.0 projects. Are you familiar with that cost benefit analysis?
Yes.
And you discussed it a bit in your testimony on page 68 as well. On line 6 through 10, are you at that page? Should turn there.
Yes.
All right. You state that the cost benefit analysis scores should be used for directional purposes rather than considered absolute, do you not?
That is correct.
Were you in the room yesterday when Mr. Roberts, on behalf of Duke, was responding to questions on commission questions?
Yes.
And do you think it's possible for other transmission upgrades on Duke's system to have higher cost benefit analysis scores than these RZEP projects using the asset replacement model?
I think it is possible. However, outside alternative analysis is impossible to determine.
Now back to your testimony on page 73. On lines 15 through 19, you state that some of the projects identified may be generally reasonable projects to pursue through the traditional transmission process. Is that correct?
That is correct.
And by traditional transmission process, you mean not as a public policy project or MVST, but potentially as a reliability or economic project. Is that correct?
That is correct through the local transmission planning forum.
All right. And then I'll start wrapping up here. As I wrap up, I want to talk to you a little bit about equity, the word equities. Subject to check, would you agree that you use the word equity 8 times in your testimony?
Subject to check.
And you use the term equitable 6 times?
Subject to check.
Right. And your testimony is 170 plus pages, so 14 times may not be that significant, but would you consider this still a core element in your testimony?
Yes, the overall equity and impacts individual ratepayers for these investments in longer term planning is a core element of my testimony.
And this is a theme that you've carried forward from the testimony of Public Staff Witness McClawhorn in the 22 carbon plan proceeding, is it not?
Generally, yes.
And I don't want to go through each of the references to those words, but I do want to highlight a couple of specific references. On page 72, if you want to turn there.
Okay.
You state on lines 4 through 8, one additional item to address is that of ratepayer equity. If transmission upgrades are built and costs are assigned to DEP ratepayers to provide energy benefits to DEC ratepayers, DEP ratepayers will be unfairly burdened, or in some case continue to be burdened with those transmission costs. Is that correct?
That is correct. For example, when you're looking at the overall needs of the system and how the Encompass model is being constructed and dispatched, to the extent if we're importing energy if DEC is importing energy from DEP East, where large amounts of carbon-free or reduced carbon generations resources are needed, that's creating an equity issue on multiple facets, but one is the transmission system. So for example, let's just say theoretically we were to build 2,200 megawatts of offshore wind, and that would trigger a nominal hypothetical $1 billion transmission upgrade. If that same amount of energy on either the hourly profile or equivalent is being transferred over to DEC, those costs for that $1 billion transmission upgrade is sitting on DEP's ratepayers' books. DEP ratepayers would be paying for that transmission in this hypothetical or energy that is but needed for DEC.
Thank you. And on page 140, so jumping towards the back of your testimony now. Starting on line 11, you discussed the difference in environmental impact and state that this trend suggests that DEC's strategy relies in part on DEP's generation assets to achieve total CO2 reductions, highlighting a potential equity issue in the distribution of environmental efforts and costs between the two utilities. Is that correct?
That is correct.
Right. And then the last example on page 145. And in that, there's a series of pages here, but I've just referred to one quote here. The last line on page 145, you state the following, and this is in a broader context of rate disparity and cost causation principles, but you state, it is essential that you, or excuse me, I'm reading that wrong. Costs related to such transfers are managed, no, I apologize, let me start over. It is essential that costs related to such transfers are managed equitably to ensure that no single group of ratepayers bears a share of the cost to serve another group of customers. Do you see that statement?
Yes.
Right. Now, in this last sentence, you use both ratepayers and customers in that sentence. Do you use those terms interchangeably?
I do use those terms interchangeably.
I would note in some cases in your testimony, you do distinguish between customers as retail and wholesale customers, do you not?
That is correct.
And would you agree that the equity concerns that you raised are not just limited to ratepayers, i.e. retail customers, but are also applicable to both retail and wholesale customers?
Yes, notably, specifically, transmission would have much more impact to wholesale customers.
Thanks. No further questions.
Thank you, Mr. Dodge. And now cross-examination from NCSEA.
Thank you, Presiding Commissioner Kemmerite. Justin Simulowski on behalf of NCSEA. Mr. Lawrence, that binder in front of you, can you please flip to tab 11? And once you get to tab 11, can you please go to page 53? Tab 11, for the record, should be a copy of the company's supplemental planning analysis.
Okay, I'm there.
Thank you, Mr. Lawrence. And Mr. Lawrence, the third full paragraph.
Before you ask any questions, do you want to go ahead and identify the exhibit?
Presiding Commissioner Kemmerite, I believe the supplemental planning analysis is already in the record, so I don't believe I need to identify it as an exhibit. This is just there for reference, assuming they didn't have a copy in front of them.
Okay, and which exhibit has it been entered into the record for?
This is NCSEA's potential cross exhibit, tab 11.
Tab 11. You may proceed.
Okay, thank you. Mr. Lawrence, the third full paragraph, can you confirm that I'm reading it correctly? It reads, the companies intend to engage interested stakeholders, including the wind energy area lessees, in providing input on the development of the RFE. The results of the ARFI would then be presented to the commissioners once completed to facilitate the consideration of further action. In parallel, the companies will continue limited early project development and engineering work on the related transmission while not taking definitive actions prematurely.
That is what this says.
Great, thank you. I just wanted to ground our discussion in that quote. If you could please now go to the amended agreement and stipulation of settlement, please.
Okay, I have that in front of me. Is there a specific
Great.
place?
Thank you. And Mr. Lawrence and Mr. Thomas, it might be more appropriate since you supported the testimony on the settlement, if you want to take these questions. Paragraphs 27 to 34 relate to the initial development of offshore wind, correct?
Yes.
And those paragraphs primarily outline the stipulated to ARFI, correct?
Yes.
None of the potential market participants in this proceeding are parties to the settlement agreement, correct?
That is correct.
So therefore,
I don't know their position on this stipulation. There's a lot in the stipulation that they may have objected to, but I don't personally know the market participants' view of this particular portion of the stipulation.
okay. But being that they're not signatories, it is fair to say that this ARFI is something being served to the market participants inside of something being developed and agreed to by market participants.
I think they're not signing on to the stipulation again might reflect other parts of the stipulation that they don't agree with, and therefore they didn't want to sign on to this comprehensive stipulation. But if you're trying to tell me that they don't agree, I haven't seen anything or gotten any feedback from them, particularly on this.
And the only thing I would add is item 28 is the stipulating of parties agree that the RFP should request. So we're not mandating that the developers provide information. We can only request the information. If we request it and we do all this work at the RFP and the offshore wind developers, whatever reason, don't want to participate for their, where they can articulate, then that may be the result of this process.
Thank you. So, Mr. Metz, understanding paragraph 28 is a request for that information. Paragraph 28 does read, the stipulating parties agree that the ARFI should request binding information to the greatest extent possible based on the procurement between 800 and 1100 megawatts for commercial operation by 2034 and 2200 megawatts and 2400 megawatts by 2035, subject to further conditions below. Correct?
That is correct. Emphasis on that it should request.
Yep. And if the wind energy area lessees take up the option to provide this information, who is this provision binding on?
Is this reflecting for?
I think that this provision is certainly binding on the stipulating parties, right? So it's going to require Duke to issue this RFP and hopefully elicit serious and thoughtful bids from the offshore wind developers and the holders of the WEAs. When we say binding information, I think what we are trying to get at here is we want the information presented in the RFP to, as closely as possible, look like potential prices and contractual arrangements that we might actually see if and when these resources are actually procured. So we want these developers to make a concerted effort to account for potential future inflation, potential other risks, so that when we get those bids, we have a modicum of comfort that they are pretty in line with the actual procurement costs that we would see should we move forward.
Thank you, Mr. Thomas. And I think this leads me to one of my questions, because listening to your testimony and Mr. Lawrence's testimony this morning from cross-examination from counsel for Avangrid, it seems like there's a conflation of what a request for information is and what a request for procurement. Because Mr. Thomas, you described it as wanting to accrue information to improve modeling inputs. And I heard Mr. Lawrence describe it as a bid that is bound and starts a procurement process. Is that an accurate representation of that conversation that happened this morning?
Yes, I believe so, but I don't believe it can be only one or the other, right? I think that this is going to elicit information, not just what is the dollar amount per kilowatt, but things like what kind of contractual structures might you like, what kind of ownership arrangements, how do we split development costs, or how do we, ensure that there's a runway? So there's a lot that I think the RFP will kind of take in. It'll be more than I think was taken in the DNV study from the last one, but I think the point is that information would come in, we'd have a track towards actionable plan of executable actions in the RFP docket. And then at the same time, right, in the next CPIRP, information we receive here will help inform that modeling effort. So maybe the first available date might have shifted. Maybe there might be additional costs that aren't reflected in the model, or more information that developers have that can help ensure that not only are we evaluating these on a potential pathway to procurement in a robust manner, but also that we're updating and continually updating our CPIRP modeling with the most up-to-date information we have on this resource.
Thank you. And understanding that can all feed into updated pricing and how that will flow through the Encompass modeling produced by the companies and potentially other parties in futures IRP proceedings. But is there different information for collecting information for bid than collecting information for modeling input?
I mean, I think there'll be all types of different constructs. You can call it non-binding requests for proposals, non-binding requests for information, binding. I mean, you can pretty much come up with an acronym to tease out different levels of information. You call it negotiations of contract structures. But I'm not hung up on the terminology in RFP. We've laid out an intent through the settlement on exactly the actual items that we want to create. Following out of the RFP, to the extent that the resource is still selected and all the conditions listed herein, there will more likely probably be the acronym more familiar with is a request for proposal, where the terms and conditions on a multi-billion-dollar asset will be extensively worked on and negotiated on between the parties.
And I would just echo Mr. Metz's comment about not getting too caught up in the acronym used, the ARFI, RFP, whatever you want to call it. We've laid out the the steps here, and we'll have the two dockets. Our expectations will have the two dockets where the results of this ARFI will inform the modeling process in the next carbon plan. It's not to, it kind of serves both purposes at the same time. And it doesn't really make sense not to, because we have the information that we expect to get from this process. We also expect that to be used in in our planning in the next CPIRP proceeding.
Okay, thank you. I'm going to move forward other provisions in the stipulation at this point, but appreciate your answers. Can we now look at paragraph 29, please? And paragraph 29 reads, the stipulating parties agree to request that the commission establish a new docket to receive reports from the companies regarding the ARFI, and the companies agree to engage an independent evaluator to support the ARFI, correct?
Yes.
And would it not be appropriate that the stakeholders bound to provide the most accurate information to the greatest extent possible have input on the independent evaluator that will be evaluating and interpreting the information they share?
So you're asking if the market participants should be able to have input in the selection of the specific independent evaluator? I don't know. That's a good question. I think that an independent evaluator is supposed to be there to essentially make sure that the information is being handled in a equitable fashion between the different market participants, that the bids are being are realistic, right? Are not making assumptions that are unrealistic, and that the final report to the commission reflects the realities of the information that is procured. I think we've seen IEs selected in solar procurements, the ongoing solar procurements, as well as the 2022 carbon plans, offshore wind information request. So I'm not so sure that there needs to be market participant input on the independent evaluator, but certainly I would, not object to hearing from market participants on that matter. And certainly if the commission wanted to establish a docket in this document, request comments on potential independent evaluators, that they have that right.
Thank you. Can we take a brief detour still in the amended stipulation? Can we go to paragraph 46, please? The first sentence reads, the stipulating parties agree to retain a consultant to be selected by the companies with input from the public staff. Why does the public staff feel the need to have input on the companies selecting that consultant?
Well, I think that offshore wind, RFE, just called the offshore wind RFE is certainly a different animal than this kind of more detailed cost benefit analysis of the Energy Infrastructure Reinvestment Act. And this was a program that we feel has as detailed in our testimony and has some potential to save ratepayers dollars, and talked earlier about getting every available federal dollar that we can to reduce costs for ratepayers. And so in this particular, very cost recovery, cost of capital kind of proceeding with this consultant, we felt just the need to be closely involved in this selection of the IE, and then working with the IE. I think in here it's even, we're going to be in every meeting and we're going to be on correspondence, right? We want to be deeply involved in this effort to get federal funds to reduce costs of this transition plan to ratepayers. I think that stands a little bit different. It's a different structure, different organization than the RFI for offshore wind. That's part of the reason why we focus more on, I wouldn't say we exclude the market participants from RFI. I think we just looked at this and said, we really want to be deeply involved in this because, we said in not only this proceeding, but in multiple proceedings, we really need to get all of that federal money we can. We need to do everything we can. And the public staff is kind of taking a particular interest in this program.
So the public staff just wants to make sure that the details and the information are accurately represented and have a eyes on that process.
I believe that in this particular instance, when we're talking about federal funds from the government, this is a big part of our role, right? We're here to ensure that the cost that ratepayers pay for electrical service is reasonable and that we have taken advantage of every funding opportunity that we possibly can. And so, yes, we feel that this particular, our involvement with the consultant in this instance is an important factor.
But it's possible that the offshore wind developers would also appreciate that their details and their numbers for their business are also accurately represented. And if they are able to help an independent evaluator, it could help be a more transparent process.
Yes, I would agree, although I would also note that I have not heard or heard from any offshore wind developer or read any testimony that suggested that I believe DNV is the IE for that the existing RFI independent evaluator did not do a good job or did not thoroughly consider their concerns. I mean, in any sort of RFI, we expect that there's going to be communication and participation, stakeholder meetings, to discuss the structure of the RFI. It's not going to be developed, I believe, completely in a black box and then issued. I expect that there will be input from wind energy area lease owners in kind of working through the RFI details.
Okay. Thank you. Moving to paragraph 30. The stipulating part, paragraph 30 reads, the stipulating parties agree that the proposed ARFI shall incorporate an asset acquisition reference price. The asset acquisition reference price shall be developed by the companies in consultation with the public staff and IE and will not be shared with market participants. The asset acquisition reference price shall be the maximum price at which offshore wind is economically selected by the company's modeling, reviewed by the public staff and the IE, inclusive of all costs, including but not limited to the costs to bring the generation to shore and build required inland transmission upgrades. Correct?
Yes.
Would that reference price on its face be deemed reasonable?
In what manner?
Well, would interested stakeholders and market participants have an opportunity to question whether that reference price is reasonable and represents a fair price?
So I think I've identified earlier, there is some concerns if we make the reference price public to the market, then the market would say, oh, I have a ceiling that I can now get and make sure my project is selected. That we would like to encourage competitive marketplace for the potential transfer of these projects or however the project is ultimately developed. And that's why we believe it's not appropriate to share that with market participants.
And if I could add too, I mean, this is not the first time that we've proposed to use some modeling inputs and modeling findings in an RFP. The 2022, 2023, and I believe the 2024 RFP all have or are considering a volume adjustment mechanism, which utilizes a reference price. Basically, what is the price of solar within the model? And that reference price is then used to potentially adjust the RFP target up or down based on that price. So it's something we've done before. We've taken a modeling cost and we've used it in RFP, and this is simply an extension of that to say we're going to do essentially the same thing in order to understand at what is that break point at which offshore wind just isn't a cost-effective resource.
But again, just to differentiate, in terms of the reference price, quote, determining the maximum price at which offshore wind is economically selected by the company's modeling, would that not be something that should be discoverable by the offshore wind companies in the future carbon plan IRP proceedings?
So taking a step back, the future carbon plan proceedings will use a desensitized value for purposes of the resource planning. So to the extent that the developers or individuals who seek information through discovery should be able to ascertain certain aspects of that price. Correct, if I can restate, be able to see inputs into the model and how the model was selected and the price assumptions used in that model.
Mr. Thomas, you said something this morning that I also want to just follow up on. In reference to the reference price, you said you referred to it as something as reasonably close. That's not what the stipulation says, though. Stipulation says at or below the reference price to being a viable project.
Yeah, I'm trying to remember the exact context, which I said reasonably close, but yeah, no, the stipulation is if those costs are below the reference price, then we would, expect to see that plan and that development effort and those actionable items.
So the public staff is not envisioning a opportunity where a project bid into this AR5 could be just above the reference price in a zone of reasonableness or something like that. That's not going to be eligible to be selected.
I mean, I think we're going to be involved with the IE, and obviously there's a lot of uncertainty. If there's a bid that comes in and it's 1 penny above the reference price, I think we would discuss this with Duke and the IE and see what we feel is reasonable, or, and the stipulation says what it says, but I think, we're going to look at this very closely. My hope is, seeing as offshore wind is being selected in some model runs, my hope is that if you continually increase that price until it's no longer selected, that will give the offshore wind developers some headroom, as it were, to ensure that they can bid in, and they'll bid their most competitive bid, and presumably then we'll see that below the reference price. I think this trigger is really just for us to make sure, look, at this price, the model's not even wanting it, the model's not selecting it. If you're above that price, if you're well above that price in particular, there's no way that you're part of the least cost plan because the model's not selecting you.
And if I can add on that, another reason to potentially, to identify this pivot point is when we move into the next CPIRP, and if offshore wind is not being economically selected, we would need to run additional analysis to start identifying that shortfall and whether or not we need to start taking different actions on either long-term or mid-term capacity and energy resources to supplement that shortfall.
Right. And so this RFP here is not necessarily the final result. If a bid, or if no bid comes in at the correct price to be selected through this process, we still have our carbon plan proceeding in 2025. In this case, we saw a significant amount of load increase between the initial filing and the SPA. We don't know between now and the time of the filing of the next carbon plan proceeding by Duke that what that's going to look like. So, that process will also help to inform as well. It's not going to be siloed out into the two separate dockets. We'll have to look at the conditions that exist at that time, and so this language also looks to reflect that what might be or what will be the reality at that time that we can't predict now.
So leading to my next question then, if no project comes in below the reference price, would we have to reproduce this ARFI prior to every carbon plan cycle? Will this actually end the cyclical nature of this process?
Well, just as an initial matter, if we talked earlier about how the results of this RFP will both inform the potential procurement and actionable items within the RFP docket, and also because of the timing that we've worked out, feed into the 2023 or the 2025 CPIRP. If we get a bunch of bids from the wind developers that are way above the reference price, and then we turn around and we kind of feed an amalgamation of that protecting commercially sensitive information into the 2025 CPIRP, my expectation would be that the model would not select offshore wind because it is above that price at which it would have been triggered. And in that case, if we're coming back next year and we have a CPIRP that is using these higher prices from the RFP and it's not selecting offshore wind, then no, I don't think we'll be having this conversation because we won't be arguing to select, or we won't be arguing to move forward with offshore wind because it will have been demonstrated to not be part of the least cost plan. So I think that's why we've got to do this kind of both at once, right? We need to understand the prices that we're seeing, how reasonable they are, bring them in line with the actual prices that we see off the coast of North Carolina, which are, again, different resources than are in the Northeast, right? We can compare the North Carolina wind energy areas to the prices in the Northeast, but it's not an apples to apples, right? Because those are generally more productive assets and maybe closer to load centers, right on the coast. So it's a lot that we have to consider, and that's why we're kind of recommending this dual track, this RFP docket, and that's what the stipulation hopefully will lead us to.
So Mr. Thomas, can you clarify that if there's no selectable process at the conclusion of this ARFI, that offshore wind will not be reevaluated in future carbon plan IRPs?
Well, I imagine it will always be included as a resource, but the point being is that if it's above that, if the price is above the point at which it's being selected economically by the model is not going to select it. And presumably, if the model is not selecting offshore wind in Duke's portfolios next year, when we see the 2025 CPIRP, I imagine that their near-term action plan won't recommend procurement of it, won't recommend moving forward. And we'll learn more about this within the RFP docket. But again, that assumes that the bids that might come in during the RFI are significantly above, right, the reference price, which is itself going to be significantly above the actual price that's been used in this proceeding. So I think we just, don't know what will happen next year, but we'll have to watch some of this play out.
So Mr. Thomas, I'll take one more shot at clarifying this and then I'll move forward. So the reference price determined by this ARFI process is evergreen. There will be no revisiting and updating the reference price. It will not go stale.
So if I may, are you asking that once this reference price is set here through this ARFI, and now let's say we're in 2030, if we're still going to be looking at that same reference price that we would set in 2025?
Yes, that would be one scenario, yes.
I don't believe so. I believe it would be updated as necessary, through this a similar process that we're in here, and this whole process is cyclical. Every 2 years, this filing is going to be made with, as long as we have this current construct with that we have being this IRP process. So, we can't get away from that part of the cyclical process. And as long as there is a lease area available that is not contracted with any entity, we would evaluate it in, this IRP process.
And point of clarification, I think we're speaking in general terms. To Mr. Thomas's point, if we determine kind of like this max price and the offshore wind comes in higher than that, then from an economic standpoint, least cost, that energy capacity is going to be served by a lower cost resource. So one would say from a silo standpoint, at that snapshot in time, you wouldn't need to reevaluate it because it's already resolved. you would have to take a step back and say, okay, what is the mix of those energy capacity resources that solve that shortfall? Is it another long lead resource, say, for example, a AP 1000? And if we start taking actions towards that, that may start to push out an actual item for offshore wind in a future procurement. But back to Mr. Lawrence's point, each carbon plan with updated information will continue to include that in the overall analysis.
So thank you. Understanding that if an offshore wind project is above the reference price, there will be other resources to meet it. But would it be possible that we're looking at another 2027, another round with an independent evaluator, updating that reference price for the next carbon plan?
It is possible, but before I can't speculate, but so far on that, because I would need to see the results of this process. Not stating there could be lessons learned from this process that would drive improvement, which is no different than the solar RFPs that we've done that we continue to learn as we move forward.
And I would just add, I think if the intention is to ensure that offshore wind is developed no matter what, I understand that this process may represent a barrier. But what we are trying, because of the fickle nature of offshore wind, because it drifted in and out of the models, essentially that last resource that's being selected, it's borderline cost effective. Sometimes it is, sometimes it's not. Sometimes it's 1 gigawatt, sometimes it's 4. That has caused uncertainty for us, right? So that's why we tried to set this up. If the result of this process, and maybe I'm repeating myself, but if the result of this process is that offshore wind is below the reference price and part of lease costs and it's selected next year, then I think that this will likely lead to moving forward with joint development and setting an in-service date and working on that effort, spending dollars, right? But again, if it's not, if the price is too high, then it is not part of the lease cost plan. And that is what the statute requires. And if offshore wind is not included in that lease cost plan, if we can get there another way, then we need to be looking at that, even if it means not developing offshore wind. But I think that there's a lot of information that we need to get here, a lot of information we need to gather. I think I said this before, that if it weren't for that offshore wind being ductile, as Mr. Metz called it, we might not be having that conversation. If it was selected across all portfolios, Duke might have asked for an RFP instead, or we might have pushed for an RFP instead, but that didn't happen, and so here we are.
Thank you. Moving on to the latter half of paragraph 30, paragraph 30 on page 15. It reads, the companies will notify the commission of the results, and to the extent that the definitive pricing submitted within the AR5 results in projects that are at or below the asset acquisition price, the companies shall propose a plan to begin development efforts and a timeline of executable actions, or provide a detailed explanation for why development efforts or other executable actions should not be pursued and or should be delayed. As written, that provision gives the companies certain discretion on whether to develop a procurement plan or if they can explain why they're not developing a procurement plan, correct?
Yes, and we identified a lot of the reasons earlier in testimony on those factors that can go into that.
Right. So if there is a project, though, that does come in under the asset acquisition reference price, wouldn't it still be beneficial for the company to develop a procurement plan, even if they don't think now is the right time, so that when it is the right time, they can act on that plan quickly?
I can only add for the statement of the or the reason for my view on why that or is in there, from the establishment of that price to the extent until when we get to July is the timeline that Mr. Thomas laid out. Other events may transpire before Duke puts forward that plan. From my view, that was a reasonable effort to give Duke, who ultimately would be responsible for this when I looked at them for cost recovery. Other events may take place that may say, you know what, something changed and this is no longer a good deal for ratepayers.
But just to agree with Mr. Metz, but I think to put a finer point on our at initial glance, if we saw bids come in under the reference price, our initial expectation would probably be that, yes, Duke would propose these action items and provide them to the commission. It would have to be a very good reason that Duke would have to provide the commission to indicate why, even with these bids under the reference price, they were not willing to move forward with development activities. And at that point, within that RFI docket, I imagine that would be resolved within that RFI docket to evaluate whether Duke's efforts are reasonable or whether they need to take more aggressive action.
And it's the companies that shall propose a plan. It's not the companies and the project that came in under the asset acquisition reference price, correct? Wouldn't it be beneficial to have that be a collaborative process?
I can only add, for purposes of the settlement, is the reason that the language is in there, and because a market participant wasn't part of the settlement, I couldn't necessarily think it would be reasonable to bind them into the terminology here.
But yes, it would be reasonable for the companies to work with that particular bidder to develop a plan. I would not imagine they would do so in a vacuum.
Okay, but they don't have to by the written language.
The stipulation does not explicitly require a market participant to engage in those efforts. However, my understanding is that these developers are attempting to find an off-taker for their facility. So even though they may not be bound by the stipulation, I would expect that such a developer would want to be involved and would work with the IA and the companies to the extent necessary to provide a development efforts and a timeline of executable actions.
Thank you. When would the company need to make that statement of developing the plan or why they're not developing the plan? Would that be part of the July 30th, 2025 filing? Would that be in their near-term action plans at the carbon plan IRP? What are the parameters of timing for that?
I believe that that paragraph in the bottom of paragraph 30 is talking about notifying the commission of the results. And then paragraph 32 explicitly says the results of the RFE shall be filed no later than July 30th, 2025. So I'd expect that any actions following that would occur after that date, but that's when we would expect that report.
Okay, thank you. Don't want to be duplicative. I think you answered my other questions from earlier today. Thank you.
And before we move on to cross-examination from SACE, I was asked to provide some clarification about the order that I referenced in regard to my sustaining of Duke's objection to North Carolina EMC's Exhibit 1 that they proffered. And the procedural order that I referenced is the order delaying hearing until Wednesday, July 24, 2024 at 9:30 a.m. and providing additional procedures issued in docket number E-100 sub 190, issued on July 18th of 2024. And specifically reference the ordering paragraphs number 2 and number 4, and I will read a couple of the excerpts from ordering paragraphs number 2 and number 4. Ordering paragraph number 2, that to the extent that parties have potential cross-examination exhibits or potential redirect examination exhibits as part of the stipulation or the forthcoming support testimony, each party shall A, file updated versions of its previously filed exhibit indices of potential cross-examination exhibits and potential redirect examination exhibits, and B, provide electronic copies of the indices and new potential cross-examination and redirect examination exhibits to all parties and to the commission via email by no later than Monday, July 22nd, 2024. And then ordering paragraph number 4 states that the commission expects the parties to strictly adhere to its orders, instructing parties on the procedures for providing potential cross-examination exhibits and potential redirect examination exhibits. To the extent that extenuating circumstances require a party to seek to introduce a potential exhibit outside of the procedures established, that party shall seek leave for good cause from the presiding commissioner orally during the hearing and shall be prepared with a sufficient number of paper copies of the requested exhibit. And as I mentioned in my ruling, North Carolina EMC did not comply with the procedural order and also did not provide good cause for its noncompliance with the procedural order. That information is to provide clarification of the order. And with that, Mr. Neal, you may proceed with your cross-examination.
Thank you, Presiding Commissioner Kimmerite. I am David Neal for SACE et al. Good afternoon, gentlemen. I want to take us to resource adequacy and starting with Mr. Thomas. You reviewed Astrape's 2023 resource adequacy study as part of your work in this case, correct?
I did.
And at page 33 of your direct, lines 1 through 7, you provide a calculation of the increase in megawatts of firm capacity needed to meet the increase in winter planning reserve margin that results from the proposed 30% increase in that margin.
That's correct.
And you calculated that the proposed increase to a 22% winter planning reserve margin leads to an additional 1,115 megawatts of needed firm capacity in DEC and 806 megawatts of firm capacity in DEP, correct?
That's correct.
Now, both Duke's modeling and public staff's each plan on reaching that full proposed 22% winter planning reserve margin by 2031, correct?
That's correct.
You get there in different ways, though, isn't that right?
That's correct.
Okay. Now, as I heard it in a response to a question from counsel for EDF earlier today, did I hear you correctly testify that combined cycle plants were selected by the model because of coal plant retirements and increasing load growth?
I think I was speaking in the context of the EPA rule and pointing out that much of the new gas generation that is on the system that is selected economically by the model is used to supplant, to a large extent, existing coal and some existing gas because it is more cost effective, it is more efficient, and has lower carbon emission reductions. That doesn't mean that we turn off our old gas or old coal. It just means that they're utilized slightly less. More of the energy comes from the new combined cycles, but all of these categories of plants still provide capacity to the system and count towards the reserve margin.
So, well, would you agree that a combined cycle plant addition could also be, at least in part, informed by the increased firm capacity needed going to that increased winter planning reserve margin as coal plants are retiring?
I'm sorry, can you restate the question?
Sure. Just that, again, just not to put too fine a point on it, but that the increase in firm capacity that you've testified to as a result of increasing the winter planning reserve margin is another factor that could lead the model to select something like a combined cycle.
I mean, it could select a combined cycle. I think that the model is also selecting battery storage and solar plus storage and onshore wind to meet capacity needs. I think and combustion turbines as well. And I think it's hard to pinpoint any one resource and say, well, if we use a lower reserve margin, that specific resource wouldn't be selected. I think generally the reserve margin is met by a variety of resources.
Nevertheless, you would agree that Duke's P3 does include 1,360 megawatt combined cycle plant in 2031?
Yes, subject to check, I believe so.
Now, at page 34, lines 4 through 8, can you turn to that? And at the end of line 4, could you read that next sentence? Starts with the.
The public staff is concerned that declining generator reliability across the company's existing fleets is driving the need for a higher reserve margin, particularly given that recent winter weather improvements are not reflected in the data.
Now, you would agree that a driver of declining generator reliability that was captured in the company's resource adequacy study was included the declining performance of Duke's coal units. Correct?
Yes, and I summarized those in confidential table 2 of my testimony.
Yes, I was going to ask you about that in a minute. But first, Mr. Metz, turning to your testimony, if you wouldn't mind going to page 122 of your direct.
Okay.
And here, you testified that public staff has previously raised concerns with declining generator reliability from Duke's aging generation fleet. Do you see that testimony?
Yes.
And you would agree that the concerns you raise in this section of your testimony include Duke's aging coal fleet?
That is correct.
Could you read, starting at line 13 of page 122, where that sentence that starts, "I have observed," and carrying on down to the line 3 of the next page? And really, I was actually inviting you to read it to the commission, but I could.
Mine lines aren't matching up with what your statement is.
Well, I went to your corrected testimony to try to make sure I didn't run into this problem. And I'm happy to go to it. This is the, again, I went to the corrected.
I got it.
Okay, so I have observed trends.
Yes.
Okay, thank you.
I observed trends of the company's decreasing O&M spending in certain business groups of the generation fleets. And 2, the company's proposed reserve margin increase in this proceeding is not reflective of the additional projects and increased spending they have used to justify base rate increases in the MYRP proceedings.
And continuing on to, again, the rest of that paragraph.
The decrease in maintenance spending, including a reduction in craft employees, has likely contributed to the increase in outage rates and impacted the time it takes to make repairs as needed for the restoration of and/or improvement to system reliability, as also noted in public staff witness Thomas's testimony.
And I think there's just maybe 1 or 2 sentences left.
The company's actions to reduce O&M cost and reduce employee headcount may have inadvertently contributed to the need to increase the overall reserve margin. To quote an old adage, and sometimes they may have been a penny wise, but a pound foolish.
So as I read that testimony, it sounds like one of your concerns is that the concerns you've raised in previous dockets about reduced O&M for those aging, particularly again, the aging coal units, may be a contributing factor to what's identified here as a need to increase the winter planning reserve margin. Is that a fair summary?
Yes, that was a fair summary of my testimony.
Mr. Thomas, returning to you, would you agree that the public staff's concerns about declining generator reliability include the performance of coal units during Winter Storm Elliott?
Yes, I would say that because the generator availability data system, GADS data was inclusive of through the end of 2022, it did capture the performance of the company's fossil fleet in Winter Storm Elliott. But again, I did just want to point out that, certainly it is a concern of ours, right? We need to keep these plants running, right? We need to make sure that they're available for us at the winter morning when we need it. But at the same time, we also need to understand that those outages did happen, right? And if we aren't taking that into account, if we ignore that, we could see that same thing happen again. And in any case, I believe I testified that the increase in reserve margin associated with the outages, specifically the increased outage rate, cold weather outages, is I believe about 2.5%. But you can't take away all of that, right? So even if you tried to tease out what is the specific impact of Elliott, and let's say we resolved all those issues, we tracked down every inch of exposed pipe and ran heat traces through it, If you get rid of all of that Winter Storm Elliott failures, you still are going to have failures in cold weather. It's still going to happen. Even in a very, very perfectly maintained fleet, it will happen. So we can't just ignore those impact of those outages when we plan for our system if we want to make sure that we have that power available during those cold winter mornings, those cold snaps and polar vortexes.
And you mentioned something I wanted to highlight, that page 32, lines 4 to 7, that you just mentioned here, that half of the increase, half of that 5 percentage point increase is due to generator outage data, correct?
It's half of the 5 percentage point increase is attributed to the increased outage data and the correlated risk of increased outages and very high loads in extreme winter weather. For confidentiality purposes, I think I grouped 2 impacts together, but they're correlated.
And you referenced this a minute ago, and this isn't a confidential portion of your testimony, so I'm not going to ask you to read the numbers, but you mentioned a table 2 at page 32 of your direct that compares the forced outage rates of different resources from Astrape's 2020 resource adequacy study and the 2023 study, correct?
Yes.
And without, again, asking you to divulge confidential information, you would agree that the forced outage rate for Duke's coal units went up significantly from 2020 to the 2023 study.
It did increase, yes.
And again, Presiding Commissioner Kimwright, I believe the Commission's already taken judicial notice of its order making findings and directing actions related to impact of Winter Storm Elliott in docket M100 sub 163 from December 22nd, 2023. Is that correct?
That is correct.
Thank you. And so, Mr. Thomas, you're aware that DEC's and DEP's coal units experienced derates and forced outages during Winter Storm Elliott, as we were discussing.
Yes.
And again, the specifics are all covered in that order, so we don't have to go through each one, but you would agree that those included derates and or forced outages at Marshall Units 1 and 2, Roxborough Units 1 and 2, Cliffside 5, Mayo 1, and Roxborough 3 and 4.
Subject to check, I would agree. I think Mr. Metz may be more familiar with that report's details, but in general, yes, I think it identified issues at numerous coal plants.
And you would agree that Duke's P3 retires more than 3,100 megawatts of coal units by 2031, including the coal units that contributed to that declining generator reliability that we were just talking about.
Yes, so the specific coal retirement dates, I'd have to look to witness Mishna, but yes, there are numerous coal units that will be retired. And part of the amended stipulation is obviously to revisit this resource adequacy study prior to the 2027 proceeding, so we can better understand the impacts. But, you know, I do just want to emphasize, right, even if we did retire all that coal today and have new and more efficient, hopefully better insulated new generation facilities, that is still just, the coal outage rate is still just a small part of the overall system outage rate that increased. And so, you know, I think we're talking about a small piece of 2.5 percentage points. And so I think we recognize that it is important to maintain system reliability and that we need to make sure that we're reliable no matter what type of generation resources we have connected to the system.
And if I got another thing is, I mean, the reality is we have the system that we have to live with today, and we need to try to balance what future resources that we need. And as Mr. Thomas pointed to, as we go through time, as we get closer and more certainty of when these coal generation assets are retired, the assumption is that the resource adequacy study will be able to evaluate and potentially start removing those assets because they're no longer in the longer term capacity needs. But however, right now we're in this unique period where they should be, for purposes of this evaluation, included.
And as you testified, Mr. Metz, some of the concerns that you've expressed in this docket and previous dockets about the declining O&M and declining reliability of those units. How, I guess, you would agree that once those units are retired, there's at least one of the drivers for that proposed increase might be out of the system, and we could have a fresh look at that, at what a appropriate reserve margin is.
Yes, when we do the next study, maybe we look at a 2033 study year, 2034. I'm not sure what study year we'll be looking at that point, but some of these coal assets will be retired. We'll have new assets on the system. Maybe we'll better understand outages associated with renewables and other inverter-based resources. Maybe we'll have a better understanding of how battery storage functions in the coal. And we may see other updates. We may realize that we can't rely on our neighbors as much as we thought we could in this study, or maybe more, right? There's a lot of inputs into the resource adequacy study. And so certainly I think it's something that should be updated periodically, regardless of any stipulation. And Duke has submitted these, fairly regularly on a 2 to 3 year cadence, basically since as long as I've been with the public staff. And so we will continue to look at that and study that. And how does retiring a fleet of less reliable coal units, how is that counteracted by maybe, now because PJM has shifted even further to deploying solar and storage and wind, how does that, comport with, reduced neighbor assistance? Because now we all have very, very correlated high peak winter loads as we electrify heating and cooling, and we have relying on batteries and less thermal dispatchable resources in neighboring BAs. So there's a lot of levers to pull here, but my presumption is they'll all be studied in the next study.
Thank you. That was my 15 minutes. No further questions.
Thank you, Mr. Neal. Duke, I believe it's your turn.
Thank you. Good afternoon to the panel. Brett Riceford on behalf of Duke Energy. Hope you're all doing well. My questions are going to predominantly be for Mr. Metz. So if other panelists have anything to add, please feel free to do so, but I'll direct these primarily to Mr. Metz. So if you could first turn to your amended testimony in support of the amended stipulation that was filed, please, at page 6.
Okay.
Thank you. And just as background, earlier in the day, you received a number of questions, starting with Attorney General's office and then other parties that focused on the public staff's extensive initial testimony in this proceeding and positions relating to your interpretation of House Bill 951, the significance of 2030 versus 2032 versus 2035, the reasonableness of public staff's modeling assumptions as compared to Duke, and the proposed execution activities. Do you generally recall those questions throughout the day?
Generally, yes.
Okay. And I think the purpose was to highlight differences between the initial modeling inputs and assumptions that the public staff used and the settlement. And a couple that were referenced were solar resource availability. Do you recall those questions?
Yes.
And then and I think you characterized it as the minimum level of gas generation that public staff ultimately presented in your NTAP, which was your Exhibit 1.
That is correct.
Okay. And in arriving at the stipulation with Duke, is it accurate that you, on behalf of the public staff and others of the public staff, reviewed Duke's rebuttal testimony as part of your assessment of a reasonable and negotiated stipulation?
Objection. This is friendly cross. These are questions pertaining to the stipulation agreed to by the public staff and Duke, as well as Walmart and CCBA. And these are not cross-examination questions.
Presiding
Please,
Commissioner.
please respond.
Yes, absolutely. So I'm trying to elicit that these questions relate to the reasonableness of modeling assumptions, where the panel represented earlier in the day that they viewed their initial modeling assumptions as reasonable. And I think it's important to assess in arriving at the stipulation that they informed that ultimate agreement to the stipulation and their stipulation testimony by an assessment of Duke's rebuttal testimony.
Okay, so I'm going to overrule the objection. However, refrain from doing, I'm going to give you some leeway, but refrain from doing any friendly cross. So make,
Absolutely.
make sure that your questions do not involve any friendly cross-examination.
And so returning, so you would agree that Duke's rebuttal witnesses and panels disagreed with limited aspects of the public staff's modeling assumptions, informing your recommended portfolio, as well as the pace, scope, and scale of proposed execution actions?
Yes, there were areas of disagreement.
Right. And ultimately, in establishing the stipulation, you arrived at a reasonable resolution of those issues, which you address on page 6 at lines 8 through 13 of your stipulation testimony.
Yes, the stipulation represents reasonable steps towards achieving the carbon emission reductions.
Thank you. I'd like to turn now to actually one related question. So would you agree with me that both Duke's modeling assumptions and the public staff's modeling assumptions used to inform their initial testimony and positions in this case are not binding on future proceedings, and it's reasonable in the context of resource planning to review these assumptions again in the next CPIRP proceeding?
Yes.
Thank you. You had some questions from Mr. Dodge on the topic of the use of the term equitable in various places in your testimony. You recall that?
Yes.
He specifically asked you about equity considerations as related to wholesale customers. And I think your testimony was you agreed that was important. Equity was an important consideration for wholesale customers in the context of transmission investments.
I can't recall if I said transmission investments or transmission planning.
Transmission planning. All right. So you didn't say anything about transmission investments or transmission cost recovery or allocation of transmission cost. Agree with that?
Subject to check.
Okay. And the public staff, to your knowledge, hasn't presented an opinion on the equitable allocation of cost or what are just and reasonable rates for recovery of transmission investments from wholesale customers in this proceeding?
That'd be correct. To the extent that those discussions happen within the local or regional planning, the public staff would file comments in those forums.
And those forums are FERC jurisdictional and wholesale transmission rates are jurisdictional to FERC.
That is correct.
Okay. And are you aware that witness Ragsdale on behalf of NCMC has filed testimony in this proceeding, this state jurisdictional resource planning proceeding, suggesting that NCMC may challenge future allocations of transmission costs on the current load ratio share basis at FERC?
I can't remember the specifics of the testimony, but I believe that's a fair generalization.
Okay. And just to confirm, your general agreement regarding an equitable approach to transmission planning and cost allocation, that wasn't intended to suggest that the current load ratio share methodology is unreasonable and the costs allocated to retail customers should be increased and the costs allocated to wholesale customers should be decreased.
That is correct.
Thank you. All right. Would like to briefly ask you a few questions about red zone expansion plan. This is the one area of the stipulation between the companies and the public staff that we didn't achieve comprehensive resolution on. All right. If you could turn to page 56 of your testimony, please.
Okay.
Line 3, and I think I've gotten all the page numbers updated from your corrected testimony, but if you could just read starting at line 3 and confirm the next two sentences, please.
I do not have the
All right,
the
well,
correct line items beside me. If I
that's
look
not
in
a
this
problem.
reference.
I can read it and we can.
Okay.
Yep. So would you agree that your testimony states that planning for the transmission system is a core function of resource planning? Transmission planning ensures that long-term reliability should be a factor for the commission to consider when it takes into account the plain language of House Bill 951 that references maintaining or improving system reliability?
Yes.
Thank you. And so when you reference the plain language of House Bill 951 there and the focus on transmission planning, is that in the context of the reasonable steps that this commission is required to establish for implementation of the carbon plan? When you quoted the plain language of House Bill 951, what were you intending to articulate there?
To the extent that we need future generation resources and looking at least cost planning, the cost of transmission and the implementation of transmission needs to be a cornerstone in that evaluation.
Okay, and so the transmission investments that are needed to enable that generation are resources that, as part of assessing the resource need through the modeling and then establishing a near-term action plan, are the reasonable steps the commission should identify and authorize in this proceeding. Is that your testimony?
My testimony was looking at the identification of looking at transmission and whether or not the resources selected had a reasonable amount of transmission included or transmission cost included within it, inclusive of the time frame to implement such a overall requirement, tying back to the least cost concept.
Okay, so just to be clear, because I'm not sure that was clear in at least my hearing, should the commission be identifying transmission investments as reasonable steps to execute the carbon plan? What I understood you to say was more of a modeling answer versus more of a execution oriented here, the resources to be selected and the plan to be approved by the commission.
Can you re-clarify or restate, please?
Sure. Let me try it a different way. So are you familiar with the rule RH68 that the commission approved last fall?
Generally, yes.
Okay. And if you'll recall, the company and the public staff worked through a rulemaking proceeding to establish that rule?
Yes.
Okay. And I believe you have a copy with you. We talked about this briefly earlier after conferring with your counsel. So subsection D5 is evaluation of resource options. It's on the second page of the rule.
Subsection D5, evaluation of resource options.
And subject to check, or if you have a chance to review it, the last sentence establishes that the CPIRP should include transmission as part of the least cost path consistent with requirements of 62.110.9.
Yes, and that is one of the reasons that I had in conflict. Looking at the discovery, we asked Duke to evaluate alternative analysis to determine the overall least cost and the reasonableness of the plan, notably the DEC portion of the Red Zone 2.0 upgrades, and Duke did not answer that DR response, or they answered it, but they didn't provide the information. Give me 1 second.
Okay, we can get to that in a minute, but
Sorry, that was just for
Go ahead.
posterity, looking at public staff data request 46-6. To the extent possible, please expand upon the following scenarios. I listed out a whole series of scenarios and asked it for evaluation, and Duke did not provide the evaluation.
okay. Returning to the rule, subsection 8, speaking to execution, requires the company to file a near-term action plan. Take a minute to review it, please. And as
Yep, and looking at their including upgrades to the transmission system, I don't necessarily see where it says approve or acknowledge.
fair enough, but the company's obligation in complying with the rule was to present a plan that they felt was executable based on the evaluation of the resource options to meet the objectives of House Bill 951 and identify the resources to be selected by the commission, including upgrades to the transmission system necessary to interconnect those new supply side resources, correct?
Correct.
Okay, thank you. And were you here, I think it was yesterday, for the discussion I had with Mr. Roberts on redirect about the public policy study?
Yes.
And you discussed that study extensively in your testimony, is that correct?
Correct.
And the public staff actually was called a sponsor of one of the public policy proposals that helped to inform that study. Is that accurate?
That is correct.
And did you hear Mr. Roberts' testimony about how the inputs and assumptions of that study were developed?
Yes.
And generally familiar with the inputs and assumptions and the parameters of that study?
Yes, we used historic prior cues in order to identify the potential future upgrades with that snapshot in time, which was similar to the Red Zone 1.0 analysis that we collaborated with Duke to provide insight and design the parameters to look at those overall evaluations. What I tried to do was going back to DR 46-6 was to further evaluate whether or not any other resources or potential transmission projects would alleviate the need for these projects because no alternative analysis was completed. So in a different lens, it's trust but verify.
Okay, but would you agree with the analytical rigor of that study and the conclusions that it verified that these RZEP 2.0 projects were needed based on the amount of generation proposed to be added to the system?
Yes, I have no reason to doubt the technical rigor that went into that analysis.
Okay, and I think we've spoken to this, but on page 66 of your testimony, you make a general statement that I think this is specific to the DEC projects, but you say that there was no formal study or cost analysis that was completed. And just focusing on the formal study, was this prior to the public policy study being completed that you wrote that?
No, this was more in reference back to, I believe, PSDR 46-6, as well as other discovery in DR 46.
Okay, but it is accurate that the purpose of the public policy study as implemented by the Transmission Planning Collaborative is to assess the need for new transmission upgrades to meet public policy objectives. Is that fair?
Based upon the public policy that was submitted, which was a snapshot of those resources at that specific time. Yes.
Okay, and it's accurate, and I think you say this in your testimony, that the amount of generation injected into that public or used to develop that public policy study was generally consistent with the resource needs identified in the near-term action plan for the supplemental planning analysis.
That is fair representation, yes.
Thank you. And then on page 67, starting at line 3, you make the statement that both of the DEP RZEP projects are likely needed given the continued interest of resource solicitation cluster market participants and other future generation resources such as standalone batteries to locate facilities in this area. Did I read that correctly?
Yes.
Okay. And how do you reconcile the phrase that you use in your testimony, likely needed, with what Duke was tasked with doing in the rule and what the commission is tasked with doing in establishing reasonable steps of developing an executable plan for what transmission investments the company needs to undertake to enable successful execution of the plan on the timeline contemplated?
Fair question. So looking at the overall concept of likely is through the continued RFPs or resource solicitation cluster for future solar resources, as well as DICES, there's continues to be strong interest in certain sections of Duke Energy Progress's transmission system. When you look at the progression over time of where those resources have shifted over general transmission lines, and you look at the kind of generally trend over time where the power flows are developing into the system, these seem like more likely than not reliability upgrades that are going to be required as more generation is interconnected into the system. Also identifying that I believe it was on the Selma project or the Clayton-Selma project, it was also large load likely interconnecting in this area, which that combination would be driving future transmission upgrades. The conflict is continued, which was an issue that I raised for the DEC projects, is that comparative to Duke Energy Progress, from my view, there is still not a as strong interest for solar developer projects in Duke Energy Carolinas. Also, because the nature of the 100 kV system, when you have a large project such as a 200 megawatt battery project, it has large repercussions through the overall 100 kV system, as well as if you have significant amounts of solar, couple hundred megawatts, it has large waves that goes through the transmission system. So DEC, it's one, we don't have as strong interest in DEP, so it is slightly more speculative from my view, and we're more or less fixing a topology issue of the 100 kV. It doesn't mean that the 100 kV system was built incorrectly. It has served its purpose as it was designed, We didn't have generation, and we had large distances between load. That is not commensurate for interconnecting battery storage and solar generation in a concentrated pocket. When you take a step back and you also look at potential DEC projects, for example, DEC has a whole host of onshore wind projects, some of which may be located down in this area. Duke Energy Carolinas has also proposed a combined cycle, which would potentially be located down in South Carolina. If you look at the overall 100 kV system that's in challenge, and you got WS3 over here, and the lines that we continue to fix, generally speaking, from red zone 1.0 and 2.0 are this little V, we have a larger issue going on. And if we take a step back and look at what are all the generation that is likely going to be needed in this area, and not just solely focus in on solar or battery storage that maybe not should be connected to begin with in the 100 kV system to this magnitude. Should we be developing a 230 kV line? Should we be developing additional 100 kV line? Should we be intertying into the 500 kV system to offload portions of this troubled 100 kV network? That's what we try to do. Apologies for a long-winded answer. Through discovery to verify that at least Duke's plan is least cost and whether it's reasonable.
Thank you. That was a lot to unpack there, and I'm not even going to endeavor to try, but I will ask, is the public staff open to continued discussion with Mr. Roberts and the other technical experts that support the transmission planning process to ensure we're appropriately evaluating the needed transmission investments to execute the plan?
Absolutely, and look forward to it.
Great. That's all I have. Thank you.
Redirect from the public staff. We'll go for about 10 minutes on redirect, and then we'll take a very quick break before we finish for the day.
Mr. Thomas, you and Mr. Smith discussed ownership structures of offshore wind resources. If you can, I'm going to have you turn to SIGFR Cross Exhibit 42. And Presiding Commissioner Camright, this exhibit is the Commission's order in the 2022 Carbon Plan proceeding. So if it would be okay with you, I would just ask that this be that the Commission take judicial notice.
So the Commission will take judicial notice. If it's the carbon plan order, it would be issued on December 30th of 2022 in docket number E-100 sub 179. Is that the correct order?
Yes, that's
Okay.
correct.
The Commission will take judicial notice.
Thank you.
And which page?
So we're going to turn to page 33. And if you can take a look down at footnote 9. Now this is the footnote that I believe you were referencing in your conversation with Mr. Smith regarding ownership requirements in NCGS 62-110.9. And if you could read that footnote, please.
Sure. So this is in the context of the Commission determining that the resources selected must be utility owned with cost recovered on a cost of service basis. And the footnote says, for the avoidance of doubt, the Commission does not intend that its decision on this matter exhaustively define utility ownership nor extend to resources the utility selects for purposes other than compliance with the carbon dioxide emissions reduction directives of NCGS 62-110.9.
Thank you. So if you could please expand a little bit based on the conversation you had earlier on the relevance of this footnote to the ownership structure of offshore wind facilities.
Sure. So I think the point I was trying to make earlier was that as far as offshore wind goes, obviously it's a large investment, large project, very complex, something that Duke hasn't necessarily done before. Some of these wind energy area leaseholders have done these types of projects before. And the way that at least the public staff had interpreted that footnote is that this does not necessarily mean that Duke needs to immediately acquire the wind energy area and do all the development work itself and own 100% of that asset. We saw this as the Commission kind of leaving open the ability of potentially joint ownership of these facilities, maybe between DEC and DEP to reflect some of the equity issues that Mr. Metz has been talking about relative to that ownership, right? If the energy is being shared between DEC and DEP, perhaps ownership and costs should be shared between DEC and DEP, or potential, innovative contracting structures between Duke and wind energy area leaseholders that might allow for partial ownership or majority ownership by Duke, or some other novel contracting structures, similar to kind of what we're seeing even up in Dominion with their CVAL project and different ownership structures. But ultimately, I just raised that issue to say that we want to minimize risk to ratepayers with such an investment that is new to the Carolinas. And if part of achieving that allows for some flexibility in this ownership structure, we believe that that should be explored and pursued if possible.
Mr. Metz, two quick follow-ups, if I may. First, you had a discussion on the public policy study. It's your testimony, is it not, that the results of the public policy request should be considered as directional and not absolute? Is that correct?
Yes, they're directional. You have to take a look at the overall values and see whether or not that is an appropriate snapshot or reasonable plan to move forward with. Say for a hypothetical, if a cluster study assumed 6 1,000 megawatt projects were trying to interconnect into the 100 kV network, that was a project that was potentially fishing for a place to interconnect, and it just wasn't viable for that project to stick around, so it moved on. So you have to take a step back, parse out the data, what's really going on, and identify whether or not you should move forward with those upgrades.
All right, and second question, you had a question a little bit about House Bill 951. None of that discussion, however, supplants the need and the required step that the company go through the CTPC, and that acknowledgement's not required. Is that correct?
That is correct.
Thank you.
Okay, so we are going to go ahead and take a 10-minute break. We're going to come back on the record promptly at 3:59 so that we can get as much testimony done as we can. And we'll come back with commission questions. We'll go off the record now. Before we get started with commission questions, I have a couple of procedural matters. Commissioner McKissick has a conflict and needs to leave the hearing around 4:15 this afternoon. Are there any objections to Commissioner McKissick reviewing the missed portion of the hearing by reading the transcript? Okay. Let the record reflect that no party has any objection to Commissioner McKissick reading the transcript. I also wanted to mention that we are going to do our best to continue with the hearing in as an efficient manner as possible. And that means several things. When attorneys are getting ready to do their cross-examination, please refer to your reserved or your anticipated cross-examination time and do your best to comply and stay within your cross-examination estimated time. We also are going to change the schedule for the hearing to some degree. Tomorrow morning, we're going to begin at 9 o'clock in the morning rather than 9:30. And we may be staying until 5:30 rather than 5 o'clock. So be aware that 9 o'clock tomorrow morning, with the possibility that we are going to stay until 5:30. And each day, I will let you know what time we are planning to start the next day and finish, because we need to make as much progress as we can with getting this hearing completed. So with that, I will begin with questions, and my questions are going to be directed to Mr. Metz. And Mr. Metz, my questions are specific to the RZEP 2.0 projects. And to begin with, I just want to understand at a high level your objection to the specific RZEP 2.0 projects. And my understanding, and please correct me if I'm wrong, is that your two objections are, one, that Duke did not perform a larger and more holistic planning of the needed transmission. And then secondly, that the public staff would like for the cost causers that trigger the network upgrades to pay for the upgrades. Is that a general understanding of the public staff's objection?
In regards to the first one, a holistic, that is absolutely correct. In regards to the cost causer, well, taking a moment to reflect there.
Let's start with the first one that we talked about, and we can talk about cost causers in just a minute.
Okay.
And so you testified, I believe, to questions from Mr. Bryshworth about the transmission upgrade projects in the DEC territory. And my notes show that you stated that there was not as strong an interest in interconnecting solar in DEC as opposed to DEP territory. Is that correct?
Yes.
And then I think that you said for DEC, one of your concerns is that the public staff would like for Duke to be taking a greater or more holistic approach in DEC for planning transmission upgrades to interconnect solar, onshore wind, and other generation resources. Is that correct?
That is correct.
Okay. And is your opinion or position the same for the transmission upgrade projects in DEP territories as it is for the DEC territory?
Yes, for future DEP projects, we would like a holistic planning applied to it. It's just for identification of these discrete Red Zone 2.0 projects. It's likely that the two that identified in testimony aren't necessarily driven by larger holistic planning. It just seems like a next step in the overall process if you look at transitioning power flows across the system.
Okay. And are you referring to DEP territory when you
DEP.
state that? And for those transmission upgrade or the network upgrade projects in DEP, my recollection is that you did testify that those network upgrade projects were necessary to interconnect solar in order to meet the objectives of 951.
On one of the projects, I think it'd be a fair designation to say it'll be enabling the increased power flows from DEP East over to DEC, which would not be centric upon solar, while solar is a primary driver and that overall excess generation moving that direction.
Okay, and the other one, you state your position. I guess before we start, for clarification, what is the transmission upgrade project that you just mentioned?
That is the Lilesville to Oakboro project, the one I just got done discussing.
Right. And then what about the Clayton Industrial Selma project?
The Clayton Industrial Selma project is identified. If you look at the overall transmission system and you look at the point of interconnections, that just seems like a natural progression of power flows coming from the predominantly solar, but as well as other generation plants that are centric to the center DEP system, coupled with the load that is being requested within Johnston County and specific off those feeders.
Okay, so do you have the same objection to that transmission project? Do you believe that that project is justified or needed?
I believe that is a reasonable project.
Okay, so the two projects, just to make sure that I'm clear, the two projects, the Clayton Industrial Selma and the Lilesville Oakboro projects, you believe are reasonable projects?
That is correct, with the additional qualifier of the DEC portion of the upgrade that was listed in Mr. DEC witness Robert's rebuttal testimony. The as proposed project didn't include subject to protect approximately a $250 million upgrade on the DEC portion of the transmission system.
Okay. And before we go to before we talk about my second question about cost causation and who should pay for the transmission network upgrades, can you explain the public staff's, it seems like there is a difference in position from the carbon plan proceeding in 2022 and this carbon plan proceeding in regard to RZEP 1.0 and RZEP 2.0, because in the first carbon plan proceeding, the public staff supported the acknowledgement of the need for RZEP 1.0 for implementing the carbon plan, but the public staff is taking a different position in this carbon plan proceeding. Can you explain why?
So taking a step back, I believe that I provided some reservations on moving forward with certain elements of the RZEP 1.0 projects, notably the DEC portion of the projects, which are all located in South Carolina. So from where I sit in North Carolina, I have some reservations on telling another state where to start building their transmission system. So that's just one concern. Upon further reflection is looking at the terminology of acknowledgement through local transmission planning and regional transmission planning. It's just not required for that project to go forward to that local and regional project. We can have discussions or debates about potential cost allocation within the local and regional projects. There's one concern to the extent that this commission acknowledges a project, which this commission may do so, that would almost give more rise to future disputes about cost allocation and not enable other parties, let's just say for the public staff, to potentially dispute cost allocation principles. So for example, as a hypothetical, if this commission was to acknowledge a plan and it goes to a local transmission planning process and the local transmission process said we gave weight to the NCUC's policy discretion, one could take a step back and say those transmission projects are but for North Carolina's request, and therefore it would be 100% cost allocated to North Carolina. When we looking at the larger impacts of some of these future transmission systems identified, nominally about $2.6 billion in transmission upgrades were identified in the public policy upgrade. Nominal $1 billion plus or minus are for potential offshore wind projects. Those are large dollar values that aren't being reflected within the Encompass model on the bill impact analysis if 100% of those costs are assigned to North Carolina.
Understood. And so I want to ask some questions about cost causation and who should pay for the transmission upgrades. And my understanding from your testimony, so please correct me, if I misunderstood your testimony, is that you testified that through the DICES process, or through the DICES or the Resource Solicitation Cluster process, that the solar developers or the interconnection requests that trigger the network upgrades, that there would not be a delay in having the transmission, I should say material delay in having the transmission be constructed if the cost causers were required to pay for the transmission upgrades, as opposed to it going through the local transmission planning process. Is that your testimony?
In regards to those discrete items, I believe I was referencing the Duke Energy Carolina projects that had a nominal approximately 4 years for implementation. So I did not see that as a material impediment to potentially delay future resource additions. Now, to the extent if those were 8 to 10 year construction schedules, I would have to reevaluate those on those facts and circumstances.
So you were not, your opinion about having the cost causers pay for the transmission upgrades and there only being a delay of about 2 years did not apply to the projects in DEP territory. Is that correct?
The cost causation would still be appropriate for Duke Energy Progress. The material delay was more of the lack of material delay was more of a factor in Duke Energy Carolinas. So, but when you took a step back and looking at the Duke Energy Progress projects in general, that with the increased power flows, taking a step back and looking at overall modeling, there will be increased power flows going from east to west, regardless of which portfolio one selects. So that, to me, that identifies a longer term reliability need in order to economically transition that energy from one system to the other. That does start to raise the concerns about cost causation, because why is that energy being transferred? Energy is being transferred to economically serve Duke Energy Carolina customers, but where Duke Energy Progress's transmission system and Duke Energy Progress ratepayers are essentially forced to pay the bill.
Okay. And I'm sorry, let me just make sure I'm clear. I think we're talking cost causation between DEC and DEP is a discrete issue from who pays. Does the solar developer pay for the transmission upgrades if they trigger it? Those are two separate issues, correct?
That is correct.
Okay, so I want to make sure that we are separating those issues, because I think that you're talking about both issues when with your objection to the RZEP 2.0. Is that correct?
That is correct, because what I'm trying to articulate is the complexity associated with continued advancement of policy-driven upgrades. And it is very hard to put a pin on exactly saying which caused what and who should pay for what.
Okay. And when you talk about potentially some delay in 2 years for building of transmission in DEC territory, I think there's some concern about whether we are going to be able to interconnect enough solar in a timely manner to meet the interim goal. Do you believe this 2-year delay could factor into making it even more difficult to bring enough solar online to meet the interim goal?
It's a fair question. I guess where I'm challenged is that the Duke Energy Carolina system is still a large system. We are continue to be focused on this very narrow part of upgrades, which is a topology issue or construction of the existing 100 kV system. To the extent that developers are seeing this constrained area with high transmission costs, that should be a signal to continue to evaluate other alternatives. Time will tell whether or not that will come to fruition or not.
And if you know, I think we've talked about this extensively in other dockets, are there other areas in the state, other than the constrained areas where RZEP 1.0 and now RZEP 2.0 are located, where we're seeing a lot of interest in cost cost-effective solar being located. Do you have any information that you can provide to the commission about that?
Looking over to Mr. Thomas, if he recalls anything for looking at the analysis of the bid results without going into confidential information.
Let's not go into confidential information. But if you know some information that's not confidential, I'm interested.
I've looked at, like, for example, the 2022 selected port RFP, solar RFP selected bids and the 2023 submitted bids, but it's kind of difficult to draw a clear and bright line between where the project is located and what the price is. There's a lot of factors that go into that, but they're not necessarily, trying to think how to, I would have to do some additional analysis of some of that confidential information to kind of better understand exactly how the location correlates to the price that's been bid in and the included network upgrade. So I don't have anything right now.
Well, we do not need to go into confidential information. I think we're all looking for the least cost solar that we can bring onto the system. So that's a question we've been thinking about for quite some time. And my last question, Mr. Metz, Duke Witness Roberts yesterday was making the case for the commission acknowledging the need for RZEP 2.0 to implement the carbon plan. And by doing so, the cost would be socialized among ratepayers, and they would not be borne specifically by the solar developers. They wouldn't have to pay for the transmission upgrades. Witness Roberts, his argument basically was that this is simply a mathematical or accounting exercise, that the end result is the same because either the costs are socialized or during the solar procurements, the solar developers increase their bids if they have to pay for the transmission upgrades, they increase their bids to cover those costs. Do you have a response to that argument that it's simply an accounting exercise?
It is one of the push and pull relationships that we try to identify on where will the costs go. End of the day, ratepayers will be borne with those costs. Each methodology has its own pros and cons. They're about equal, in my opinion. However, when I take a step back from the accounting exercise, to the extent that we have FERC jurisdictional projects seeking interconnection or state jurisdictional projects seeking interconnection, those are regulatory approved constructs that have already factored in the overall accounting mechanics. So to the extent that we apply more discretion in those regards, I think it does start opening up the vulnerabilities for future or downstream arguments on cost causation and cost allocation methodologies.
Understood. I think that's a fair answer. That's all the questions I have, and I'll turn it over to Chair Mitchell.
Right. Good evening or good afternoon, guys. I will try to be quick, but I got to cover a lot of ground with y'all. Mr. Thomas, I'm helping. I would like for you to sort of give me some real basic education on the system configuration for modeling purposes. I don't know if you heard my questions yesterday that I directed towards Ms. Bateman, and they were not the clearest of questions. But what I want to understand is the way that the way the systems were configured for purposes of the modeling that was done for this plan for the IRP. Can you walk me through how the systems were configured? And if I have questions along the way, I'll stop you.
Sure. And if you'd like, I can open with just the resource adequacy study that moved to Encompass.
Just start with Encompass. I think I'm clear enough on resource adequacy. I have one question that I'll come back to on that one for you, but start with the IRP.
Sure. So within the Encompass model, there are essentially balancing authorities that have, or areas that are intertied, and you can set constraints and definitions for each of these balancing areas. So within Encompass for the 2023 CPIRP, there is a DEC, there's a DEC balancing area, there's a DEP East balancing area, and a DEP West balancing area. Each of them have their own load, their own hourly profile, their own peak load forecasts that they must meet. And within that, they also have their own reserve margin target that they have to meet with resources that they themselves control, own, and operate, located within their balancing authority. The model does not permit, at least the way that it's set up in the 2023 CPIRP, it does not permit the sharing of capacity for reserve margin purposes. So if DEC is low on their reserve margin, they can't go call on capacity in DEP to meet that reserve margin calculation. So they have to separately meet that 22% reserve margin. But there are energy allowances and interchanges between them, representing approximately the cumulative transmission intertie capacity between the two companies, mostly DEP East and DEC. And so during the natural dispatch, very similar to how they operate today, DEP may overgenerate and ship some of that during the middle of the day and ship some of that over to DEC to meet their load so that DEC doesn't have to dispatch its more expensive resources. The system is essentially dispatched together, and then that energy is able to meet that load up to that transmission interconnection constraint. And so we actually saw that quite a bit, and Mr. Metz discussed it a little bit, where that cap is hit, and then the DEC might like to import more energy from DEP, but can't, so it has to flip on or ramp up its own generators.
And
when you
say cap, do you mean the transmission limits are hit? And so, okay.
Yeah, so it's like at least in the production cost, it's an hourly, or it's a seasonal limit. So it's not as precise as they may handle it day to day with ambient line ratings, but it's essentially modeling that cumulative transmission capacity. And once that limit is hit in any given hour, if no more can be imported, then that importing BA needs to turn up their own resources.
Okay, so I'm with you so far. The exchange of energy across the two BAs when sort of the appropriate circumstances arise, is that accomplished? Now we're sort of moving beyond the modeling, and I'm asking you a question that happens in the real world. Does that exchange of energy between the two BAs occur pursuant to the JDA?
Mr. Metz is the expert in the JDA, but I believe that, yes, that is the function.
Yes, that is correct.
Okay.
Generally speaking, yes, that is correct. There's must-run designations and a few other qualifiers, but yes.
Okay.
And the JDA also addresses certain, my understanding of the JDA is it addresses some cost-sharing agreement between the import that isn't necessarily reflected in the model, but it might be reflected. So, but from an operational standpoint, it's largely similar, but cost allocation and assignment might be a little different.
Okay, understood. Thank you. The carbon plan, portions of the carbon plan, Chapter 4, Chapter 2, Appendix C, if you want to refer to it, discuss the system configuration for purposes of the modeling exercises that were conducted here. And one of the things mentioned is that the analysis assumes the implementation of consolidated system operations. Do you remember that description in the carbon plan?
I do,
component?
in the discussion, I think a little bit yesterday with witness Bateman, I believe I recall that, yeah.
So what does that mean exactly?
So I think that the way that so each of these BAs, I think, normally can kind of share resources to meet their operational reserve. So I just real quick, I talked a little bit about reserve margin and that reserve, and that is kind of long-term capacity planning. But the model also, they have to load in hourly data for their balancing reserves, their frequency regulation, and I believe one more. So there's all these resources, and they have an outside kind of calculation. They say, how much operating reserves do we need in each hour? And that is kind of added to it's not really added to the load, but it's resources that have to be there to kind of maintain that flexibility. My understanding of the consolidated system operations is that to satisfy those reserves, those hourly operational reserves, they can share resources. They don't have to meet those reserves with only their own.
Okay, thank you. That's helpful. Last question for you on this line. The Chapter 4 says, while the resource plan does not at this time assume for fully merged utilities, future long-term planning assumptions will be appropriately aligned as the work stream progresses. And that's in the discussion about the company's plans to pursue the merger. So as I understand it, the modeling does not assume full merger of DEC and DEP, but does assume some coordinated operations as you have explained them to me and as they are explained in the portions of the carbon plan. Is that a fair statement?
Yes, they're still modeled as two separate BAs, but kind of pre-merger, but post this operational coordination, or however it's described.
Okay, so the model does, the modeling that occurs does reflect the energy sharing that can occur pursuant to the JDA, or that does occur and that will occur for the foreseeable future. And then then there's also this the model reflects some consolidated system operations where there's perhaps a sharing of a sharing of resources that are necessary for maintaining or meeting their NERC obligations. Is that right?
Yes, approximately. And then, if I could anticipate your next question, I think that the merger, if they were to model themselves post-merger, they would be kind of one BA within the Encompass model. And there are some other benefits that might arise from that. But the biggest one is that instead of each company having their own reserve margin to meet and build capacity for, they would have a single 22% reserve margin that could build resources anywhere to meet that reserve margin. So there's some benefit there in terms of, as a whole, the system might not need as many megawatts of a reserve margin.
Can you explain that to me? Why the system as a whole, if modeled as a merged system, might not need as many megawatts?
So, I mean, capacity expansion is lumpy by definition. So the extent that we aggregate load, we may be able to fit a more precise resource in there and not cause a significant overbuilding. We'd be able to grow more incrementally into that load. And this would be potential deferring of future resource assets.
Yeah, and if you kind of figure 3 on page 35 of my testimony, you can kind of see here that I'm showing the Duke kind of total calculated reserve margin, but I'm also showing the reserve margin for DEC and DEP. And so they all meet that 22% in 2031, but it might be 22.9 or 22.4. So you can imagine that because of this blockiness, you might be able to get the whole BA at a 22.2, and that in and of itself is going to result in less megawatts on the system. Or
Okay.
could.
Okay, and where did you said table 3?
Figure 3.
Figure 3,
On
okay.
page 35.
Okay. Okay. Okay, one of the witnesses in this proceeding testifies as to a concern about overbuilding. Let me find my notes. I believe it's one of the SIGFR witnesses. And I'm going to paraphrase the testimony, and if you remember it differently, you can correct me. But my read of the testimony is there's concern that if we are engaging in this long-term planning now with the understanding that the companies are going to seek to merge the BAs in the future, and there may be some implications for resource needs following that merger, taking any action right now in this time period is premature and could lead to overbuilding and overspending at the risk of the ratepayer. Can you respond to that concern?
Yeah, I'll take a crack and then.
And first,
Yeah.
can you confirm that you recall this testimony?
I believe it sounds familiar. I've
Okay.
read, I don't know how many 100 pages of testimony, but it sounds familiar.
Right.
But that is a concern that I think we share.
Okay.
And I think, there's a couple ways that we've addressed this. So obviously if the merger does operate swimmingly, and by January 1st, 2027, we have a single combined utility. Then the 2027 CPIRP would obviously reflect that, and we'd have some updates, but I expect that we'll have some updates or some better understanding of this process in 2 years when we're all sitting down here again in this hearing room. And so it is true that there might be a reduction in necessary capacity that's needed after the BAs merge, but it's not going to be thousands and thousands of megawatts, right? You might have in this critical period, kind of 2027 to 2031, if you were able to combine the utilities and kind of get rid of some of that lumpiness, maybe you could cut out several hundred megawatts of needed resources for your reserves. And that would be pretty good, right? That's lots of megawatts. That's hundreds of millions of dollars. But the problem is that if the merger doesn't happen, they still have to have those reserve margins and operate, independently. So we have to kind of build in somewhat of a delay. We are expecting a new reserve margin study in advance of the 2027, so that'll help inform some of this. And then also, our concern about some of the gas plants and the need to build out as much gas as Duke had proposed in its original near-term action plan. Our amended stipulation reflects some give and take on those plants and acknowledgement that at this time, there should only be pursuing a certain number of them based upon construction schedules and when they're needed. And if we get to the next CPIRP hearing and the merger isn't going well, and it looks like we're not going to be able to share that capacity or realize that benefit, then we'll have to reassess, right, what the plan is at that point. But ideally, at that next CPIRP, we're able to even potentially model them as a combined utility or make some assumptions about them converting to a combined utility and explore what that might mean in terms of, a capacity build out.
Okay, so do I understand then your testimony be that while there is time to assess further what capacity needs or what resource needs may be in the future, assuming a combined utility, and that the risk of overbuilding or overspending is one that can be mitigated against? I mean, is that what you're saying?
I think that's a fair generalization. I think that's what we're trying to get here.
Let me say it this way. If I understand your testimony that way, is that a fair understanding?
Yes.
Okay. I don't hear the public staff saying, we can't do this, we need to wait. We're concerned that they're going to overspend and overbuild and saddle the ratepayers with these costs.
I think you could look at the near-term action plan, at least as we've crafted in the estimate, as kind of that least regrets. This is what we know we need, and a merger might change things in the future, but that might impact CC4, 5, or CT 5 and 6, right? So we hope that this near-term action plan represents that least regrets, and we will give us enough time to assess that in the future. But Mr. Metz may want to add.
I'll only expand. I agree with everything Mr. Thomas said. Is we can't wait to see what a merger happens. We need to be planning for resource adequacy today and maintaining those reserve margins, because if for whatever reason, well, even though I'm optimistic for the merger was to fall through 2027, I mean, that's 3 years from now. You can already look, this is a very aggressive near-term action plan. What will we do if we wait 3 years? I can't even contemplate of how much we would have to get out of the hole to get back to where we need to be. And that is a significant risk.
And when you say get out of the hole, you mean how much capacity we might have to build in a short amount of time to meet projected load?
Yes.
Okay. Mr. Thomas, I think it's your testimony. I don't have the specific reference, but you're focused on the period between 28 and 32, and you describe it as extremely constrained.
Yes.
Is that ringing a bell to you?
Yes.
Okay. Assuming that the company secures permission to construct the gas assets, those gas assets that are pending before this commission at this point in time, and those assets are planned to go into service in 29. There's just not much, what else is going to happen between now and 2032 that's going to ensure that we get through this period of time with minimal disruption to service?
Yeah, so I think,
assuming the load projected actually materializes.
yeah, so obviously that's a big if, right? And we have seen that load shift and changing economic conditions has impacted that. But the bottom line is that some of that load is here and coming, and I mean already building, constructing. So some of that load is going to be there. I think we already have multiple resource kind of solicitation clusters going on right now for solar and storage. Duke is expanding its standalone storage, placing new resources, not only in the MYRP, but also, seeing them at existing coal plants, at existing solar plants. So we're seeing kind of this capacity being built up and these resources being there. But because we know we have some upper limit, some practical upper limit on those types of resources we can connect to meet this load, especially this high load factor load, these gas resources that Duke is planning for is something that's going to need to be there.
And that's one reason, apologies, that's one reason why in my testimony, we listed so prescriptive in Exhibit 1 on the near-term action plans, looking over the notes section, is like, we need this amount of resource by this time frame. We need this much by this time frame. It was to try to bridge this constrained area that we're in.
Okay. All right. Mr. Thomas, my read of your testimony is initially filed. This is sort of pre-settlement and the company's position pre-settlement. There didn't seem to be disagreement on the reasonableness of a 22% reserve margin, but there was a difference of opinion on timing as to when that 22% should be achieved. Did I read the testimonies correctly?
Yes.
Okay. And so where did you all settle out on that issue in the stipulation settlement agreement?
So looking back at the stipulation, I believe we assumed, just make sure I'm not misspeaking. Yeah, so paragraph 12, the amended stipulation assumes 22% by 2031, and then using the 2023 study kind of as that basis for increasing. And so my assumption is that we will essentially grow into that reserve margin. It may not be at the exact schedule that Duke had proposed, but we will grow into it by 22% by 2031.
Okay. All right. Back to the JDA, the payments that are made pursuant to the JDA, are the money that is exchanged under the JDA. Does that include payment for transmission service?
My understanding is no, and that's one reason in part we did the transmission cost allocation within the last general rate cases for DEC and DEP.
Okay, so does that mean that energy can flow only when there's transmission capacity available?
It is the non-firm as available energy. So for example, as a hypothetical, if someone wanted to move power from Southern to PJM, they would subscribe to that firm reservation first, and if there was no headroom left over, then there would be no energy to flow across that scheduled node, noting that there's multiple nodes or multiple interties in between DEC and DEP.
Okay. Okay, there was sort of difference of opinion between the public staff and the company about the location of a proposed combined cycle generating facility in South Carolina. Do you recall that difference of opinion?
Yes, I believe a variety of witnesses discussed in the testimony, but yes, we generally had found that in the 2022 carbon plan order, the commission had ordered that new potential resources be modeled as if they were in North Carolina until some material movement and had indicated that they were committed to South Carolina. And so we just kept that same, followed that through into this proceeding. We removed the South Carolina combined cycle from the modeling, but I believe I mentioned, or maybe Mr. Metz mentions that, if at some point in the future in a CPIRP hearing, if Duke has secured the permission to authorization to build or applied, or at least made material efforts to build one in South Carolina, or maybe had even already built one in South Carolina, that would obviously be exempt from the 951 standards because it is out of the state.
And if I may, we ran a sensitivity also to inform the lease regrets planning if that combined cycle was located in South Carolina and if the emissions did not count. And you can see the movement on what resources were selected.
Okay, so for purposes of so at this point in time, are the parties looking to the commission to answer any questions about the planned location of that CC?
That's a good question. It's not explicitly discussed in the stipulation outside of the statement that the modeling is reasonable for planning purposes. My understanding is that
I don't believe it's under dispute. And to the extent that, at least it was our testimony, if the company was to file a CPCN or South Carolina or have some more positive movement, we would reevaluate that and the facts and circumstances in the next CPIRP.
Okay, so, but it doesn't, but that proposed, the South Carolina proposed facility doesn't impact the agreements that you all made or the positions, the consensus you achieved and that's set forth in the settlement agreement?
No, but by all means, if the commission wanted to provide clarity on that for the next hearing, I think that would be appreciated.
Okay. All right, Mr. Thomas, can you walk through your analysis of Duke's P1 fall supplemental proposal?
Yeah. Yes, one moment. Let me just get.
And you cover it extensively in your pre-filed testimony, but I'm hoping you can just sort of give me an overview of what you found.
Yeah. So this is P1. Yeah.
P1 fall
30
supplemental.
compliance. Yeah. So we looked at P1 and in discovery and conversations with Duke, trying to understand how this was arrived at. They essentially took a slightly different approach in their modeling. And they said, what is the total number of resources that we need online by the interim compliance date to meet this interim target? And then they just spread those out over however many years are available. So for P1, for example, the solar and solar plus storage limits per year were 4.275 gigawatts of interconnection capacity per year for solar and solar plus storage. And then also very high targets for storage as well. And so they basically ran their model with those very high targets, not necessarily reflective of anything that Duke thought was reasonable or achievable, but simply to show this is what we would need to get there by that date.
So does the model, just so that I understand, when Duke was running the model to achieve that, using that P1 fall supplemental proposal, you said they set the interim target. Does that mean they set a carbon emissions level to occur at a date certain, so 2030?
Yeah, so
Okay.
essentially, and I think I have a chart in here somewhere, but it's there's a curve that represents the annual carbon cap. And so they just kind of shifted it to the left so that 70% target, it's like 22 or 24 million tons that limit occurs in 2030 as opposed to 2035 or any other year.
Okay. All right. So then keep going with your with your analysis of that P1 fall supplemental
Sure.
portfolio.
And so as part of this kind of, call it resource cramming, right? They said, what do we need to meet that interim target by that date? And they adjusted their resource availability caps or limits, annual limits, to allow that much to be installed. They also moved in a lot of resources, right? So for example, in the P1 fall supplemental, the first block of offshore wind actually arrives in 2028, which was done in order to get the model to solve without carbon violations. But at this time, I do not believe anyone, no intervener and no party has expressed that 2028 is possible for the wind lease areas off the coast. Onshore wind is available in 2030. That's when those first blocks, over a gigawatt of onshore wind, is connected in 2030. And then again, I think I pointed out that you have for 2028 and 2029, you're connecting well over 4 gigawatts annually of solar, and in some years over 3 gigawatts total of standalone storage. And in addition, you are also adding gas, combined cycles, combustion turbines, and quickly retiring coal, about 6.6 gigawatts between 2029 and 2030. So it's a compressed schedule. They basically take everything that occurred in their P3 by 2035 and just scoot it up to 2030. So we looked closely at that, and we paid some attention to this, right? I personally have read, I don't know how many hundred consumer statements of position advocating for 2030 and for no new gas. And so we ran 2030. We ran 2030 with no gas. We tried to understand if it was possible, but we also tried to take a different approach than Duke, and that was to try to use relatively reasonable or maybe a little bit outside the bounds of reasonableness targets, and then see if the model could even solve. Whereas Duke, just increased them to these outrageous levels so that, they could solve it. But both of the modelings kind of confirm the same thing. If you only use the resource connection limits that we had used, the lower, more reasonable targets, the model simply couldn't solve. It could not reduce carbon enough, and there were exceedances in every year. So you put in a 2030 date, and you call it a 2030 plan, but you actually don't achieve compliance until 2033 or 2034. And then on the flip side, you look at Duke's approach, where they increase these quantities, and I just cannot see, public staff, we work with interconnection dockets and competitive procurement dockets and all of this stuff. And from where we're sitting, we just cannot see a pathway to interconnecting as much as 7 gigawatts of new resources, new renewable resources in a year. At the same time, you're also connecting 5 gigawatts of gas. And so for us, that was simply not a reasonable plan, not achievable. It's not even about execution risk, it's just impossibility. And so that's why, and so that was kind of the gist of kind of going through that 2030 compliance, both from Duke's approach and our own approach.
If the commission were to accept P1 fall supplemental as reasonable for planning purposes, do you think that would be a threat to the reliable and the reliability of the electric system? I mean, is it your opinion that directing Duke to pursue that course would risk reliability? I mean, I recognize what you're saying. It would be impossible from an execution standpoint to interconnect the sheer number of resources that the companies would have to interconnect, but talk about it in terms of reliability and adequate service.
Sure. And I may let Ms. Metz chime in, but I think a lot would depend on how Duke implemented such an order. I think if Duke went ahead and set up some RFPs to go procure 4 or 5 gigawatts of solar in a year, and then just before those resources were interconnected, started retiring coal pursuant to the schedule and P1 fall base, and then those resources fail to be interconnected, we simply can't make it happen, then yes, I think we would have reliability issues at that point. If I saw a way for us to get to that level of interconnection, I think the public staff would advocate more strongly for an earlier compliance date. But I think, what's represented in the near-term action plan, our modeling with the 2034 and Duke's kind of P3 fall base, I think those represent achievable steps that we can take without sacrificing system reliability.
And in this expand, we did take this very seriously, and that's why we spent extensive testimony trying to evaluate this. Notably, I go back to the reliability section. When you look at what we call the DEP PS1F 2030 no combined cycle high grid edge operation risk and impact reliability low load events, we talk about all the nominal 8 gigawatts of solar that was being forced into the system in a very truncated manner. When you look to that graph, you're almost having to curtail during the shoulder seasons. You're going negative generation. You're having to curtail all that solar. And then in addition to that, you're going to have to cycle down the entire nuclear generation fleet on top of that for multiple days through multiple periods of the shoulder season. So not only was it an execution risk, it was also from my view, an actual reliability and operation risk in real-time system dispatch.
Okay. All right, Mr. Thomas, you looked at the modeling work you did. You also looked at 2032 as a compliance interim compliance deadline. Is that the case?
That is the case. We tried to look at what our position was in the last carbon plan hearing and see if that was still achievable.
And what did you find?
Well, unfortunately, we found similar significant levels of interconnection that would be required to get there, or simply exceedances where the model would simply not be able to meet that target. So we would try to plan for like a 2032 compliance date, but not really achieve it till 2034. So, I think, and part of P2 as well, that the P2 fall supplemental that Duke submitted, also similar in approach, only they used 2033, had fairly aggressive, interim, like immediate need for these resources. So generally, we found, based on our analysis, that 2032 isn't achievable either without threatening system reliability. However, our amended stipulation does still, while we did kind of decide that future modeling of 2030 compliance was no longer productive, we did not necessarily take it off the table for 2032 because it is possible that some of this new load could go away by the next update, and that kind of falls back into place. But either way, the near-term action plan that we have here, I think, does represent those achievable steps. But 2032 would be the lack of the ability to pull in onshore wind and offshore wind, I think, in particular, hurts the ability to get there by 2032.
And I can span another data point. It happens to be figure 1 nuclear capacity, but it can be found in any of the analysis. The public staff's 2032 plan, when you look at the highest cost across each one of the years listed, the 2032 plan had the highest cost compliance associated with it by a significant margin. For example, looking at 2038 compliance, it was $92 billion for 2032 compliance compared to the median cost of $77 billion.
Oh, I'm gonna get there. Okay, so have you all? So there's testimony that's been offered in this proceeding by other witnesses, and I can go into specifics if I have to. But the testimony from these witnesses suggests that the companies didn't sufficiently examine achieving compliance by 2032, that their analysis wasn't sufficiently robust. And so what is your response to that criticism of the company's analysis of achieving the 70% reduction by 2032? Did the companies take a good hard look at achieving compliance by 2032? And did your work also examine achieving compliance by 2032?
So just as an initial matter, I'd say, Duke did not actually model a pathway with 2032. They looked at 2030, 2033, and 2035. I believe a lot of that reflects their kind of understanding going into this, that, look what we would need to get there by 2030. Let's provide some kind of maybe more reasonable portfolios. But I do think that we looked into it fairly well. And I think we kind of came to the same conclusion that Duke may have, is that, absent some sort of revolution in the way that we interconnect and build and safely and reliably interconnect new generation resources, 2032 is not possible. Not without, these completely almost fantastical doubling. Like, we modeled what happens if you try to comply by 2032, but you can double your DSM and your other grid edge programs, which was more illustrative than anything, because Witness Williamson talks about how that's not achievable. But we tried to model that. We tried to include rooftop solar and behind the meter storage as a fairly significant portion of selectable resources in our model, and we still did not get there by 2032. When we modeled with our interconnection limits, we saw carbon exceedances in that 2032 timeframe, where the model simply just couldn't build enough, couldn't dispatch out of economic order enough before it kind of got had to violate that carbon cap.
So, Mr. Thomas, there were in its work on the P1 base and P1 fall supplemental base, it's my understanding that Duke used some resource availability limitations do you take issue with any of the limitations that Duke used?
For
P1, the P1 and
Oh.
P1 fall supplemental.
Yes, I think they were illustrative and they are not achievable.
The limitations that Duke used for modeling purposes.
Like the annual interconnection limits.
Yes.
Oh,
Well-
I'm sorry. You said, I don't take issue with them as illustrative to show us how to get there, but in terms of turning that cap into reality and procured projects, I do take issue with that. I don't think that Duke proposed those limits in P1 as we can do this. It's more of, this is what we would have to do, and it is unreasonable for us to get there because our system is not capable. Now, I look at EIA reports of new interconnections, and P1 calls for, I believe, off the top, subject to check, that the solar and the solar plus storage limits are 4.2 gigawatts, and I think the standalone storage limits go from 1 to over 3 gigawatts. And that's just those resources. And I mentioned wind is pulled in, but just talking about solar and solar plus storage, I mean, we're talking about exceeding by almost 50% the interconnection rates of Texas or California, which are much larger states, which much higher peak loads and many more parties kind of operating in there. And so turning those, the P1 limits are, and they're fine for showing us what it would take to get there, but I don't believe that they're actually achievable.
Okay. And I thank you for that explanation. And I understand your testimony and your position there. My question, and I did not ask my question well. So, Witness Burgess, who testifies on behalf of the AGO, indicates that takes issue with the work that Duke did on the P1 portfolios and says, and I'm trying to find his testimony now, but as I understand it, and we'll hear from him when he gets up here, but as I understand it, he takes issue with the fact that Duke increased the availability of some resources, but not all, but not others. So the model, and I'm going off memory now, the model could not select more CTs and batteries, but it could select more solar. And do you remember Mr. Burgess's testimony to that effect?
Oh, I think I understand. You're talking specifically about going from the September filing to the supplemental planning analysis. Is that correct?
Let me find his testimony.
Because I do recall him discussing that issue.
Okay, so if you, page 12, do you have Mr. Burgess's testimony in front of you?
I don't. I was trying to minimize binders
Okay.
up in my office.
This is where the Elmo might be helpful.
Page 12.
Yes, find page 12, and page 13.
Okay.
12 has the question: for the single supplemental portfolio Duke analyzed with a 2030 interim target, do you believe this analysis conducted was robust? And then he gives his opinion there, starting with a no.
Mm-hmm.
And then, as I understood his testimony, he says, it increased the assumed availability of certain resources, solar, wind, and CCs, but battery and CT were not increased. Do you see that?
I do.
And so he seems to take issue with that. Do you take issue with that?
So I remember looking into this when the supplemental planning analysis was first filed. I think it's almost a moot point, I guess.
Help me understand that.
So the batteries, the increase of the energy generation resources like solar and wind, these allow the model to produce the carbon-free energy that's required to meet interim compliance. Certainly batteries help kind of shift that around. But I think if the question is, do we, if we would only have to connect 4 gigawatts of solar instead of 4.2 gigawatts of solar if we had a little more batteries, I do think that's kind of a moot point because I don't think that we're on the verge of interconnecting 4 gigawatts of solar, period.
Can you explain why that is?
Well, I think historically, it's been a minute since I've looked at the interconnection figures, but I think over the past several years, we've been hovering somewhere between 300 and 700 megawatts of solar interconnected on Duke's system per year. And so I'm just not confident that we are on the cusp of increasing that by tenfold in the next 2 years to procure those resources. But I guess I would point out that the table 5, and I want to make sure that I have this right, is perhaps they didn't increase standalone batteries, but according to my analysis of their Duke's P1, table 5, I mean, they did have significant levels of battery storage. I think in 2029, for example, there's 3.5 gigawatts of batteries connected, but I believe that's standalone in SPS. And I think that Mr. Burgess is talking here about specifically standalone batteries. So I think if the exercise for P1 was simply to increase those interconnection limits to the point at which we could satisfy that that interim target, it might have been helpful to increase battery and CT resources. I believe batteries were maxed out in that analysis. But again, I think that the impact to the amount of solar and wind, and those are where the carbon-free energy is actually coming from. You can only shift around so much energy before you actually just need to produce more. And so I think what's really illustrative about P1 is the increase to solar and the pulling in of wind. But the battery and CT, I think that would have been helpful. I don't necessarily disagree with his statement, but I think, our stipulation does focus more on P3 fall base as a reasonable pathway.
Okay. Oh, okay. No, we haven't. Thank you, Mr. Thomas. I'm not finished, but.
Okay. It is just a little bit after 5 o'clock, so we will adjourn for the day, and we'll pick up tomorrow at 9 o'clock with Chair Mitchell's continued questions. And I will let everyone know in the morning if we are going to continue until either 5 o'clock or 5:30 tomorrow. And we will try, as I mentioned earlier, we'll try to be as efficient as possible tomorrow. Thank you, and let's go off the record.